Fresh,
fresh.
Tuesday, kodi.
So October ಇಂದ ನಾನು ಉತ್ತರ ಹೇಳಕ್
Day, sir. Yes.
498 matter my lord.
ಮೆನ್ಷನ್
ಒಂದ್ ದಿನ 300 ಮೀಟರ್ ತಗೊಳಕ್ ಆಗಲ್ಲ. ಒಂದೇ ದಿನ ಸಾಧ್ಯ.
ನನಗೆ ಅರ್ಥ
Yes.
ಆಗುತ್ತೆ
ಹಾ.
ಬಟ್ ನಮ್ದು ಕೂಡ ಒಂಥರ ಕಷ್ಟ.
ಏನು ನಿಮ್ದು ಕೂಡ ಅಂದ್ರೆ?
ಪಾರ್ಟಿ ಗೊತ್ತು ಹೇಳೋದು.
ಪಾರ್ಟಿಗೆ ಹೇಳ್ಕೊಳ್ಳಿ ಏನ್ ಬೇಕಾದ್ರೆ. ನಿಮ್ ಪಾರ್ಟಿಗೋಸ್ಕರ ಐ ಕ್ಯಾನಾಟ್ ಟೇಕ್ 300 matters in a
6
day.
ತಿಂಗಳಿಂದ ತರ್ಸಕ್ಕಾಗಿಲ್ಲ.
What can be done, sir? Yes.
498
Then
matter.
I will start taking 100 on Mondays also.
I understand.
I will stop 300 and take 100 on every day.
ಇಲ್ಲ ನಾನು ವೆಕೇಶನ್ ಆಗು ಟ್ರೈ ಮಾಡಿದೆ.
Whatever, sir. If you are telling your party should be told, I will take only 100 every day.
ಮಂಡೇ
Then you can tell to the party whatever it is.
ಮಂಡೇ ಇಟ್ ಮೀನ್ಸ್
ತಗೊಂಡ್ರೆ ಮತ್ತೆ ಇದು. Yes.
498 matter my lord. Husband and wife reunited matter. Kindly put up 230.
ಅದು ಹೇಳಿದ್ರಲ್ಲ ಈಗ. Yes.
498 man 23 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿರೋದು. ಅದಾದ್ಮೇಲೆ ಮೂವ್ ಮಾಡ್ತಾ ಇದೀನಿ. ಬರ್ತಾ ಇಲ್ಲ.
ಮೂವ್ ಮಾಡ್ಲೇ ಇಲ್ವಾ?
ಮೂವ್ ಮಾಡಿ.
Fresh matter Tuesday.
My lord, it was IA ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆ ಅದರಲ್ಲಿ.
Tuesday.
IA ನಂಬರ್ 1 ಪೆಂಡಿಂಗ್.
ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
ನೋಟಿಸ್ ಆಗಿಲ್ಲ.
Tuesday.
My lord, third time ಮೆಮೊ ಮಾಡ್ತೀನಿ. Date was given today, my lord. And there is a trial court ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ ಮತ್ತೆ ಫೋನ್ ಕಾಲ್ಸ್ ಬರ್ತಿದೆ ಅವರಿಗೆ ಅರೆಸ್ಟ್ ಪ್ರಿಸಂಪ್ಷನ್.
ಆನ್ಸರ್ ಮಾಡಿ ಕಾಲ್ಸ್.
Maybe tomorrow or day after tomorrow, my lord.
Tuesday, yes. Answer the calls. Yes.
One review petition filed by KPTCL, your lordships had allowed the writ petition without notice to KPTCL, directing refund of GST in while your lordships were sitting in GM.
ಹೌದಾ?
This was in February.
ಕೊಡಿ.
A request for Friday.
Fridays.
I'm grateful.
Withdrawal minutes.
ಯಾವುದು?
Withdrawal minutes.
Which one?
498.
ಅದು ತಗೊಳ್ಳಿ ವಿಡ್ರಾಲ್ ಹಾಕಿ ಮಾಡಿ. Next week after the next. Week after the next, according to the year and seniority, they'll come. Yes. ಆಯ್ತು ತಗೊಳ್ಳಿ ಯಾವತ್ ಬೇಕು. ಆಯ್ತು take it. Tuesday. So what? Tuesday, yes. ಕವರ್ಡ್ ಅಂದ್ರೆ ಬೇರೆ ಕೋರ್ಟಲ್ಲಿ ಮಾಡಿಸ್ಕೋಬೇಕಾಯ್ತು. Yes, next week. Give all the memos again. Why are you all gathered here? Give all the memos.
It's one matter for the end of the list.
It's a public servant.
So what?
My lord, it's a false and frivolous PCR.
ಅದೆಲ್ಲ false and frivolous. Fresh
2023, madam.
next week. Is
It's
next
one
week or
matter.
week after the next they'll come.
It's one matter for the end of the list today.
Given.
End of the list,
Apologies,
why?
please, my lord. The respondent is a bank. It's a fresh matter. Respondent is a bank. They had issued loan to me, my lord. There is a security lien created against the property. 42406 is registered, my lord. The issue is on trial court matters.
Bank.
On that. My lord, Vijaya Bank previously, I have made all efforts to settle. DRT proceedings are initiated. They already have the deposit of my loan amount with the
230
bank.
ಯಾಕದಕ್ಕೆ?
Lord, Saturday, my lord, it is for framing of charges.
ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
My lord, I had all the security, my lord, I have given to the bank. My account is frozen, my lord. Kindly, my lord.
No issues. We'll take it on Tuesday only.
Please, my lord. The end.
Fresh matter ಅಲ್ವಾ?
Fresh matter, my lord. NBW is ordered against me, my lord.
ಅದಾದ್ರೆ ಕೊಡಿ.
Please.
Tomorrow. Covered matters. ಆಯ್ತು ಕೊಡಿ 22nd bills. Yes, call the cases.
Number 14, kindly permit to withdraw.
ಅದು ಕೊಟ್ಟಿರಿ, ನಂಬರ್ ಕೊಟ್ಟಿರಿ.
Serial number 59, my lord.
You want to withdraw?
14.
You want to withdraw?
No, day after tomorrow.
No adjournment, direct or indirect. Yes.
Reporting for settlement.
No adjournment. Mention when it is called.
Oblige.
Yes.
Serial number 14, liberty to.
Withdrawal ಎಲ್ಲ ಮೆಮೊ ಕೊಡಿ, ನಂಬರ್ ಬರ್ತ್ ಕೊಡಿ. Yes.
Lord, serial number 67 handed over to the CBI. So it is a defreezing of account. Bank has handed over the
ಏನ್ ಬೇಕೀಗ?
times. ಅದು ತಮಿಳಲ್ಲಿ ಇರೋದ್ರಿಂದ ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡಕ್ ಕಷ್ಟ.
ಅದು ರೀಚ್ ಆದಾಗ ಕೊಡ್ತೀನಿ.
May I just
10:00 ಮೆನ್ಷನ್ ಮಾಡ್ಬಿಡಿ. ನೋ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ at 10:30.
No, your lordship. Item 110, that's a construction matter. Where your lordship.
10.
Yes, your lordship. Eka matter concerning Ozone Urbana, where the secured creditors' properties had sought to be.
I know, I've heard that. I'll take it at 2:30.
Because they are escalating the matter.
I'll take it at 2:30.
File for withdrawal.
28 ಮೇಡಮ್. ಆಯ್ತು ಬರ್ಕೊಂಡಿರಿ. ಎಸ್. ಲಿಸ್ಟ್ ಮುಗಿಸ್ಕೊಂಡು. Council submission. Same Tuesday. ಗೊತ್ತಲ್ಲ ಕವೆ? Tuesday, same Tuesday. Next.
For the
That's
petitioners,
number 2, my lord.
I am for the petition.
Overruled, posted on Tuesday, yes.
3. List 2, ma'am. List 2,
List two, madam, not this.
For the petitioners, my
Same
lord.
Tuesday.
Interim order may be extended, my lord.
Oh, Tuesday ಬೇಡ ಹಾಗಾದ್ರೆ. 22 ದಾ? Interim orders ಇದೆಯಾ ನೋಡಿ.
Interim order.
ಇದ್ರೆ overruled and post the matter on Tuesday ಅಂತ ಮಾಡಿ. First ಒಂದ್ ಸರಿನೂ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಮಾತ್ರ Tuesday, otherwise according to the dates. Overruled, interim order subsisting shall continue till the next date of hearing. Yes, next. First time ಇದ್ರೆ ಮಾತ್ರ ಹಾಕ್ಸೋಣ. Same Tuesday.
This case appear for petitioner. Is a judgment. The number is wrongly mentioned in the judgment, my lords.
That is not the objections.
The first objection is that criminal miscellaneous number 78 of 15.
How much time you need to correct the, to comply with the objections?
No, my lords, the order itself is wrong, my lords. There is a wrong mention in by the trial court itself. It is at in page number 40, my lords.
ಇದನ್ನು ಬೆಳಗ್ಗೆ ಎದ್ದು ನೋಡ್ತಾ ಕೂತ್ಕೋಬೇಕಾ? Yes.
In page number 38, criminal miscellaneous number 78/15. But subsequently, my lords, the order says criminal miscellaneous number 78/16.
Whether it is 16 or 15, sir.
It is 15, my lords.
What have you written?
I have written 15 only, my lords, but office says there
Same
is.
Tuesday, yes.
Yes.
May I, with my lord's permission, serial number 8, the display is still not working.
ಮತ್ತೆ
Serial number 8. There's a display is not working. I'm not able to understand which serial number is going on. Mine is 8.
Display is working, second list is on, so please be patient. Yes.
Mine is second list, your lordship, serial number 8.
I have not yet reached 8, madam. Yes.
Yes, your lordship.
Serial number 6 ಇದು. Same Tuesday. Two weeks to comply with the office objections. Next. Yes, what is 8?
Your lordship, serial number 8 have complied with all the objections in February.
Learned
matter
counsel
has
to the
been-
petitioner submits office objections have been complied with office to verify. And in the event they stand complied, list the matter on Tuesday. When do you want?
Your lordship, the 26th.
26th.
The connected
List the
matters
matter
are,
on- I know, 26th. Yesterday it was at serial number 53. Yes.
yes, your lordship, yes, your
Yes.
lordship. Your lordship,
Yes.
there is one more. Okay, your lordship. Highly
Yes.
obliged.
Yes.
Appear for the petitioner, madam. In the FIR copy, madam, the hospital name is mentioned, madam. That's why we made the party as the respondent number 5, madam.
Before court submission. No, you have to comply with this. No document is produced. R3, 4 and 5, nothing is there.
In the FIR, madam, in page number 14, in the FIR, they have mentioned the hospital name. And they have been admitted to this said hospital.
ಇದೇ ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಹೌದು ಸ್ವಾಮಿ, ಅದೇ ಕೊಟ್ಟಿದ್ದೀವಿ.
Tuesday. Yes. Next.
For the petitioner, Millage. Office has directed me to file the entire order sheet of the trial court. Order challenge is at page number 50, Millage. That is the only challenge before me.
If you rely on one page, then I will not permit. Yes. Next, Tuesday.
Great.
Any other page, if you rely, I will not allow you to rely. Yes.
No, Millage. That is the only order which.
We'll see. Yes, next.
Great.
The submission is the rank of the parties that we change.
Tuesday.
Lord, the
Same.
relevant portion, petition is case, Lord.
Same.
Lords, ಇದ್ರಲ್ಲ IA ಇದೆ sir.
Maintainability ಏನು?
IA ಇದೆ sir.
ಹಾ?
IA ಇದೆ.
ಸರ್, maintainability ಮೇಲೆ ಏನ್ ಹೇಳಿ? Seal number 13 ಆ?
12 ಸಮಿ.
12 ಆಯ್ತು. Yes, next.
Second list.
12 ಲತೀಫ್ದು, ನೀವೆಲ್ಲಿದ್ದೀರಾ?
First list.
First list, yes.
First list, sir. First list ಅಲ್ಲಿ 12.
13.
12 lords.
Wait, sir, first list ಕರೆದಿಲ್ಲ ಇನ್ನು. Yes. 2 weeks to comply with the office objections.
And for petitioner, my lord. ಇದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 45 ಬ್ಲಾಂಕ್ ಇದೆ ಅಂತ ಹೇಳಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಸ್ವಾಮಿ. ಆದ್ರೆ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಎಲ್ಲ ಡೇಟ್ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆ ಸರ್.
Tuesday. Next.
Because the petitioner is case. Online certificate copy it's not producing. A state of hearing though.
Tuesday. Yes. Same.
11th portion of the order sheet.
Same. Same.
19.
Only objection formality ಗೆ respondent number 1.
Formality.
Respondent number 1.
A week's time is granted to comply with the office objections. You can't make a co-accused a respondent, sir. Yes. Next.
For petitioner. Produce the order copy up to 8/5/24. Subsequent, I have filed the internet copy, my lord.
Same. Tuesday.
21.
To produce the entire charge sheet, my lords. The entire charge sheet is of 16 volumes. There's more than 3,000 pages. The role of these accused are very limited, my lord.
Tuesday.
22.
I am the petitioner. I am for the petitioner, my lord.
Who has given this submission?
Uh,
The legible copy of FIR will be orally
ಮಾಡ್ತಿದ್ದೀನಿ.
furnished before the
Submit
court.
ಮಾಡ್ತಿದ್ದೀನಿ ಸ್ವಾಮಿ.
What is it? Orally furnished before the court?
Online copy ಸ್ವಾಮಿ, ಅದು certified ಮತ್ತೆ
ಆಯ್ತು, ಇದು ಯಾರು ಬರ್ದಿರೋದು? Orally furnished before the court ಅಂತ. Yes. Tuesday. File it in the registry.
What shall we?
Yes.
My lord, in this matter, we are seeking only for quashing of 307 of IPC, my lord. There are other offences in the charge sheet.
Tuesday.
Replacement.
24.
My lords, kindly have it on 18th, my lord. Similar matters 18th list ಆಗಿದೆ ಇದು.
ಯಾವ್ದಿದು?
WP.
Office objection ಹೇಳಿ madam.
Maintainability ಮೇಲೆ ಇದೆ, my lords.
Yes, Tuesday. ಇದು ಅಷ್ಟೇ. 25 same. 26 same.
27.
The respondent, your lordship, withdrawal memo has been given.
Withdrawal memo.
Withdrawal
ಕೊಟ್ಟಿದ್ದಾರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ 10/10/23 ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋದು.
ಆಯ್ತು. ಅದಕ್ಕೆ
10/10/23 second.
Serial number 27, my lord.
Hmm.
Serial number 20, Tuesday, my lord. It may kindly be taken regarding
ಏನ್ maintainability?
regarding, my lord, earlier, my lord, petition was filed for seeking for quashing of FIR.
Charge sheet ಹಾಕಿದಾರಾ ಅಮ್ಮ?
That was allowed. Thereafterwards, I was not made as a party in writ petition. I preferred writ appeal.
Writ
then my-
appeal ಆ?
Please, my lord.
WP ಏನಿದೆ? 482 ಅಲ್ವಾ?
No, my lord.
482 ಯಾವ writ appeal ಹಾಕಿದ್ರಿ?
No, my lord. Earlier, that was styled as writ petition under Article 226 read with 482 of CR.
Correct. The writ appeal is not, writ appeal ಬರೋದೇ ಇಲ್ವಲ್ಲ ಅದಕ್ಕೆ?
No, my lord. I was a de facto complainant in that
Maybe.
case. I was not made as a party.
Hmm.
Therefore, I preferred writ appeal. Then writ appeal came to be dismissed with a direction to prefer writ petition before learned single judge.
Correct. Yes.
Please.
Tuesday, maintainability overruled, list on Tuesday.
Operation.
Therefore, petitioner.
The petitioner is the managing director of the company which is before the NCLT. The issue is whether proceedings against the managing director under section 138 of the Negotiable Instruments Act could continue despite the clamping of moratorium and dependency of the proceedings before the NCLT. The learned counsel for the petitioner places reliance upon two judgments illide memoli. Prima facie, I am in respectful agreement with what the courts have held. Therefore, there shall be an interim order of stay of further proceedings before the concerned court till the next date of hearing. Emergent notice to the petitioner shall serve on the counsel who represents the complainant before the concerned court and file an acknowledgement in the next 3 days. List the matter on 20th.
Matters are pending.
20th. Yes.
We clubbed my lord.
Move ಮಾಡಿ. Yes.
Appear for petitions.
Why it is still hanging? Remove the name ಅಂತ ಕೇಳ್ತಾ ಇರೋದು. Acute ಆಗಿದೆಯಾ?
Milords, FIR ಅಲ್ಲಿ ಹೆಸರಿದೆ
ಹ್ಮ್.
ಇವರಿಬ್ರದ್ದು.
Adadmele, they have not been made a party the charge sheet.
ಆಯ್ತು.
Now.
Dropped.
Now they have dropped.
Hmm.
Now the problem, please, my lords, what has happened is still reflecting in the FIR. And now whenever she applies for a job, may I invite your lordship's attention to annexure G, please, my lords.
But
Yeah.
the entire thing doesn't get closed. Still 319 is available to bring you in.
True, please, my lords. But in the charge sheet itself, what has happened to, when the complaint was given, please, my lords, this refers to QNet.
The matter, it's all right. I'm not on that. But FIR ಲ್ಯಾಕ್ ನೇಮ್ ಇನ್ನು FIR ಡ್ರಾಪ್ ಮಾಡಿದೀರಾ? ಇಲ್ಲಿ ಡ್ರಾಪ್ ಮಾಡಿಲ್ವಾ?
It's been dropped, please, my lords.
Heard the learned counsel for the petitioner. The grievance of the petitioner is petitioners. The grievance of the petitioners is that their names are still being reflected as the accused in the FIR, notwithstanding the fact that their names have been dropped from the array of accused when the police filed their charge sheet against the other accused. Therefore, the learned counsel submits that every time when a check is made with regard to the antecedents of the petitioners, these criminal cases are projected as a crime, projected to be a crime pending against them. Therefore, the learned HCGP shall secure instructions as to why the names of the petitioners still hang on as accused in the FIR on the website and report the same to the court on the next date of hearing. List the matter on Wednesday. Wednesday, na? Thursday, madam. Yeah, Thursday.
Please.
Yes. Next.
Serial number 3, my lord. I'm for the
Yes,
petitioner.
madam.
Main case is, my lord, 2597 of 23.
ಯಾವ್ದು madam ಅದು?
ಅದರಲ್ಲಿ 3 ಇದೆ. 2597 is the main case.
Filed by
Well,
Praveen
my-
Kumar.
Please,
Case is registered. Case is registered on my complaint. It was 307 in the FIR, my lord, and
Main
as a
case,
counter blast.
main case ತಗೊಳ್ಳೋಣ first.
Yes,
ಹಾ,
as
ಕೊಡಿ
a
ಅದು.
counter blast, she has
ಇದೆ
filed
ತಗೊಳ್ಳೋಣ.
498.
ಕೊಡಿ madam.
The respondent number 2 is the wife. Her husband, my lord.
My lord.
Petition number 3 is the.
ಅಲ್ಲ, ಈಗ you are appearing for the husband?
Yes, my lord. Charge sheet is at page number 76, my lord. The FIR is at page number 66.
No, I am holding the petition filed by Praveen Kumar.
Yes.
Please refer to the pages in that petition. You said that's the main petition.
Praveen Kumar.
Advocate Praveen.
2.1.
You said that is the main petition.
That is a criminal petition 25 of 97.
2597.
Yes, ma'am.
Pages ಅದರಲ್ಲಿ ರೆಫರ್ ಮಾಡಿ.
ಅದು ನನಗೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ, my lord, still.
Sir.
Art is all this. ಕಾಪಿ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ? ಇಲ್ಲ, ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ, ಸರ್ವ್ ಆಗಿದೆ.
ಎಲ್ಲಿ ಸರ್ವ್ ಆಗಿದೆ? ನಾನು ಲಿಸ್ಟ್ ಮಾಡಿಸಿದ್ದು.
ಆಯ್ತು, ಸರಿ. If that is the main case, then give a copy.
This 498 yes, she has filed as a counter blast. ನಾನ್ ಫೈಲ್ ಮಾಡಿದ ನಂತರ ಹೋಗಿ ಫೈಲ್ ಮಾಡಿದಾಳೆ.
ನೀವು ಏನ್ ಫೈಲ್ ಮಾಡಿದಿರಿ?
I have filed 307. They came
307 against the wife and family members.
Subsequently, 307 has been dropped.
brother, yes. Father, brothers ಬಂದು ನನ್ನ ಮನೆಗೆ ಬಂದು 341 is in my case. They came to my house and assaulted me. And subsequently she went and they made her go and file 498. ಯಾಕೆಂದ್ರೆ ಅವಳು ಕೊಟ್ರೆ effective ಅಂತ ಹೇಳಿ. She went to Mahila police station. I went to jurisdictional police station. I filed complaint. I was in hospital. There police came and registered my complaint, my lord.
The charge sheet material is here.
Yes, my lord. My charge sheet, yes, it is there.
Karnataka HCGP is directed to.
76 page number. It is my charge sheet.
What have you challenged in this case, madam? ನಿಮ್ ಕೇಸ್ಗೆ
I
ಬನ್ನಿ.
challenge this 498.
1 minute. 129197 of 23 is filed by you.
12197 is DV Act. Subsequently, she filed because she filed 498A. She filed DV Act. First is 498A, my lord.
So what is the order passed by the court in criminal miscellaneous 33 of 2021?
33 is DV Act, my lord. That is, they have.
Maintenance is ordered at 10,000 each from the
Yes, sir.
respondent.
Yes.
What is
That
wrong?
I have been.
You have been paying?
Yes, yes.
Then why have you challenged it?
Because once it is ordered, I have to pay. I have to comply. Then I can.
Then continue to comply.
That I have been, my lord, I have been doing it, but what about this, my lord, 498
That
and?
we will see.
Yes.
Idರಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. The
There shall be
learned
a stay.
counsel for the petitioner, a WP, a criminal petition 12197. The learned counsel for the petitioner submits that the order directing payment of maintenance at rupees 10,000 has been complied with and would be complied with during the pendency of the petition. The submission is placed on record. ಈಗ 498 ಯಾವುದು?
12264.
3.2 madam. Serial number 3.2.
Ah. Yes. Charge sheet ಆಗಿದೆಯಾ?
Yes. I filed a complaint and it is 2597, my lord.
ಎರಡರಲ್ಲೂ ಚಾರ್ಜ್ ಶೀಟ್
ಆಗಿದೆ,
ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ಎರಡು ನಡೀಲಿ ಬಿಡಿ.
ಹೇಗೆ, my lord, this is a false case. ನನ್ನ ಮೇಲೆ ಬಂದು ಅಟ್ಯಾಕ್ ಮಾಡಿ 341 is in my case. They came to my house.
1 minute. Government, secure entire charge sheet material in all these cases and produce it before the court, and you serve a copy of the petition forthwith. The petitioner in writ petition, criminal petition 2597 of 2023 shall forthwith serve complete set of papers upon the counsel representing the second respondent wife, husband. A second respondent husband. List these matters on Wednesday.
498 may be stayed, my lord.
498 ಇಲ್ಲಿ ಏನಿದೆ?
12264. Maybe stayed.
Who are the petitioners?
The husband alone.
No, I will not stay. Yes. Unless I hear, I will not stay.
So far as my petition is concerned, my lord.
You first serve, sir.
Please.
On Wednesday all.
My lord, I'm supposed to furnish a copy of the latest order sheet before its honorable bench. Yesterday I received the copy, it's ready with me. If my lord permits, I can submit it over.
All right, come to page 37. You are accused number?
My lord, I am accused number 125, my lord.
All of you are here.
Yes, my lord.
So all of you are there in page 37 also. Please see. ಮೈ ಮೇಲೆ ಹೊಡೆದು ನೋವುಂಟು ಮಾಡಿ. Yes, anything else, sir?
My lord, page 37 of,
Which, you are in which serial number? You are Abhilash?
yes, my lord.
Page 37 of the petition, sir.
Yes, Mr.
That's a summary of the charge sheets.
Summary of the charge sheet.
Huh? 37 ಅಂತ ಇದೆ. I have it at 37. Wherever the summary is, please read.
Yes, my lord.
What is the offense alleged? 323, 324.
24, 506.
No, 504, 506, don't worry. Come to,
My lord, this is the description of the alleged incident, but my lord, to come to this conclusion, my lord, at least I must be investigated, no, I must be given a notice. I must be
notice for what, sir?
I must be, FIR is.
Accused need not be investigated into, sir.
At least,
Investigation will take place. You will have all the opportunity later.
yes, my lord, because all this, the complainant and accused, they are related, blood relatives.
Maybe, sir.
There is a property dispute,
Maybe.
pending property dispute.
That is not a license to assault.
And my lord, before that, my counter complaint also need to be,
Which is your counter complaint?
no, my counter complaint, my lord, may kindly, peruse page number 14, that is document number 2, which is an RTA reply. Which state that there is
69, CC there, CC 69 of 2020, what is that?
CC. My lord, page document number 2, my lord. CC 669 is the crime, my lord, which is, trial is going on in KGF.
Government, what happened to this 108 of 23 crime? The learned HCGP is directed to secure instructions as to what has become of the complaint registered by the present petitioner against the respondents in crime number 108 of 2023. by the next date of hearing.
My lord, my only submission, my lord.
I am not staying it, sir.
My lord, my only submission is that both sides need to be equally taken.
Correct.
I am not, I am written in charge sheet, I am mentioned as a businessman, man, my lord. I am,
We'll see, we'll
I am
see.
a farmer, my lord.
We'll
The
see.
basic principle is that I.
The learned counsel for the learned HCGP shall secure the charge sheet material and place it before the court case. Whether you are a businessman or a farmer, the allegation is assault. We'll see what you are described as later.
My lord, I oblige, my lord, but again, my lord, the facts must be, because I must be given a chance, at least what happened, somebody must.
Accused need not be given, sir. What is this you are saying?
Counter complaint must be considered, my lord.
That we'll see. Counter complaint, that is why I have ordered, we'll see. Yes.
So it need to be fair, otherwise it should be considered as an irregular
We'll see.
proceedings, my lord.
We'll see. Yes. Next, list on 27th.
My lord, kindly stay the
No,
trial.
sir. Not in the case of assault. I'm granting bail in this.
Successive petitions.
Huh? Successive ಆಗಿದೆ ಮೆಡಿಕಲ್ ರಿಪೋರ್ಟ್ ಇದೆ ನಿಮ್ದೇ ಮೆಡಿಕಲ್ ರಿಪೋರ್ಟ್ ಆನ್ ದಟ್ ಗ್ರೌಂಡ್ ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಈಗ ಒಳಗೆ
2 years, 10 months,
ಆಲ್ಮೋಸ್ಟ್ 3 years.
please.
Yes. I will upload the operative portion. We will get the order by Monday.
Please.
Monday or Tuesday, yes. ಇದು operative portion ಮಾತ್ರ bail granted ಕಂಡಂಗೆ ತೋರಿಸಿ ಮಧ್ಯಾಹ್ನ. Hello. Yes, sir.
But in this case,
Great Wall of China.
please, my lord. My lord, I am a Chinese citizen.
That's why I said Great Wall of China. Tell me. You're a Chinese citizen, I know. Where do you want to go?
China, my lord.
Why?
My lord, my father is not well, he is in a critical condition.
Where?
He is
Where?
80 years of age.
Where, sir?
In China, my lord.
Oh, he's taking Chinese medicine there.
My lord, even he can't come to India. And now I can't go to India since the condition number 2 of the bill order saying that.
You should have sought for
petitioner-
relaxation of condition.
No, already I sought.
What
Already
happened
I
to that?
sought in the coordinate bench has been rejected, saying that in the 3 ground.
Huh.
I'll read it the portion, my
It's
lord.
all right. Justice Vishwesh Shetty ಅವರು.
Please, my
I
lord.
have seen. ಆಮೇಲೆ ಎಲ್ಲೋದ್ರಿ ಅದ್ರ ಮೇಲೆ?
Saying that you should have filed permission seeking the 15 days to visit the China, not the relaxation of the condition. That was the order, my lord. And now, my lord, it is 2009 I got married to my husband in India. And since 2017, I am residing in India with my daughter, 11-year daughter, and my husband, my lord.
That is why I asked the DSGI to
Please,
be
my lord.
served. Yes, sir. What is the
Please, my lord.
information?
Your lordship may kindly see, my lord, in the year 2017, the petitioner comes to India on the strength of a tourist visa.
You are a petitioner.
Please, my lord.
Tourist visa.
Please, my lord. My lord.
From China.
From China, my lord. Then, my lord, they say that, my lord, a Chinese national in Kerala, other Chinese national in Kerala was not keeping well. And they had to undergo the medical treatment as such.
Kerala.
In Kerala. As said, the tourist visa was converted into a medical visa. Your lordship will get it at.
No, another Chinese national is unwell andre. Why medical visa is given to this person?
That is what.
Medical attendant visa is
That
okay.
should have
How
been
did
given.
medical visa emerge? FRRO also functions like this. Yes.
What is there?
I know. ನಿಮ್ದಲ್ಲಿ ಹೇಳಿದೆ FRRO also, they should apply their mind.
But
So medical visa is granted.
medical visa is granted. Thereafter, my lord, on investigation, the police in Kerala has found that the said medical certificate was a forged one.
Certificate itself is forged.
Forged document. Therefore, my lord, 2 crimes have been registered
In Kerala.
in Kerala, Kadakal police station, my lord, and Info Park police station, my lord. Your lordship will get it at page.
Those are pending investigation.
Those are pending investigation, my lord, and there, lord, the petitioner has obtained bail. There is a condition that they shall not leave the country without the permission.
In
Therefore-
Kerala.
In Kerala.
ಆಯ್ತು. ಇಲ್ಲೇನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ?
Lord, illi the problem is that.
What is the crime registered here, sir?
Crime number 8 of 2021, my lord. Under
For what?
Under section 420 and 66D of Information Technology Act.
420 why?
My lord, my husband was running a company, and the allegation of the complainant saying that he has changed, deviated his business. The complainant is a payment gateway, my lord. He says he has deviated the business and started an investment business. That is by name Power Bank app has been opened in the Google Play.
Razor
Google
Pay is
Play.
the
Please,
complainant.
my lord. Please, my lord. So I am not owner of the Power Bank, my lord. It is an allegation, but the other accused has been using that one. No amount has been transferred to my account. Either I have opened any investment company, and I am the petitioner. I have no connection. I have no account. I am not into the business, my lord. I am accused number 19. Only my husband was doing that business, and they say I was helping to the accused, my lord. My
Since
husband.
how long are you staying here?
2017, my lord.
8 years in the.
Please, my lord.
Who was taking care of your father all these 8 years?
My lord, that is what I am. I
Who was
come to
taking-
that, my lord.
Who was taking care? Sir?
My lord, only my father and mother are there. Both are the
Who
senior
was
citizens.
taking care of it?
They themselves are taking care of them, my lord.
Yes.
My lord, what happened when I came into the 2017, there is a false case has been registered against me. As the counsel said, bail has been obtained, my lord. And that is for the forged document submitted for obtaining the visa. My lord, the document which was submitted from my own hospital, my lord. Since there is a family dispute.
Own hospital?
My lord, my husband
Owns a hospital.
please, my lord, in Kerala, my husband family owning one hospital. They have issued a certificate saying that she is not well and she has to undergo the surgery, my lord. Due to the family dispute of the property, they have filed a case saying that it is a false document. My lord, also, they have obtained, I have obtained a bail, and also an order has been issued by the court saying that she can visit China for 3 months, my lord.
Where?
I'll give.
Court in Kerala?
Please, my lord.
Pudi. When was this passed?
My lord, on 4 June, 4
24.
June 2024, my lord. Operative order, my lord. The petitioner is permitted to leave the country for the purpose of going to China only for a period of 3 months from the date of her leaving from India. The petitioner shall file an affidavit that she would not stay more than period of 3 months
Yes.
abroad, and she would be available before the court on the expiry of the period of
cases.
3 months, my lord.
I was not aware of this, my lord.
Both the cases.
Lord, may make one.
Like,
This similar.
Court at Kerala has given permission. Husband's business is here still.
Please, my lord.
My daughter also
Husband's
living here.
business is here,
Please.
Kerala.
Husband business is in Bangalore and Kerala.
Um,
Lord, in this, my lord, as my learned friend told my lord, that a similar petition was filed before the coordinate bench. Lord, the coordinate bench rejected, and then SLP was preferred before the
Against
apex
that,
court.
Justice Vishweshat's order.
Please, my lord.
Pudi.
It was withdrawn, my lord. SLP. I have filed in the additional document, my lord.
Lord, that what my learned friend has filed in page 31 is Justice Krishna Dixit's order, my lord.
Yaudu?
In the additional documents, my learned friend,
Permitting travel.
That is for relaxation of condition, my lord. That coordinate bench has
Surrender
rejected.
passport.
no, my lord, Justice Krishna.
Yeah, that is for the visa extension, my lord. Sought the permission to extend the visa, my lord. Since the case was pending, the visa was not extended, my lord. And Justice
So the-
Krishna Dixit has.
1 minute.
Please, my
The
lord.
learned sessions judge has rejected your application, seeking
Application-
relaxation of bail.
Please, my lord.
That is affirmed by this.
Please, my lord.
That is, you have filed an SLP and withdrawn.
It is affirmed by the Justice.
Coordinate
Vishwanath
bench.
Shetty. Please, my lord.
You filed an SLP. You
SLP
withdrew
was
it.
withdrawn, my lord.
You withdrew it.
Please, my lord.
Withdrawal is dismissal by consent.
My lord, again, I have filed application since in the ground where coordinate bench was rejected, they said you should have sought only permission, not the relaxation of condition. It is written in my lord.
No
Kindly
permission is
see-
sought. That is said.
Please, my lord.
Look into this Kerala judgment.
Please, my lord. Now, my lord, what has to be looked into is whether a foreign national committing a crime in India and seeking a bail, my lord, and without completion of the trial, before completion of the trial, if she seeks a travel permission, my lord, she may not come back. That has to be seen, my lord, insofar as that
That's
is.
the whole problem.
My lord, even the page number 7 and 8
Will be
of
not
the
reachable even to Google.
additional, my lord. In the additional document, I have submitted my daughter's ID card. She's studying at Bangalore, my lord. And no one in China for me except my father, my lord.
5 cases registered.
Yes, against the petitioner.
My lord, it is in related to the same matter, 8 of 21, my lord. That is
ಅದರಲ್ಲೂ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ ಕ್ರೈಮ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆಯಾ?
crime state, my lord.
Just
All the cases has been consolidated, my
sir.
lord.
look into this.
Please, madam.
And
Please,
tell me, tomorrow we'll pass orders.
please.
My lord, all the cases
Not,
is connected to the crime number 8 of 21, which has been consolidated by the Honorable Supreme Court, my lord. It is in the same, before the learned principal civil and session judge, my lord.
we'll
It is
see.
not, it connected to the same, my lord.
Look into that and
Please.
tell me tomorrow.
Please.
Yes, tomorrow in the same stage.
Please.
ಇದು 12th ಬರ್ಲಿ. ಇವತ್ತೇ ಅಲ್ವಾ? ಸಾರಿ, ಎಲ್ಲ 12th ಇವತ್ತೇ. Other cases, where are the other cases listed?
83.
Huh?
Serial number 82, 83.
I'll take along with that,
Man.
all the cases.
ಆಯ್ತು ಬನ್ನಿ.
For the petitioner, my lordship. The offenses under section 504, 506, 447, 4.
Who is in possession of the property?
We are in position, my lordship.
How?
We have formed the layout, my lordship, already.
The learned
have got
counsel for the petitioner submits
conversion
that
order.
the petitioners are in possession of the property as they are the ones who have formed the layout and the complainants are not. If the petitioners are in possession of the property and the complainants are not, allegation for criminal trespass into their own property cannot be laid, albeit prima facie. Therefore, till the appearance of the second respondent complainant, there shall be an interim order stay of further proceedings, quay the petitioners. Either investigation or is charge sheet ಆಗಿದೆಯಾ? Investigation, yes. Next.
For the second respondent complaint.
Lordship, petitioner number 1 and 2 are friends. De facto complainant is the wife of petitioner number 2. Petitioner number 2 and the de facto complainant were married in the year 2018. Subsequent to the birth of the child, they moved to Agra. And when the marriage, when they were residing in Bangalore, petitioner, the de facto complainant had some financial constraints for which she had borrowed 2 lakhs from petitioner number 1, who's the friend of petitioner number 2. And in guarantee of the money she had borrowed, she had given a check as a guarantee. And after she moved to Agra, along with petition number 2, there was some matrimonial disputes. And she left the matrimonial house in August 2022. And petition number 1 filed an application under section 9 of HM Hindu Marriage Act asking for restitution
Now,
of conjugal
what
rights.
is, come to page 34. And the issue is 1,90,000.
Yes, Your
My
Lord.
lords, your lordship may kindly see this. After the relationship got strained, my lords, she was deserted and she was deserted and she was at her parents' house. She gives a complaint saying that all my documents remain at my marital house, that is at Bangalore, and it includes passports, checkbooks, and all these properties are there, and they are not permitting to take them back. On that, my lord, the police gives an NCR.
ಕೊಟ್ಟಿಲ್ವಾ?
Kutila, Allah, your lordship may kindly see. Ali on the checkbook now, what the offense is this? Using the checkbook, petition number 2 is the husband of the complainant. Petition number 1 is the friend. He goes, opens the law, takes my checkbook, forges my signature.
Who is the complainant?
Complainant is the wife. That is
Of whom?
wife of second petitioner,
Your Lordship, if I may.
Agarwal.
Nikhil Agarwal.
Yes. My lords, when
Who
my
is the first petitioner?
first petitioner is the first friend of my husband, is friend of my husband.
Your Lordship, the
Well,
matter.
your lordship may kindly see this. When my checkbook is also.
ಆಯ್ತು, ಈಗ check misuse ಆಗಿದೆಯಾ?
Check, they have forged the signature of the complainant and they presented it. I got an intimation from the bank. Immediately I rushed and also lodged a complaint that my
So,
signature is forged. That is.
ಅದಕ್ಕೆ ಡ್ರಾ ಮಾಡಲು ಯತ್ನಿಸಿರುವುದು ಕಂಡು ಬರುತ್ತೆ.
Now, my lords, it was debited to his account. Thereafter, it was credited to his account. Thereafter, it is reverted back to the complainant.
ಈಗ
But,
ನಿಮ್ಗೇನು ಅಲ್ಲಿರೋ ಪಾಸ್ಪೋರ್ಟ್ ಎಲ್ಲ ಬೇಕಾ?
ಅಲ್ಲೆಲ್ಲ
Your
passport
Lordship, she
ಇವೆಲ್ಲ
has
ಬೇಕು.
taken, along with the police, she has come to the house, she has taken everything. Immediately after the notice for restitution of conjugal rights was issued, she filed an NCR with the police alleging all her
Now there-
belongings are.
there is a
Excuse me,
forest-
sir.
One minute.
Yes, may I
There is
speak?
ಇಬ್ರು ಹೇಳಿದ್ರೆ ಹೆಂಗಾಗುತ್ತೆ? What is this?
So she complained, she lodged a complaint. A NCR was registered, and in the list given in the answer at page 130, she lists everything, including the birth certificate of the child. But there is no mention of any passbook or checkbook missing. Anything about the bank is not
Where
mentioned.
is that?
Page 130, Your Lordship. A detailed list is given about her jewelry, the vehicle's RC book, her documents, everything is mentioned, but no mention with regard to the passbook or checkbook. And subsequent to this, there is an endorsement given by her only, where she has written that my husband, page 131, Your Lordship, as discussed with the police, my husband was asked to come after 1 month and give wives all belongings and other items, and this has happened.
Where-
Husband has
how-
come down.
How do you say it has happened?
That she states in her matrimonial cases, Your Lordship. She has taken all her belongings.
Hmm.
And subsequent to that, after this complaint was given, petitioner number 1, who had given her money, lodged 138 proceedings because the check was dishonored. And in challenging that, she filed a 482 petition in the High Court of Allahabad at page 303, if I may take Your Lordship.
What has happened
She seeks for a mediation.
there?
Yes, Your Lordship.
Oh.
If she was with the clean hands, she would not have asked for
All
mediation.
right. Yes, sir.
Lords, Your Lordship may kindly see the complaint government, Lords. There is a theft from the place of the second petitioner.
ಎಲ್ಲಿತ್ತದು?
Lords, ಈ ಬ್ಯಾಂಗ್ಳೂರ್ ಮನೆಯಲ್ಲಿತ್ತು.
ಎಲ್ಲಿದೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ?
List. You are referring to the list which was the
Yes,
complaint.
it's NCR.
Your list, sir. List of your belongings.
She files a 125 application also before the magistrate. There is a similar list given. No mention of these bank checkbook or passbook.
Yes.
It is all
Anything-
court
I'll just
records.
verify, my lords. My instructions are.
You will verify.
I'll
Take
just,
2 weeks, no problem.
I'll just a week's accommodation is fine, or even tomorrow is fine. I'll just verify and whether.
Heard the learned counsel, Srimati Abhinaya K, appearing for the petitioner and Sharath Gowda representing the complainant. A marital discord between the second petitioner and the complainant draws the first petitioner and the husband into the web of crime for offences punishable under so and so 379, 420. The learned counsel for the
Lordship,
petitioner.
if I may interrupt, if there is an allegation of theft, cheating would not arise. They
One
both
minute.
can't go hand in.
Why are you interrupting? The learned counsel for the petitioner submits that the wife herself, after leaving the matrimonial house, had given a list of items that were in the possession of the second petitioner, the husband, to demonstrate that the checkbook or any check leaf as alleged is not the one that was in the possession of the husband. The learned counsel would submit that this was not even the ground in any of the proceedings that were registered against the petitioner. The learned counsel would further contend that the wife had filed a proceeding under section 138 of the Negotiable Instruments Act before the Court of Competent Jurisdiction at Allahabad.
Petitioner number 2, petition number 1
Petition number 1 had filed against
against the wife.
sorry, the first petitioner had filed a petition, registered a case for offense punishable under 138 of the NI Act against the complainant
Yes.
for dishonoring of a check that had been allegedly given to the first petitioner by the complainant, where the matter is sought to be mediated by the second respondent complainant. With all these facts, it is for the complainant, counsel for the complainant to steer clear the problem with regard to the check leaf or check not being present anywhere, not being said to be present in any of the proceedings in the possession of the second petitioner husband. Therefore, till such time, there shall be an interim order of stay of all further proceedings, qua the petitioner still the next.
One submission,
Yes,
Lords. FSL report has come, my Lords. In the FSL report, it is found out that the signatures are forged.
We'll see that next time.
That is part of the charge sheet material.
We'll see. Yes, you get the check or the
The check, Two, my lord.
And 379 and 420 cannot go hand in hand.
I understand that.
Now, then
379
what is that charge that is, charge sheet that is filed? 379 is 420 ಹೆಂಗಾಗುತ್ತೆ?
420 in the sense, my lord, there is forgery of the signature in the check.
Forgery is not 420.
464 ಆಗ್ಬೇಕು.
463 onwards. ಅದಿಲ್ವಲ್ಲ?
ಇದೆ. 465 is there.
ಇದೆಯಾ? 565 ಇದೆಯಾ?
5 is there. Forgery is there.
When do you want?
Lords, any date in the next week.
List
Beyond
on,
next week.
we'll take it on 27th.
Please.
List on 27th.
In the fresh matters list.
ಅವೆಲ್ಲ admission, ಎಲ್ಲ reach ಆಗುತ್ತೆ.
Much of that.
And for the petition, for the offences punishable under section 498A, my lord, and 353. 140, 323, 354, my lord. But in this case, my lord, the accused number 1, accused number 4 to 10, they are the relations of the husband, my lord.
They have not done anything. ಕೊಡಿ. This government ನೋಡಿದ್ದೀರಾ?
ನೋಡಿ.
Come to page 18,
Please.
last 4 lines.
Please.
ಬಾಗಲು ತೆಗೆಯದೇ ಇದ್ದು ರಾತ್ರಿ 2:30 so and so ಕಾರ್ತಿಕ್, ರಾಜಶೇಖರ್, ಹರೀಶ್ ಅವರು ಏಕಾಏಕಿ ಬಂದು
Yes, my lord.
ಹೊರಟು ಹೋಗು ಅಂದಿದ್ದಕ್ಕೆ ಕೈಯಲ್ಲಿ ಚಾಕು ಹಿಡ್ಕೊಂಡು ಕಾಲಿಗೆ ಚುಚ್ಚಿದ್ದು, ರಾಜಶೇಖರ್ ಬೆನ್ನಿಗೆ ಹೊಡೆದಿದ್ದು, ಕೈ ಕಾಲಿಗೆ ಹೊಡೆದು ಸಾರ್ವಜನಿಕವಾಗಿ ಹಲ್ಲೆ ಮಾಡಿ ಮೈಕೈ ಹೊಡೆದು ಎಳೆದಾಡಿ ಮಾನಕ್ಕೆ ಚುತ್ತಿದ್ದು.
Accused
ಏನು
number,
ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ, accused number 10, 11.
That time,
Yes, my lord. But other
in so far as 4, 5, 6 ಅಲ್ಲ, ಈ ಫಸ್ಟ್ ಯಾರೋ ಇದಾರಲ್ಲ
Please,
ಅವ್ರದ್ದೇನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
please, my lord.
See,
In
accused
respect to
number
accused-
4, 5, 6, 7, 8 and 9.
Please.
No problem.
No, yes, my lord.
These 3 shall face trial.
Please, my lord.
Yes. The petitioner is, ನೋಡಿದಿರಾ ನೀವು?
Yes, ma'am.
The petitioners accused number 4 to 12 are before this court, calling in question the registration of a crime in crime number 32 of 2024 for the following offenses. A complaint is registered by the second respondent alleging torture by these petitioners along with accused number 1 to 4, 1 to 3 who are not before the court. While the offenses against the husband, mother-in-law and father-in-law are horrendous. Insofar as the accused number 4 to 9 are concerned, all that the complaint narrates is as follows. ಇವರೊಂದಿಗೆ ಅಂತ ಇದ್ದಿದ್ದು ಹಿಂಸೆ ನೀಡುತ್ತಿದ್ದು ಅಲ್ಲಿವರೆಗೆ. It is a narration in the complaint that all these accused 4 to 9 do not stay with the couple, but they would visit the house and hurl abuses against the complainant. This, in the considered view of the court, would not meet the ingredients of section 498A of the IPC or any other offense so alleged. Insofar as accused number 10, 11 and 12, the narration in the complaint is as follows. Iddu ratriinda illivarige. 19. If the narration in the complaint is noticed, it reveals minute details of horrible torture by those accused against the complainant, which would undoubtedly require an investigation. Therefore, interim order insofar as the accused 10, 11 and 12 is rejected. There shall be an interim order of stay of further investigation in crime number 32 of 2024 only against accused number 4 to 9 till the next date of hearing.
Much obliged.
For petition in this case, my lords. I will furnishing the DNA report.
Yes, government. ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ. 230 pass over. Government, look into it and tell me. Great. Yes, next.
The alleged offense 376, 420, 470. The also charge sheet also filed. This CC number 135 but 2020.
Mic use ಮಾಡಿ sir. Mic use ಮಾಡಿ, ಕೇಸ್ ಇಲ್ವಾ?
ಅಲ್ಲ, ಗಂಟ್ಲು
ಗಂಟ್ಲು ಪ್ರಾಬ್ಲಮ್. ಐಡೆಂಟಿಕಲ್.
I read the FIR content minutes.
ಏನು ಓದೋದ್ ಬೇಡ. 376.
376.
Yes sir.
Minutes ಇದರಲ್ಲಿ 2019 ಇಂದ ನನ್ನ ಜೊತೆ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದು ಆಲ್ರೆಡಿ 2020 ಇನ್ನೊಬ್ಬರ ಜೊತೆ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂತಾರೆ ಸರ್. ಅದನ್ನ ಕಾಪಿ ಕೂಡ ಪಬ್ಲಿಷ್ ಮಾಡಿದ್ದೀನಿ.
ಇನ್ನೊಬ್ಬರ ಜೊತೆ
ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂತಾರೆ ಸರ್.
ಅಗ್ರಿಮೆಂಟ್
ಮಾಡ್ಕೊಂಡು ಅಲ್ಲೂ ಕೂಡ ಅಲ್ಲೂ ಕೂಡ ಇಲ್ಲಿಗಲ್ ಅಫೇರ್ ಆಗ.
ಏನ್ ಅಗ್ರಿಮೆಂಟ್? ವೇರ್ ಇಸ್ ದಿ ಅಗ್ರಿಮೆಂಟ್?
ಅಗ್ರಿಮೆಂಟ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್ ಲಾಸ್ಟ್ ಟೈಪಿಂಗ್ ಅಲ್ಲಿ. I read it the agreement. Memo of petitions. Kindly be, please, sir.
1 minute. ಇದಕ್ಕೆ ಸೆಟಲ್ಮೆಂಟ್ ಕೇಳಿದ್ ನೀವೇನಾ? ಸೆಟಲ್ಮೆಂಟ್ ಆಗಲ್ಲ ಅಂತ ಹೇಳಿಲ್ವಾ?
ಅದೇ ಸರ್, ಸೆಟಲ್ಮೆಂಟ್ ಆಗಲ್ಲ.
ಮೆರಿಟ್ ಬನ್ನಿ.
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
ಎಸ್ ಸರ್. ಇನ್ನೊಂದು ಎಲ್ಲಿ ಕೊಡಿ ಅದು. ವಾಟ್ ಅಗ್ರಿಮೆಂಟ್ ಇಸ್ ದಟ್?
ಕೈಂಡ್ಲಿ ಬಿಡಿಸ್ತೀನಿ. 2020 ಚಿಕ್ಕಬಳ್ಳಾಪುರ
ಕ್ರೆಡಿಟ್ ಕನ್ಸಲ್ಟೆಂಟ್ಸ್ ಏನಿದೆ?
ಸೇಮ್ ವಿಕ್ಟಿಮ್ ಇಲ್ಲ. ನನ್ನ ಜೊತೆಗೆ 2019 ಹೇಳ್ತಾರೆ ಸರ್.
ಯಾವ ಪೆಟಿಷನ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ ಕಾಪಿ?
ಅಲ್ಲ ಸ್ವಾಮಿ, 12 ಸೀರಿಯಲ್ ನಂಬರ್ ರಾಘವೇಂದ್ರ
108. ಇದ್ಯಾಕೆ ಕೊಟ್ರಿ ಮೇಡಮ್? ವಾಟ್ ಇಸ್ ದಿಸ್? ಯಾರು ಕೊಟ್ರಿ ಇದು?
ಮೆಮೋ ಕೊಟ್ಟಿದ್ದೀವಿ ಸರ್. ಲಾಸ್ಟ್ ಡೇಟ್ ಈವ್ನಿಂಗ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಏನ್ ಮೆಮೋ ಸರ್?
ಇದು ಅಗ್ರಿಮೆಂಟ್ ಕಾಪಿನ. ಅಗ್ರಿಮೆಂಟ್ ಕಾಪಿ ಅಲಾಂಗ್ ವಿತ್
ವಾಟ್ ಅಗ್ರಿಮೆಂಟ್?
ವಾಟ್ಸ್ಆಪ್ ಮೆಸೇಜ್ ಕೂಡ ಕೊಟ್ಟಿದ್ದೀವಿ ಸರ್.
ಕೊಡಿ, ಅದೇನಿದೆ ಕೊಡಿ. ಕೊಡಿ, ಇಲ್ಲಿ ನಿಮ್ಮ ಹತ್ರ ಇರೋದು.
ಸರ್ ಇದ್ರಲ್ಲಿ ಕಾಣಿಸ್ತಿದೆ ಸರ್. ಇದೆ.
ಯಾರಿದು?
ಸೇಮ್ ವಿಕ್ಟಿಮ್ ಸ್ವಾಮಿ.
ಆಯ್ತು, ಯಾರ ಜೊತೆ ಅಗ್ರಿಮೆಂಟ್ ಸರ್?
ನವೀನ್ ಕುಮಾರ್ ಸ್ವಾಮಿ.
ನೀವ್ ಯಾರು?
ನಾನು
ನರೇಶ್ ಕುಮಾರ್. ಹೆಚ್ಚು ಕಮ್ಮಿ ಅಲ್ಲಿಗೆ ಬರುತ್ತೆ.
1.5 ಲಕ್ಷ ರೂಪಾಯಿಗೆ ನಾನು ಈ ದಿವಸ 20/12/2021 ಅವರಿಂದ ಪೂರ್ತಿ ಹಣವನ್ನು ಪಡೆದುಕೊಂಡು ಇವರ ಮೇಲೆ ಯಾವುದೇ ರೀತಿಯ ಕ್ರಿಮಿನಲ್ ಪ್ರಕರಣವನ್ನು ದಾಖಲಿಸಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
ಅದು 376.
ಅದೇ 376. ಇದು ಸರ್, ಇದು ಜಮೀನ್ ವಿಚಾರಕ್ಕೋಸ್ಕರ ಈ ತರ ಮಾಲಾಫೈಡ್ ಇಂಟೆನ್ಷನ್ ಟು ಹರಾಸ್ ದಿ ಪಿಟಿಷನರ್ ಮಿಲಾರ್ಡ್.
ಮಾಲಾಫೈಡ್ ಇಂಟ್ರೆಸ್ಟ್.
ಅವರವರು ಫ್ಯಾಮಿಲೀಸ್ ಎಲ್ಲ ಔಟ್ ಆಫ್ ದಿ ಕೋರ್ಟ್ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸರ್. ಬಟ್ ವಿಕ್ಟಿಮ್ ಆಲ್ಸೋ
since 3 years.
ಕಾನ್ಸೆನ್ಷಿಯಲ್, ಅದರಲ್ಲೇನು ಡೌಟೇ ಇಲ್ಲ. ಬಟ್ ಇದನ್ನು ಸ್ವಲ್ಪ ಸಮಥಿಂಗ್ ಎಕ್ಸ್ಟ್ರಾ ಇಸ್ ಹಿಯರ್. The petitioner is before this court calling in question proceedings in CC 135 of 2024 registered for offences punishable under section 376, 420 and 417 of the IPC. The learned counsel, the perusal at the summary of the charge sheet as obtaining in column number 17 would clearly indicate that the petitioner and the complainant were in a relationship for close to 3 years and have had ಮದುವೆ ಮಾಡಿಕೊ ಅಂತಾನೆ ಇದೆ. So relationship for a period of 3 years, which was physical as well. The allegation now is that the petitioner had indulged in physical relationship with the complainant on the pretext of promise of marriage, and he is now breaching the said promise. Therefore, the crime is registered and a charge sheet is drawn against the petitioner. The learned counsel for the petitioner places on record certain agreement entered into by the very complainant with one Naveen Kumar G, against whom similar offense punishable under section 376, 417 and 420 is registered, again alleging having physical relationship on breach of promise of marriage. The complainant appears to be traveling in two boats at the same time. Therefore, there shall be an interim order of stay of further proceedings in CC so and so till the next date of hearing.
Much.
1 HCGP, 2 emergent notice.
Much.
Lord, petitioner. Section
91
90
application.
91 application is rejected. My lord, the case of the complainant is that she availed project loan from
I
the
undertake
bank.
to appear for the respondent, my lord.
When is the next date?
Lord, 13th.
Nale.
It's tomorrow, my lord. It's set down for arguments. However, if the impugned order is perused, they have admitted the agricultural loan, my lord, in the cross-examination.
Let the court not take it till Wednesday. You
Please,
file
my
your
lord, we
objections
will-
or whatever you want.
Please, ma'am.
Yes. The learned counsel so and so undertakes to enter appearance for the respondent. Agidya.
I have- I have served.
Madam. Shashank.
I
You are
was-
Shashank.
No, my lord. I appear in
Shashank
the
is the
trial court.
respondent.
Respondent
Lord,
Srimati Varalakshmi, my lord.
I was directed to serve a copy on the council appearing before the
Allah,
trial
right.
court. So I
The
have.
learned counsel so and so undertakes to enter appearance for the respondent registry to print the name of so and so as appearing for the respondent and delete the name of Shashank. The learned counsel would seek for 3 days' time to file statement of objections, list the matter on Wednesday. Till such time, the concerned court shall defer the proceedings.
My lord, 18th or 20th.
No,
my
sir.
lord,
If
except
you want the interim order, be there. Yes. Next.
14, withdrawal motion.
14, filed a memo for withdrawal of the petition with the liberty.
Yes, correct, yes.
Memo ಕೊಟ್ಟಿದ್ದೀವಿ sir. With the liberty as prayed for.
Memo ಏನ್ ಹೇಳಿದ್ದೀರಾ ಅದು? Yes.
Please, ma'am. Please.
Next. 15 also, yes.
Which is purely civil in nature, several civil proceedings are pending. My lords, it arises out of an MOU. The MOU, my lords, would contain an arbitration clause. We are in charge of managing the affairs of a school, my lords. So the MOU, my lords, would get it at page 63, my lords. Now the complainant is one of the trustees in paragraph 1, my lords. He is the complainant. And paragraph 2, these are the petitioners now, my lords. Now the dispute, my lords may notice in page 66, we have already paid the refundable security deposit. Whatever needs to be paid was being paid. And my lords, if at all there is going to be any dispute, the arbitration clause is at page 75, my lords. Page 75. Now thereafter, my lords, since there was an interference by the complainant, we approach the civil court and file a suit. My lords should get the suit at page 84, my lords. The suit is pending consideration. They would go and file an application under section 9 of the Arbitration Act and seek for interim relief, which is denied by an order. And they don't choose to file any appeal against that order. Now the arbitral proceedings are going on, my lords. At this point of time, my lords, comes the present complaint.
No, it was earlier to that.
No, my lords, I'm sorry, the complaint was earlier. Now the charge sheet has been filed. In the charge sheet, the base is the MOU. Kindly notice, my lords,
Complaint is registered even before the arbitration initiation. Yes.
My lords, not before the section 9. Kindly notice section 9. My lords should notice this on 21st November 2022. 21st November 2022, my lords.
Arbitration.
How though? Kindly notice that, my lords,
Complaint is 1711.
111. The order. my lords,
Complaint is 1711, sir. 4 days prior to that.
on the MOU.
I said before that. That's all.
On the MOU itself, it happened, my lords. And then now the charge sheet comes on the basis of this MOU, which is pending consideration before the arbitrator now. Claim is being filed before the arbitrator.
Yes, you serve on the respondent. Heard the learned senior counsel. The Sandesh Chowta appearing for the petitioners. The learned senior counsel taking this court through the documents appended to the petition with particular reference to column number 17 would submit that the entire issue arises out of breach of a memorandum of understanding for which the parties are before the arbitrator in, and OS yavdu?
My lord, so OS 1412.
And alleging interference by the complainant, the petitioners have also registered OS
1412 of 2022.
Prima facie, the issue being civil in nature appears to have been rendered a color of crime by registering the said case. Therefore, till the appearance of the complainant, there shall be an interim order of stay of further proceedings. List the matter on 26th in the fresh matters list. 1 HCGP, 2 emergent notice returnable by 26th. Yes, next.
My lords, in this matter, my lords, the matter which had come up last week, 498A. My lords, few events that have transpired before this complaint is filed. My lords, the marriage is of the year 2014, my lords. My lords, 2023, the second respondent leaves the matrimonial home, my lords. Thereafter, my lords, petitioner would issue notice more for restitution of conjugal rights, my lords. That was done on 31/1/2024. Then, my lords, there was a mediation. In the mediation, the couple were brought together, my lords. This would happen on 28/3/2024, my lords. After that, my lords, on 3/4/2024, the father of the second respondent, along with certain persons, would come, my lords, and cause assault on the present petitioner, the first petitioner, the husband, where he dislodges his shoulder, my lords. And then a complaint is given on that basis. A police complaint on 4/4/2024 is given, my lords. Then an MC is filed after that on grounds of cruelty. And, my lords, that divorce petition is pending. And there's an interim order restraining the respondents from causing any trouble, my lords, which happens on 27/4/2024, my lords. Then comes this complaint on 7/5/2024, my lords. Virtually after 9 years from the date of marriage, 8-page complaint, my lords, as though the events from 2014 onwards, what has happened. And in this complaint, my lords, not just the husband, all others, my lords, if the petitioner's ranks are seen, my lords, the father-in-law, mother-in-law, sister of the petitioner number 1, sister of the petitioner number 1 residing at US, son of petitioner number 4 who's a student, my lords, against him they say 354, my lords, and one family friend are included. Now, in matters of this nature, my lords, where 498 is sought to be invoked, that too after a long gap of time, my lords, the view taken by Supreme Court recently, my lords, where Achin Gupta, where they say, in fact, my lords, they would request the legislators to have a relook at section 84 and 85.
84 to
85 of the BNS to say what exactly is happening, how you can go about it. If, my lords, there's a reference to the 2 previous judgments, my lords. One is
Tashkan Kaushal,
Preeti Gupta, Kaushal, and Arnesh Kumar. Now, if my lords would kindly notice Achit Gupta, similar, my lords, what has happened in this case, the same kind of contentions, my lords, which were taken there. Could I just pass on that one judgment, my lords? There, my lords, High Court had declined to interfere in 482, my lords. Matter went to the Supreme Court. Supreme Court extracts the whole complaint. That complaint is 16 pages, similar to what we have as 18 lords in our. I'm sorry. This reported.
2024.
Report,
SC 759.
Yes, my lords.
Yes.
My lords, just for a minute, my lords, if I can
I've
just
seen,
point
tell
out.
me.
Our complaint, I've noted about 16 paragraphs, my lords. It runs from page 3 to page 7. The whole complaint is extracted. After that, my lords, the court would notice, my lords, submissions which were done, delay insofar as the FIR is concerned, my lords. They would say there's a delay of about 1 decade for the FIR to be registered from the date of marriage. We get that at paragraph 12, my lords. And they would say, my lords, that the relevant portion, I'll just point the relevant portion, my lords, how the court observes. My lords, if paragraph 36, I mean, in fact, my lords, 32 early, many times the parents, including close relatives of the wife, make a mountain out of a molehill. Paragraph 32 early, instead of salvaging the situation,
You've seen Justice Pardiwala said.
making possible endeavors to get them together, instead of doing that, you would set the criminal law in motion and you would want the police to go against them. And in this case, I'm given to understand, my lords, the police who is investigating is a relative of the complainant itself.
Oh.
And on this basis, 32, kindly notice, my lords, after that, they quote Denning, my lords, in paragraph 33. And finally, my lords, at paragraph 36, my lords, I'll just read this more for my satisfaction than my lords. For the foregoing reasons, we have reached the conclusion that if the criminal proceedings, I'm sorry. Couldn't copy.
Ide tagoli.
I'll read it.
I have seen, you can take it.
Just these two, my lords.
Yes.
My lords, for the
No, that is
foregoing
only a
reasons-
suggestion by the Supreme Court to the Parliament to look into.
Yes, my lords, they
To look into for an amendment of section 86 to 88 of the BNS.
yes, my lords, which was equivalent to 498 here, equivalent.
88 BNS under 498.
And that is to come from 1st July.
1st of July.
ಇಲ್ಲಿವರೆಗೆ ಏನಾಗ್ಲಿಲ್ಲ, my lords. Discussion ಆಗ್ಲಿಲ್ಲ.
ಯಾವ್ದಕ್ಕೆ?
For looking into 84, 85, it stands as it stood.
It's a suggestion.
Suggestion to the legislation, have a relook because it is the most misused provision, my lords.
ಆ ತರ ತುಂಬಾ ಇದೆ IPC misuse provision.
And even Dowry Prohibition Act, we have in other acts also special enactments, my lords, we see it. Now, my lords, please
But
look
you
at the-
can't paint every case with the same brush.
No, please look at the present case, my lords. After 9 years, with so many proceedings, restitution of conjugal rights, where they have brought the couple together, then she goes away from it. And then, my lords, attack on the husband. Husband sets a law in motion with an FIR, similar to what happened even in the Supreme Court case.
Yes.
After that comes the present case, my lords.
All right.
Would
Yes.
it not be an abuse, my lords?
Yes, sir.
But 354 is clearly addressing so far as father-in-law is also concerned, my lord.
Where
Page
is that,
46,
sir?
Page 46, my lord, of the petition. Apart from 498, my lord, there's 315, 380, 354, and other offenses also.
Page 44.
Page 46, my lord, second paragraph. This is insofar as accused number 6 is concerned. That is,
One
my lord,
minute,
the sister-in-law's son.
Page 2424.
2424. 2424 ರಂದು ರಾತ್ರಿ ಆದಿತ್ಯರವರು ಅಂದ್ರೆ ವೀಣಾರವರ ಮಗ, ದಿಟ್ ಇಸ್ ಮೈ ಲಾರ್ಡ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 6, ಸಿಸ್ಟರ್ ಇನ್ ಲಾ ಸನ್. ಎಲ್ಲರೂ ಮನೆಯಲ್ಲಿ ಇರುವಾಗ ನಾನು ಅಡುಗೆ ಮನೆಯಲ್ಲಿ ಇದ್ದ ಸಮಯದಲ್ಲಿ ನನ್ನೊಂದಿಗೆ ಅನುಚಿತವಾಗಿ ಹಾಗೂ ಅಸಭ್ಯವಾಗಿ ವರ್ತಿಸಿ ನನ್ನನ್ನು ಮುಟ್ಟಲು ಪ್ರಯತ್ನಿಸಿದನು. ವಾಟ್ ಮೋರ್ ಇಸ್ ರಿಕ್ವೈರ್ಡ್, ಮೈ ಲಾರ್ಡ್? ದೇ ಕ್ಯಾನಾಟ್ ಟೆಲ್ ಇನ್ ಡೀಟೇಲ್ ವಾಟ್ ಹಸ್ ಹ್ಯಾಪನ್ಡ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ ದೇರ್ ಆಫ್ಟರ್. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಆಲ್ಸೋ, ಮೈ ಲಾರ್ಡ್. ನನ್ನ ಮಾವನರಾದ ವೆಂಕಟೇಶ್ ಅವರು ಊಟಕ್ಕೆ ಕರೆದು ನನಗೆ ರೂಮಿಗೆ ಊಟಕ್ಕೆ ನೀಡಬೇಕೆಂದು ಪೀಡಿಸಿದರು ಹಾಗೂ ನನಗೆ ಎಲ್ಲರ ಮುಂದೆ ಅಂದ್ರೆ ನೆಂಟರು, ಮಕ್ಕಳು, ತಂದೆ ತಾಯಿ ಹಾಗೂ ಕೆಲಸರ ಮುಂದೆ ಅಸಭ್ಯವಾಗಿ ನಿಂದಿಸಿದರು.
ಆಯ್ತು, ಸರಿ. ಆಮೇಲೆ
ಇದನ್ನು ಮದನ್ ಕುಮಾರ್, ದಟ್ ಇಸ್ ಹಸ್ಬೆಂಡ್, ತಿಳಿಸಿದರೆ ಎಲ್ಲವನ್ನು ಸಹಿಸಿಕೊಂಡು ಹೋಗು ಎಂದು ಹೇಳ್ತಾರೆ. ಅಕ್ಯೂಸ್ ನಂಬರ್ A7, the next paragraph.
This is A6.
A6 and
A6 is 2424.
A6 is 2424.
Accused number 7 ಯಾರು?
Accused number 7, my lord,
Family friend.
Family friend, my lord.
Family friend.
Yes, my lord. In so far as they are concerned, that is at page number 45, my lord. The previous page, second paragraph.
ಅಲ್ಲ, 45. ಯಾರು? A7.
A7. Now, my lord, what has happened? Who's a family friend? He says that, my lord, because the complainant had 2 daughters, he is saying that, my lord, he has another daughter who will get married to the husband, and he suggests the husband that he has 2 wives. That is the allegation also made. In support of the family members. 45 also, my lord, in so far as accused number 7.
ಯಾರನ್ನ ಬಿಟ್ಟಿದ್ದೀರಾ ಈ petitioners ಅಲ್ಲಿ?
Well, it's one sentence is very relevant.
ಅವ್ರು ಯಾರು ಬಿಟ್ಟಿಲ್ಲ ನಾವು. So that is why all the complaints.
One sentence is very relevant. Last portion of the complaint at page 49, her request.
This accused number 7 also.
Accused number 7 also, my lord. Accused number 7, my lord, in
6. 5 yaru?
5, my lord, is the sister-in-law.
Sister. Against 5 also there are allegations?
There are some, my lord, in so far as accused number 5, there are in first page of the complaint, page 41. Last paragraph.
Then accused number 4 yaru?
Accused number 4 is also the sister.
So these two ಮೇಲೆ ಏನಿದೆ?
Yes, ma'am. In fact, my lord, accused number 4, she stays, my lord, in fact, in the road parallel to where the petitioner and the husband stay.
5?
5, my lord.
charge sheet ಆಗಿದೆಯಾ?
Illa, my lords, our request is to bring them together. 49, please notice page 49, my lords.
They filed an
The
anticipatory bail.
Request to the
36, my lord, is the
investigating
next date of
officer is to bring us together. Please notice the second paragraph, my lords. In fact, my lords, it should not have been registered as an FIR. They should have brought them together. That is the request made.
So you want to come back together now?
Lord, we are willing, my lord. We are willing. But now what has happened, my lord? No, the complaint government still stand. For this reason, they have filed an anticipatory bail, my lord. They filed the next date of hearing is on 13/6.
Yes, bail is not.
Bail has not been granted. They have not even appeared before the police. When that is pending, my lord, they come before the court and seeking stay of the proceedings.
Is it a case of 482
Bails.
not being maintainable, my lord?
Seek bails. No conversion of 482 court to a bail court.
This is what they're trying to do.
Seek bail.
It's posted for orders today, I'm giving it.
Then I'll take it tomorrow.
13/6 is the next date, man, for
That
hearing.
is tomorrow.
My lords,
For hearing.
could I request on 13th then, I'm sorry, on Tuesday next? By then we,
18th.
by Tuesday. my lord. These are the facts. She wants to, according to her, please bring us together.
Well,
If
she's
that's
also
the request,
Please bring
if
us
that's the
together is
request, my
first
lords, later.
Now, my lord,
Rather than
what
having
has
a
happened, the
complaint
complaint
against me.
are very clear. The accused number 7, in fact, my lord, is in.
No, that
in
accused
collusion
number
with the-
6 and 7 appear to have gone beyond their limits.
My lords, kindly notice the date of complaint from the allegation. 7/5 is the complaint.
2-4.
Really, my lords,
Sir,
2/4, if anything like that would have happened, 1 month thereafter coming with this complaint.
It is
my
not a
lords.
strange, she's a wife, sir.
But
My
ultimately,
lords,
my lord,
wife
you find
all
that
the
you want to stay with
proceedings
the
that are
husband.
pending between the parties, my lords, an FIR which has been given against a father, similar
You
what
seek
happened.
bail and come.
Yes, my lords, could it be on Tuesday
I'll
then?
take it on Tuesday. Yes. List the matter on Tuesday in the fresh matters list.
Oblige.
Heard, so and so, thank you.
In the meanwhile, my lord, I'll file my objection. Please.
File anything.
Please.
Objections will be to come back to the husband probably, my lords.
Whatever will.
The case, it will be.
Provided they take a step.
Yes. Next.
Lords, this is the matter which had come up last week.
Nimdara.
ಅಲ್ಲ ಮೂರು matter, my lords. Unfortunately, it came in the same. My lords, I
Heard the
pointed
learned
out
senior
reconciliation.
counsel, Sandesh Chowta appearing for the petitioner. A perusal at the complaint would clearly indicate a color of cheating or criminal misappropriation is made purely on breach of agreement and for recovery of money, which admittedly is not a course open to the complainant. Therefore, there shall be an interim order of stay of further investigation in so and so till the next date of hearing, again 27th.
Oblige.
The last week ittala adalla.
Oh, same.
What is this restaurant?
Restaurant,
Ah.
reconciliation of the accounts.
Your lordship, kindly permit me to withdraw the petition.
Bescom,
Mescom.
correct. Vigilance sticker ಹಾಕೊಂಡು ಮತ್ತೆ. Yes.
I was not even served with the copy. I just somehow had a glance.
Heard everybody and Thaki, counsel for the petitioner, after arguing the matter at length, seeks leave of this court to withdraw the petition. Rightly so. Yes. Yesterday's matter, huh? Yes, sir.
Please. But, what I have questioned before your lordship in this petition is the order of cognizance of certain offences compliant in the compliant which are made penal under the provisions of the Penal Code as well as under the provisions of the Prevention of Corruption Act. But a certain protection is given to your public servant who is said to have committed certain offences, be it under the provisions of the Penal Code or under the provisions of the Prevention of Corruption Act or under the provisions of any other statute. In the nature of a sanction is needed for the purpose of taking cognizance.
Sanction is denied?
Yeah, no sanction is given at all. And my lord, let me submit to your lordship out of record, I am given to understand that sanction has been refused. Sanction, he has sought for sanction and he has refused. The government in its wisdom has thought it fit and necessary to refuse to accord sanction. Well, it is a private complaint. It is a private complaint against certain public servants of the rank of additional director general of police, student of police, DIG, and but I don't know whom they have left, right from ADGP of the ACP and all that. But I'm sure your lordship would certainly agree with me in view of the law which my lord has been laying down time and again, and also what the Supreme Court has said is a protection to a public servant for an act done by him which according to or the wisdom of the aggrieved constitutes an offense against false, frivolous and vexatious action. Well, it may be under 197. It may be under section 170 of the KP Act. It may be under section 19 of the Prevention of Corruption Act. Without a sanction, well, I'm sure your lordship would certainly agree with me in view of the law laid down. Time and again, the court does not get the jurisdiction, the authority, the power to accept the complaint for the purpose of recording further proceedings in the case. That is cognizance, judicial application of mind for the purpose of acceptance of the complaint. Well, this being the backdrop of the matter, I may have to invite my lord's attention. Well, kindly turn to page 32 for a second.
32?
Yes, ma'am. This is the private complaint. 32.
Is not required.
A private complaint against public servants while contending that no sanction as such is needed. But what I'm required to now demonstrate before your lordship prima facie that the act that is attributed, the act that is alleged against the public servant, which according to the private complainant may not constitute certain offences, is an act is said to have been committed by them, either the discharge of their duties as such public servants or those acts is relatable to the color of their office. If at this point of time, if I am able to demonstrate before your lordship these two issues, I'm sure I have got to get certain release at your lordship's hands. May I now request your lordship to kindly turn to the what would transpire, my lord, a case in crime number 55 of 2021 came to be registered
against the complainant.
But though the name of the complainant does not find a place in the first information report or the complaint, he comes within the ambit or the purview of the second accused and the third accused. May I request your lordship to kindly turn to the complaint which my lord gets at page 73. Well, there was rampant corruption.
This was registered against whom?
Well, this was, your lordship would get that in against these BDA officials. And then the brokers.
No person named here?
Brokers, yes, it is named, Deputy Secretary and all that it is named. Your lordship will kindly turn to page 73, kindly go to page 74 now.
74.
This is the first information report. If need be, my lord, I shall take your lordship.
Details of known suspect, Bengaluru Abhiruddhi Pradhikara Bhuswad.
Bengaluru Abhiruddhi Pradhikara Bhuswadana Vibhaga ಮತ್ತು
There is no particular name.
No particular name. But the fact remains that the crime came to be registered against public servants who are.
Because section 7 is alleged.
Yes, yes.
7, 7A, 8, 12, 13, 1.
Yes. Number 2, my lord.
Yes.
Madhyavartigalu. Middlemen.
Yes.
In the BDA.
Yes.
Well, I don't know whether your lordship would permit me to take your lordship to the complaint, which your lordship would get page 77. Rampant corruption in BDA in the matter of the allotment of sites. And then, my lord, unallotted sites which they have a separate list to prepare, fabricate certain documents and allot it in favor of certain persons in whom they have the interest and all that. Whatever it may be, my lord, we are not on the merits of that case. The fact remains that a crime came to be registered against certain public servants, middlemen, among others. At page 73, your lordship would get it.
How did you drag the complainant into the web
Yes,
of crime?
Yes. But this complainant came to be dragged into the picture for the reason that in the office of one of the deputy secretaries against whom the crime had been registered, a diary was found by the investigator during the course of the investigation of the crime.
What diary?
A diary that has been maintained, a regular diary by the deputy secretary, obviously by the deputy secretary. But in that diary, an entry was found with regard to the name of this private complainant and also his telephone number. Well, that has necessitated the investigator to probe into the issue, how he is connected with this crime. Well, what would happen is, then, my lord, not only in exercise of the powers clothed upon the policeman under the provisions of the CRPC,
my lord, what he does is, my lord, nowhere it contemplated a search warrant has got to be obtained. As long as a crime has been registered in relation to a commission of a cognizable offense, my lord, the policeman has the powers under the provisions of the CRPC.
No, but the crime is not registered against him.
No, ಇದೆಯಲ್ಲ.
No.
Second ಇದೆಯಲ್ಲ.
ಎಲ್ಲಿದೆ?
ಮಧ್ಯವರ್ತಿಗಳು.
ಮಧ್ಯವರ್ತಿಗಳು.
ಅಲ್ಲ,
There is no
doesn't-
name. He is not named. FIR is not registered against him by naming him.
By naming him.
ಮಧ್ಯವರ್ತಿಗಳು could be anybody.
ಇದೆ.
Yes.
Then, my lord, we would obtain a search warrant at the hands of the court. This investigator would obtain a search warrant at the hands of the court. May I just request your lordship to kindly turn to ink page 82. 82. On 22/3/2022.
Search is conducted.
Search is conducted. My lord, kindly see.
What comes out of the search?
Yes, my lord. May I request your lordship to kindly go to page 84. Last paragraph. ಸದರಿ ಶೋಧನಾಧಿಕಾರಿಯವರು ಪಂಚರಾದ ನಮ್ಮಗಳ ಸಮಕ್ಷಮ ಸದರಿ ಮನೆಯ ಹಾಲಿನಿಂದ ಶೋಧನೆಯನ್ನು ಪ್ರಾರಂಭಿಸಿದ್ದು ಸದರಿ ಮನೆಯ 1ನೇ ಮಹಡಿಯಲ್ಲಿರುವ ಮೋಹನ್ ಕುಮಾರ್ ಅವರ ಮಾಸ್ಟರ್ ಬೆಡ್ರೂಮ್ ಶೋಧನಾ ಕಾಲದಲ್ಲಿ ಕೆಳಕಂಡ ದಾಖಲಾತಿಗಳು ಸಿಕ್ಕಿರುತ್ತದೆ. ದಾಖಲಾತಿಗಳ ವಿವರ 3 files. Then, my lord, next, my lord, ಈ ಮನೆಯ ಶೋಧನಾ ಕಾಲದಲ್ಲಿ ಕೆಳಕಂಡ ಬ್ಯಾಂಕ್ ಖಾತೆಗಳು ಪತ್ತೆಯಾಗಿದ್ದು ಅವುಗಳ ವಿವರ ಈ ರೀತಿ ಇರುತ್ತದೆ. Then, my lord, ಮುಂದುವರೆದು ಸದರಿ ಶೋಧನಾ ಕಾಲದಲ್ಲಿ ಪಾಸ್ಪೋರ್ಟ್ಗಳು ದೊರೆತಿದ್ದು ಡೀಟೇಲ್ಸ್ ಇರುತ್ತದೆ. ಶೋಧನಾ ಕಾರ್ಯದಲ್ಲಿ ದೊರೆತ ನಗದು ಹಣ ಈ ತರ ಇರುತ್ತದೆ. ಚಿನ್ನದ ವಸ್ತುಗಳ ವಿವರ ಈ ತರ ಇರುತ್ತದೆ. ಡೈಮಂಡು, ಚಿನ್ನ, ಬೆಳ್ಳಿ, and then, my lord, certain household articles and all that. Ultimately, a Panchanama came to be done on 22/3/2022. And the articles or the material objects that were found in the house of this respondent was brought to a property farm, brought to the notice of the court, and the orders for retention of those properties in police custody pending completion of investigation was obtained. But then, my lord, on the same day, another search came to be conducted in the office premises of the respondent, which your lordship would get at page 91.
Yes.
Kindly go to 92. ನಂತರ ಶೋಧನಾಧಿಕಾರಿಯವರು ಪಂಚರಾದ ನಮ್ಮಗಳ ಸಮಕ್ಷಮ ಸದರಿ ಕಚೇರಿಯ ಮೋಹನ್ ಕುಮಾರ್ ಅವರ ಚೇಂಬರ್ನ ಶೋಧನಾ ಸಮಯದಲ್ಲಿ ಈ ಕೆಳಗೆ ಕಂಡ ದಾಖಲಾತಿಗಳು ಬಂದಿರುತ್ತವೆ. All relating to certain lines up to 19.
Yes.
My lord, at page 95, it was brought to the notice of the jurisdictional court and orders for retention of those properties after the production of the Panchanama came to be obtained.
But he is still not an accused.
My lord?
He is still not an accused.
Within 3 days of the search, he would come up before this court.
Within 3 days of the search.
Within 3 days.
Justice Hemant or order.
Yes, my lord. But fortunately for the investigating officer, this honorable court, my lord, gives.
No, that is liberty is reserved.
Yes,
incriminating material.
Yes, if during the course of further investigation of the case, in the event of you being able to lay certain.
So 2 factors are clear.
Yes.
He was never an accused in any crime.
Yes.
After the conduct of search, he approaches this court. This court quashes what?
The FIR in crime number 55 or 21.
You said he is not an accused in any case.
My lord, that is the order which came to be passed by this court. My lord, I can't make any comments on the of this court.
No, adalla. But where is the orders?
Yes, I have given it yesterday. As against him, FIR stands question.
FIR dated 19/11/55 of 21. Which is the? Which is FIR 55 of 21?
The one which I invited my lord's attention now against the BD officials, middlemen and others.
He is not even named in the FIR. Yes.
But fact remains that.
Yes.
My lord, I am not here to make any submissions, my lord.
Clarification about it.
But the fact remains, ultimately, my lord, what a coordinated bench of this honorable court would say is, liberty is reserved with the respondent lokayukta to proceed against the petitioner in accordance with law in the event of any incriminating materials are found against him with regard to the allotment of sites illegally by the BDA. Still, my lord, it is kept alive. The investigation is kept alive and.
What is the date of the order?
Well, the date of the order is in March, that is on 2nd of February 2023.
March 23.
Yes, my lord, 2nd of March 23.
Now this private complaint is registered.
But now the private complaint is registered. Well, let us see the. Well, for an offence under the provisions of the Prevention of Corruption Act. Cognizance is taken under section 13 of the Prevention of Corruption Act. Well, may I just request, of course, well, your lordship is coming across the provision of section 13. Just to refresh my lord's memory, have a look at section 13, my lords.
Yes.
How does it attract it?
The title may attract, not the content.
Proceed with an assumption. A worst scenario. Kindly proceed with an assumption. For the sake of argument, do not conceding for a moment. Yes, it is attracted. Well, the section 19 is a bar. Not only, it is for the purpose of taking cognizance of the offence. How the court would have taken cognizance? The court would say, no, sanction is not necessary. Contrary to the law laid down time and again, not only by this court, but also by the Honorable Supreme Court, but also contrary to a circular which came to be issued by this Honorable Court. May I just request your lordship?
Circular?
Yes, my lord.
Oh, with regard to cognizance.
Regarding cognizance, may I just request your lordship to kindly turn to the circular which my lord gets at page 70. It is nothing short of a caution. Circular is nothing short of a caution to the trial courts, to the sessions court. My lord, may kindly, this is on 23rd.
My order.
Your lordship.
Because of my.
In more than one case.
Yes.
In more than one case. My lord, have a look at page 71 now for a second. Small Roman one. Small Roman one. The complainant should narrate that the complainant has made its efforts to register a crime before the Karnataka Lokaayukta.
No, I remember, I wrote this and directed circular to be issued. Because private complaints were being entertained.
Lokaayukta complaint to illa illi. Right away he goes, files a complaint.
No, the learned judge records that sanction is not required in the case at hand. Following some Supreme Court judgments, let me see what is it.
Well, may I just invite your lordship's kind attention to later judgments of the Supreme Court.
Dr. S.M. Mansoori.
Devendra Singh's.
Devendra Singh old ಆಯ್ತು. Devendra Singh, Devraj ಎಲ್ಲ old ಆಯ್ತು.
Devraju ಇದೆ.
ಅದು old ಆಯ್ತು.
ಅದರಲ್ಲೂ ಏನಾಗಿತ್ತು ಅಂತಂದ್ರೆ even cognizance also could not have been.
You should go to A. Srinivas Reddy versus so and so. 2023 8 SCC 711.
ಅದರಲ್ಲೂ ಇದೆ.
Entire spectrum of the law is considered. That is again reiterated in Dr. A. Mansoori.
ಇದರಲ್ಲಿ.
That is 2023 again.
ಇದರಲ್ಲಿ the conduct that is attributed to the accused, which according to them would constitute an offence. Is it not relatable to the discharge?
That is why what Supreme Court says in A. Srinivas Reddy is it lays down the nexus test. Nexus test, both even in Mansoori it is said the nexus test. You've got those judgments?
Sorry, my lord, he could not get it. ಈಗ ಹೋಗಿ ತಗೊಂಬಂತಂದೆ ತರಲಿಲ್ಲ ಅವರು. ಇದರಲ್ಲಿ ಇದು ದೇವರಾಜ್ ಕೇಸ್ ನಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ
D. Devraj is
ಅಲ್ಲ even assault, it is a case of assault.
D. Devraj versus Owaisi is
in fact in Devraj's case number of other earlier judgments have been referred to.
True, but that is slightly deviated in subsequent judgments, one by Justice Pardiwala. And this is A. Srinivas Reddy, you should see. 23 8 SCC 711. Give that form. And the A. Mansoori, 23-6 SEC, 156, both you should get.
Also
Really?
Sadaksharhi below
Ah,
24.
that is true. This is even, yes, reported judgment. Reported at 711-23-8, yes.
ಈಗ ತರ್ತೀರಿ ಅಂತ ಅವಾಗ್ಲೇ ಹೇಳಿದೆ ನಾನು. ಪರವಾಗಿಲ್ಲ ಸದ್ಯಕ್ಕೆ
No,
ಸಾಕು.
this young boys should get up first in end.
ಸದ್ಯಕ್ಕೆ ಸಾಕು ಈಗ ನೋಡೋಣ ವಿ ಆರ್ ಅಟ್ ದಿ ಸ್ಟೇಜ್ ಆಫ್ ಅಡ್ಮಿಷನ್ ಆಮೇಲೆ
Yes.
ಬೇಕಾದ ಅವಶ್ಯಕತೆ ಇದ್ರೆ. Not here. What did the ADGP do? Let's go to the allegations in the complaint. What did the SP do? What did the remaining police officer? Well, I'm posing that
So
question to myself.
was the complainant beaten or assaulted?
Nothing. Nothing. Only they came, conducted a search. Search is contrary to section 17 capital A of the Prevention of Corruption Act. No, that is incorrect. No prior permission has been taken under 17A. That is all incorrect.
By whose permission had to be taken?
ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
For a private party search, where is PC Act 17A springing in?
But that is his case. That is what the learned judge writes. Well,
No,
ಅಲ್ಲಿ
I am only concerned whether there is something more than what meets the eye here.
Millard, I don't know whether I would be justified in making a submission out of record or not, Millard, something different. There are somebody who would set up some parties, Millard, shadow boxers, what we call them as shadow boxers. ಅಷ್ಟೇ ಇನ್ನೇನಿಲ್ಲ ಇದರಲ್ಲಿ.
Yes.
Case is still under investigation. ಆಯ್ತು, what did the ADGP do, Millard? Kindly take the allegations that is made. ಏನು ಅಂತಂದ್ರೆ
Against the ADGP also?
ADGP is the accused. DIG is the accused, SP is the accused, DSP is the accused, all the entire ACB. Well, have a look at the allegation. I shall read to your lordship only one sentence because your lordship posed a question to me. Was he subjected to any harassment?
Ah, that is what.
Yes. Well, what you would say is
Invasion of right to privacy.
ಅಷ್ಟೇ. And all of them have entered into an act of criminal conspiracy. ಕಾನ್ಸ್ಪಿರಸಿಗೆ ಕಂಪ್ಲೇಂಟ್ ಇಲ್ಲ, ಕಾಗ್ನಿಸೆನ್ಸ್ ತಗೊಂಡಿಲ್ಲ. Lord, may I request your lordship to kindly turn to for a second, although it is to some extent it is irrelevant.
ಯಾವುದು?
Order.
Cognizance order.
ಹೌದು.
Page?
Lord, it commences from page 31.
Which page you want?
Well, kindly go to the operative portion of the order, that is sufficient. At page 71, 31, I'm
70,
sorry, 31, 31.
Yes.
First of all, they must tell us in the complaint how the act that is attributed would constitute an offence under section 13, number 1. Kindly go to page 71. From the top third sentence, kindly read. I am of the opinion that prior sanction as contemplated either under section 19 of the Prevention of Corruption Act or under section 197 of CRPC is not required for taking cognizance of alleged offences and proceeding against the accused. ಇದರಲ್ಲಿ ಕೆಲವು ಅಫೆನ್ಸು ಇದೆ ಇದರಲ್ಲಿ IPC ನಲ್ಲಿ 195 is a bar. But I am not at this point of time taking your lordship in depth.
167 and 219.
Allah, we will not go in depth into it. Then, my lord, now kindly read this, my lord. Cognizance is taken under section IPC of the Indian Penal Code under section 13 of the Prevention of Corruption Act is taken. Office is directed, kindly note this, office is directed to register the case in register number 10 and put up for furnishing the list of witnesses and the issuance of process. Without even recording this own statement. Put up the papers for issuance of process. He has already made up his mind. Well, at this point of time, this would be the submissions which.
No, ಇರದೇ ಅಷ್ಟು. You can finish your submissions on the merit also.
Please.
You are ready, right? You are ready. Yes. Not at the outside.
I'm sorry, my lord. Otherwise, what happens is this. virtually my lord, subjecting a public servant to blackmail tactics. So, in every case, my lord, if an accused against whom, my lord, a crime is registered or not registered, even if it is not registered, if during the course of the investigation of the crime, if his complicity in relation to that crime is disclosed, nothing prevents the investigator from continuing with the investigation. But if everyone were to say like this, search is illegal, if search is illegal, it goes, the case goes. What is the offense you would have committed? Otherwise, my lord, no investigator, no public servant can discharge his public functions and duties as mandated under the law.
Yes, we'll hear him. Yes, sir.
Please, my lord. But at the outset, with regard to the issuance of process which the learned senior my lord referred to, there is a typographical error there in the order.
Yeah.
It is for SS that has been corrected in
Where?
the order sheet.
ಬೇರೆ ಆರ್ಡರ್ ಶೀಟ್ ಇದೆಯಾ?
ಅಲ್ಲಿ SS ಇದ್ದಿದ್ದು process ಅಂತ ಆಗಿದೆ. That has been corrected.
SS is own statement.
Own statement and for, give me a call.
All right, that's,
So my lord, now
you get into the meat of the matter.
this cognizance has been taken. Now it is posted for recording of sworn statement of the complainant on 21st.
All right.
And his witnesses. We have furnished the list on the last day.
All.
Now, my lords, certain facts would be essential in the form of list of dates. Before that, my lord, we will furnish the entire private complaint. So we'll be referring to the documents. No, the entire document.
Private complaint is not filed?
Only the complaint is filed, but the accompanying documents are not.
That's good.
Give them a copy.
All right.
Page 43 is the complaint or the information dated 19/11/21. The dates will not assume significance.
Whose complaint is this?
This is by A2 to A1. A2, accused number 2. That is the petitioner number 2.
All right.
There are, my lord, 7 accused.
All right.
They are 7 petitioners. So I'll refer to them
No,
by the
it is
rank.
with regard to
The starting point.
illegalities in the
Yes,
PDA.
BDA. Based on this, my lord, the dates are important, 1911. Please come to page 39.
Registration of the crime.
Yes, FIR is, my lord, registered by A1 on 19/11/2021, crime number 55 of 21. Now itself, my lord, I'll point out, this is dated 1911. Lordship may kindly come to the handwritten portion on the top of the page. This is sent to the special court on 25/11/21. After 6 days. Thereafter, my lord, on 20/11/21, a raid is conducted on the office of the BDA.
BDA.
Yes.
Yes.
That we have mentioned in para 32 of the complaint. Thereafter, my lord, there they say that they find a diary.
In the office of the BDA.
Office of the BDA, they find a diary in the cupboard of one Geeta Huded, who is the Deputy Secretary 1 working in BDA. And this diary is of the year 2030. We have obtained the entire diary, my lord, through RTI. Based on this diary, they say, my lord, kindly turn to page 66. This is one page, relevant page of the diary.
66.
Yes, 66 of the paper book which I furnished a little while. This is, my lord, one of the page, the relevant page. 10th January 2013. This is the diary. Here kindly, my lord, come to the fourth line. The present complainant, Mohan R.T. Nagar, his number, take 4 files, back 1 file. Based on this, my lord, with the risk of repetition, the raid is conducted on 20/11/21, even before the FIR is sent to the learned special court. Based on this, they start harassing the complainant.
Now, this is Mohan R.T. Nagar is you, is it?
According to them, yes, these numbers are mine. That I would not
Telephone
deny.
numbers are yours.
Yes. But this will not.
This is found in the office of the BDA.
Office, they say office in one of the diary. Diary runs
That's all
into several.
it is found in the office of the BDA.
According to them. And the statement, I'll come to that later, my lord. I'll chronologically take your lordships. Thereafter, my lord, they start harassing the complainant. They do nothing. The complainant is not arraigned as an accused. Neither this Geeta Hudaid is arraigned as an accused.
Yes.
That is Deputy Secretary 1. By name, she is not.
Because I myself upheld the charge against her.
Please, I'll. But in this FIR, my lord, she was not named.
In this, not in this FIR.
In the thereafter, my lord, none of the accused are named therein. They start harassing. After a period of 4 months, they conduct a raid. They obtain, my lord, a search warrant. Your lordship may kindly turn to page 45.
Yes.
This search warrant is in respect of number 62 First Cross RT Nagar, Bangalore. This is dated 21st March. That is after 4 months from the date of registration of FIR.
21st March 22.
Yes. FIR is
All right.
19/11/21.
Search is conducted after 4 months.
Yes. And your lordship may kindly come to the note made therein underneath or in the bottom, seeing that ಈ ದಿನಾಂಕ 22/3/22 ಸದ್ರಿ ವಾರೆಂಟ್ ನಲ್ಲಿ ನಮಗೆ ಸೋ ಅಂಡ್ ಸೋ ವಿಲಾಸ ಮನೆಗೆ ಹೋಗಿದ್ದು ಶ್ರೀ ಮೋಹನ್ ಕುಮಾರ್ ಅವರು ಸದ್ರಿ ಮನೆಯನ್ನು ಖಾಲಿ ಮಾಡಿಕೊಂಡು ಬೇರೆ ವಿಳಾಸದ ಮನೆಗೆ ಹೋಗಿದ್ದರಿಂದ ವಾರೆಂಟ್ ಅನ್ನು ಜಾರಿ ಮಾಡಲಾಗುವುದು. Thereafter, what the accused number 5 does it, kindly turn to page 46, my lord, is he issues another search warrant on the same day. This is 45 is by the learned special judge.
To a different address.
Different 2 addresses. That is, your lordship gets it on page 5, line number 5. That is house number 265 RT Nagar is my house on page 46.
Now, several items are seized.
Yes, nothing is found there. From the
No, nothing is found qua the BDA transactions.
Yes, the BDA transactions, only my personal belongings are found. In fact, learned senior pointed out the 3 files that were found, my lord, they are my personal properties which I have purchased.
All right.
Barring that, nothing pertaining to the so-called shady transaction in the BDA, which, my lord, is the basis of the allegation in FIR 55, is not found.
So whatever is recovered is all your explainable property.
Yes, there are 3 files and there is a report filed by accused number 6. I will point out, my lord.
Report as to what?
Saying that nothing is found.
Page
90.
Who is accused number 6?
Is sorry?
Accused number 6 is the
accused number 6
DYSP
is one SP.
Yes.
$119, my lord. No, this is, my lord, pertaining to the income tax department. There is a letter address, I'm sorry, it is at page 97. 97. This is, my lord, addressed to accused number 7. Your lordship got it.
I'm at
This is
97.
-3 2022. Lordship may kindly note this -3
Undated.
2020. Undated, addressed to ADGP accused number 7, addressed by accused number 6. Kindly come to page 100. Before that, my lord, may I point out the caption on page 97? The caption is submitting report on findings during investigation of the case in crime number 55 of 2021.
All right.
Now kindly come to page 100.
I will take it, nothing is found.
Yes. In fact, there is no reference, my lord, to those 3 sale deeds which were found, which was mentioned in the search Panchnama.
All right. Yes.
These are all his passport, passbooks, bank account of his wife, some gold ornaments.
You are still not named as an accused.
Till date. Now, my lord, they continue harassing me after this. Hence, I approach this honorable court. Your lordship was pleased to stay it on 13th. He approaches this honorable court on 12th. Page 70, my lord.
My order?
Your lordship's order is interim order. Interim order.
Where is that interim order?
Interim order, my lord, is dated 13/4/2022.
13/4/22.
Yes, he approaches this honorable court on
What?
12/4. May I read your lordship's order?
Yes.
Heard the learned senior counsel so and so, the learned senior counsel would submit that the house of the petitioner is searched without there being any allegation against him or any connection with the allegations with other officers. The search is also made on 22/3/2022 without a specific warrant to do so. Learned counsel for respondent number 2, so and so, so and so, till such time the investigation and further proceedings in crime number 55/2021 shall remain stayed. Thereafter, my lord, he approaches on 12/4. The dates, my lord, they continue, they search his house on 22, they continue to harass him. He approaches this court on 12th. On 13th, your lordship was pleased to stay.
But the FIR is squashed. He's not even an accused in that.
Please, now I will come to that, my lord. Kindly come to page 70, the final order.
There, the interim order was granted on the score that search warrant is, his house is searched.
Yes.
Without a warrant.
Yes. Now
Or
that
whatever,
is
the
discussed
submission.
in, that is discussed in his lordship's order. Page 70. My paper book itself, my lord, it has that.
70.
Yes.
Your paper book?
Yes, inclusive of the PCR, my lord.
Yes.
And it was part of the PCR.
All right.
Relevant para, in fact, your lordship's earlier judgment in Kumar Naik.
No, that
and
is on the
Balkrish-
source report.
Yes. Now kindly come to para 8 on page 76. May I read, my lord? The criminal prosecution against the petitioner accused herein was launched on the basis of a diary seized from the office of the Bangalore Development
No.
Authority.
Para 10 is what the learned judge holds. The entry in a diary cannot be the sole basis for conducting
Yes,
investigation,
yes.
the absence of any corroborative material.
Yes, to establish that the petitioner, along with the officials of the BDA, was
Not
involved
close
in
to
allotment of sites illegally. Though no incriminating materials were found nor seized, the respondent Lokayukta has not closed the investigation against the petitioner, and the petitioner is constantly put under an apprehension that premises will be searched under the guise of investigation which will infringe.
This has become final.
Yes, and in fact, my lord, we have obtained through RTI, the Lokayukta has opined that this is not a fit case where an appeal can be filed.
Yes.
So now, my lord.
Now,
the-
based upon
this,
what is observed in para 10
yes,
appears to be the genesis of the
Genesis-
private complaint.
the genesis, my lord, is the fabrication of the diary.
What fabrication?
That diary, my lord, that page in the diary was not, they search, they conduct a search on 2011.
All right.
They say, my lord, that it was recovered from Geeta Hude.
Yes.
No statement is recorded. Your lordship may kindly come to page 114 of the paper book.
Yes.
112 it ends ante ಅವ್ರದ್ರಲ್ಲಿ. We'll give it.
ಯಾವುದು?
ಅಲ್ಲ, they have some pagination problem.
Pagination ಅಲ್ಲ, page ಇಲ್ಲ.
ಅದ್ ಕೊಡಿ.
That is his allegation.
ಅಲ್ಲಿ in the diary, not with senior.
Yes, yes, I know.
Not his paper book.
Now, all right, we'll take it, everything as
I will
happened.
just point out below page 160, I'm sorry,
114.
114.
Yes.
Important page below is page 116. This is furnished by the Chief Information Commissioner based on the information submitted by the Lokayukta. Statement of person from whom diary was seized, BDF, request, etc. etc. ಕಡತಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಉಪಕಾರ್ಯದರ್ಶಿ ನಾಕು ಗೀತಾ ಹುಡೇದ್ರವರ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದುಕೊಂಡಿರುವುದಿಲ್ಲ.
Statement is not taken.
No. So, my lord, the diary, that is the page based on which they start harassing me, my lord, is the fabricated diary. That is the page. And based on which, my lord, they commit trespass. Various offenses are alleged. Now, my lord, the learned special judge has only taken cognizance. It's a well-reasoned order. As regards, my lord, sanction and all, I will answer.
Answer that. That
Please.
cuts at the root of the matter.
Please. Before that, my lord, may I submit, this honorable court has held. Where is my copy? Huh? My lords, regarding sanction as per the judgment of latest judgment of Supreme Court, my lord, in Sadakshari versus State of Karnataka, sanction would not be necessary.
This is old, sir.
Please, that, my lord, is with regard to locus standi of the petitioner himself. Kindly, my lord, turn
Locus
to
standi of what?
of the petitioner to
The accused.
Yes, petitioner accused to challenge the cognizance when it is at the stage of inquiry. It identical circumstances, my lord, relying on this is the
Yes, sir.
para 42, my lord, may I para 42 and para 68. It starts at para 42. The discussion, my lord, relying on the Supreme Court judgment in Nagava and Vadilal Panchal versus.
You need not labor, sir. I don't accept this.
2011, 2020.
In fact, learned senior had argued it.
I will, Allah, maybe. But
ನೀವೇ ಮಾಡಿದ್ದು. One of the.
there are
And I had.
three counts.
ಅಲ್ಲಲ್ಲ, ನಾನು ಹೇಳ್ತಾ ಇರ್ತೀನಿ. Well, legal profession is just like a spinning of a coin. At times it will be head and at times it will be tail.
And I had assisted him in
For
that.
petitioner, that will be the.
And never shole.
Sorry.
Never shole. Yes.
Yes, both head ಇಲ್ಲ ಅಲ್ಲಿ, both tail ಇಲ್ಲ.
ಅಲ್ಲ, ಅದಕ್ಕೆ.
ಅಲ್ಲ, ಅದು 2011, now in 2020 this is what.
No, you need not rely. I will not, I don't accept this at all. If
No, my
somebody
lord.
is entitled to knock at the doors of this court and it is entertainable, why should someone face the rigmarole of trial?
Please.
Sanction ಹೇಳ್ಬಿಡಿ ಅಷ್ಟೇ.
Let
That's,
him take sanction and prosecute me if I have committed any sin or wrong.
that we'll see.
See,
That-
and I have applied for sanction.
Then it's all right. You tell me what. On sanction, what it is.
So that regarding rejection, my lord, we have not been communicated.
No, that's all right. You
Yes.
labor on
Page-
why sanction is not required because
Please,
court
page-
says sanction is not required.
With regard to one
Now,
ninety-seven
while
PCI.
taking cognizance.
Yes,
Court says cognizance is not, sorry, sanction is not required either under 19 or under 197. Justify that.
please. That is, my lord, on two scores. One, the special court, my lord, has relied on the constitution bench judgment in Antule's case, my lord. And secondly, the latest, that is 2024 SEC online SC 48.
Relies on that also.
That has not been, my lord, specifically referred to.
Kodiyar.
At Kudi.
Actually.
Yes, Kudi. Reduction. Huh? Sorry? Yes, this is live law, my lord.
Yes.
Equivalent is 22. I put this. Sorry, senior, you know, copy. So there they say, my lord, fabrication of records.
No part of official duty.
Please. So on that score, my lord, it has been. And now the entire ACB has been abolished.
It's Lokayukta now.
Yes. They no longer hold the, of course, but with the amended 99.
Seriously? Because there is a change in post user saying sanction is not required?
No, I'm not saying
Then-
that. Reference to Antule, my lord, I am clarified. That is the old law, that's it. With the amendment,
So
my lord,
with
it is-
reductory, you say that fabrication is not a part of official duty,
please.
so it cannot be. Cognizance is taken for 13 also.
Well, who has said it is fabricated? Somebody should say it. That is his
I'll-
allegation.
I'll get back.
I'm sorry, I'm sorry. Always.
Yes. Yes, sir.
Please, my lord.
Allah, cognizance is taken for 13 as well.
Of the
Section
PC
13
Act.
of the PC
Yes,
Act.
because, my lord,
Ah.
there is bribery allegation in the complaint.
Bribery by whom?
That they demanded illegal gratification. They kept on the delay, my lord, from the date of FIR to the date of search.
They have been demanding illegal
Yes.
gratification. They are all these ADGP and others.
Yes,
All the accused.
yes, in conspiracy and learned
In,
senior, my
in
lord.
conspiracy, they have demanded money from you.
Yes. And cognizance is taken for 120B also.
No, 120B also. that's
Yes,
there.
because learned senior, my lord, by oversight submitted that it's not taken for 120B.
ಇಲ್ಲ 120 ಇರ್ಲಿ. Take it as one. ಆಯ್ತು. 120B ನೂ ಇದೆ.
Yes, tell
ಅಲ್ಲಿ 12 ತಗೋಬೋದಿತ್ತು.
yes, even bribery. Even
Yes.
for bribery, my lord,
Yes.
add,
So according to you, section 13 is taken for, cognizance is taken qua section 13 because they demanded money. That is your complaint.
my lord, for other offense, it could have, now with the amendment, now section 13 is watered down to 13(1)(a) and
Yes,
B.
13(1)(d) and D. Yes.
There might be, not that I'm conceding, my lord, but for a moment, even if I concede, that cognizance is taken for a wrong provision. It ought to have been for 7.
Will not vitiate the.
That will not vitiate.
That's Pradeep Odayer.
Yes. And in fact, your lordship has consistently followed Pradeep Vadeyar because we are at the cognizance stage. Now, my lord, my sworn statement has to be recorded. I will have to establish now prima facie the learned special judge is satisfied, he has taken cognizance. Under 200, my statement will have to be recorded. Under 202, my witnesses, the list has been furnished on the last date. I will have to examine them. After that, my lord, the learned special judge has an option to dismiss the complaint under 203. And he need, even if he, my lord, decides to issue process, it's not necessary that he has to issue process against all of them. This is only cognizance, and your lordship has copiously dealt with relying on Pradeep Wadia, and has, my lord, in fact dissected cognizance of an offense and summoning of an offender. So I need not, my lord.
Because cognizance is taken against the offense, not the offender.
Yes.
Yes.
And our specific, my lord, prayer was to take cognizance only. Because regarding fabrication, under 202, an inquiry can be conducted. The learned special judge can order an inquiry.
Yes.
He can even direct the police. My lord,
So according to you, sanction is not required.
at this
That's your
stage.
submission.
Yes, in fact, we have applied. As per,
Different things, sir. Now, if you have to justify,
justify, 4
if
months,
you have-
has-
if
4
you
months
have-
has elapsed.
no, if you have if you are justifying the finding at paragraph 14 of the concerned code, it holds that prior sanction as contemplated in 19 or 197 is not required for taking cognizance of offences and proceed against the accused person. That is the finding.
Yes, that there is an added, my lord, reason. Kindly, my lord, turn to page 79. This is the sanction which I have sought for on 6/12. This is in.
So the court does not record that, but court records that it is not required.
Regarding sanction, it is not recorded that we have applied.
I am of the opinion that prior sanction as contemplated under so and so is not required for taking cognizance. Perhaps you must have impressed upon the court that fabrication is no part of official duty.
Strictly speaking, for 197 of the CRPC, my lord, but with regard to 13, my submission would be this was placed on record. The special judge has not, my lord, referred to in the order, but this was placed on record. And kindly, my lord, come to page 97, page 87 for a moment. Page 79 is in respect of accused numbers 1 to 5.
Yes.
This is applied on 6/12. Page 87 is in respect of accused number 6 and 7. This is on 6/12.
6/12/22.
23.
23.
Yes, and I filed the complaint on 15/4/24.
So long before
Yes, 4 months
filing,
as provided.
long before filing complaint.
Yes, as
sanctions.
provided in the proviso. That 3+1, my lord, so it is deemed proviso to section 19. Your lordships are aware, my lord, 3 months.
Vineet Narayan.
Yes, and also in the act itself, now in the amendment.
Now act, amended.
Yes, and they further they say, provided also that in case where the purpose of grant of sanction for prosecution, legal consultation is required, such period may, for the reasons to be recorded in writing, be extended by a further period of 1 month. Now, my lord, this
4
is,
months.
yes, this is akin to section 34 of the Arbitration Act. Now that is, my lord, over. I have filed the complaint on 15/4, long after 6/12. That is long after 4 months has elapsed.
Yes.
So, my lord, the special judge's order may not specifically say that. That to that extent, because I can't, my lord, add anything to the.
No, those are facts.
Yes, but prima facie, my lord, he says that he is satisfied. And it is not a sketchy order. He has referred to every allegation.
No, I'm not saying it's a sketchy.
Yes, only this 19. He could have, my lord, because whatever is furnished today is the paper book that is filed before the special court. This was not specifically referred to in the order.
All right. Ashtana, anything else, sir?
One submission forwarded.
That's all.
My friend invited your lordship's kind attention to the subsequent order which came to be passed by the trial court on 4/6/2024.
No, he's not asking.
But the earlier order is for issuance of summons.
Summons.
Now, I don't think I can get from this order sheet, well, this was on 4/6/2024. And I would file this petition before this honorable court on in the early hours of 4/6/2024.
ನೀವು ಫೈಲ್ ಮಾಡಿದ್ 4/6 ಈಗ?
ಹೌದು. ಆಮೇಲೆ ಇದಾಗಿದೆ ಇದು. ಇರ್ಲಿ, ಆಗಿದ್ರು ಏನಾಗಿದೆ ಅಂದ್ರೆ ನೋಡೋಣ. Kindly see, my lord. Just like even without issuance of notice, without compliance of office of trade, just like that. I have filed my petition on 4/6/2024 itself. Even otherwise, kindly read this order. Case is called out. The complainant with his counsel is present and furnish the list of witnesses for sworn statement. How can he correct it? He can't review his order.
And let's see. Stella?
362, it can be, my lord, if it is a typographical error.
Somebody should say, the judge should say, not my learned friend.
This is only the case status in the order. This is case, or this is not the entire order sheet. And 4/6, it was posted. It was posted for my sworn statement.
For issuance of summons.
Due to paucity of time, that is, my lord, for issuance of SS. Wrongly, summons, typographical error. That is why 362, my lord, is.
Somebody should say this type of, who? You are saying it. Court is not saying it.
I will answer.
No one is saying that court did not say it.
Heard the learned senior counsel, C.V. Nagesh, appearing for the petitioners, and the learned senior counsel, Murthy D. Nayak, representing the respondents, who has both have completed their submissions in its entirety. The will take your submissions as objections, whatever it is.
Yes, this paper book can.
That I will, yes, I'm taking it. Yes.
And this has, we have furnished a
The
copy.
submissions of the learned senior counsel, the learned senior counsel Murthy D. Nayak submits that his objections, his submissions and the paper book that he has filed be taken as his objections to the petition. The same is noted, judgment reserved.
An interim order could be.
Next yavatide?
21st.
21st of June.
Yes, for.
Iದೇ ತಿಂಗಳು. Next week.
Sworn statement, not for process.
When he can't take in the event of this honorable court were to come to the conclusion that the order of taking cognizance itself is bad, the question of recording the further sworn statement may not arise at all. That would be clear.
In 10 days. Before that.
Please.
Grateful.
Landlord tenant dispute, criminal trespass 447, 448 is alleged, my lords.
One HCGP, heard the learned counsel of the petitioner, one HCGP, two emergent notice. The crime appears to have been registered for offences punishable under 447 and 427 as a counter.
448,
448 and
504,
504, as a counter blast to what the petitioners have sought to register. Till the appearance of the second respondent, there shall be an interim order of stay of further investigation in so and so. Is list on 2nd July, 4th July. Yes, next.
No, I appear for the respondent. But I have a request to make, my lord, this matter may be had on some other day, my lord. There is some we have filed a very elaborate objections. There are some documents which are missing in that, my lord.
All right.
I want a week's time.
Learned senior counsel.
I have filed not 4 volumes of statement. My petition runs to 15 pages.
4 volumes of statement of objections.
Petition runs to
Documents hakidivi. My lord, there are bank statements. Most of them are bank statements. There was an earlier, my lord.
So the objections.
Yes, my lord. Along with the
4 volumes.
objections, we have produced, my lord, certain bank statements. Of course, it was at the stage, my lord, is not appropriate at this stage.
But the matter, lords, I may point out. But of course,
Intervener. What? You're not the respondent?
I'm responding.
Application, intervener application, who has filed?
I don't know, my lord, who has
Nitin
filed that.
Prasad.
Wait.
You don't press it?
Yarge?
Learned counsel Nitin Prasad, who had preferred an application seeking to intervene in these proceedings, would submit that the application be dismissed as not pressed. In the light of the said submission, the application so filed is dismissed as not pressed.
just one submission I want.
This heavy matter,
ಏನಿಲ್ಲ ಅದ್ನ ಯಾವ್ದು ತೋರಿಸ್ತಾ ಇಲ್ಲ ನಾನು.
This is a matter
in
when
the
let's accept
enthusiasm,
what the
my lord.
senior counsel will say. But there is a settlement agreement entered into between the
As we'll
parties.
share
As
it
per
in
final,
one
no,
week's
I'm not,
time.
I'm saying something else. I'm not. They, my lords, have received part of that. Arbitration proceedings have been initiated. Their complaint is that as per the settlement, they have not acted upon, hence a case for criminal breach of trust is in. And cheating.
409 and 420.
That's
409,
all
420.
is the, it lies, my lords, in a short compass as to whether this, my lords, constitutes breach of contract or my lord, criminal breach of contract.
Next week, ma'am.
ಯಾವತ್ತು?
ಅದರಲ್ಲಿ one document, my lord, most important document is not filed. ಇದೆಲ್ಲ we can
Objection ಅಲ್ಲಿ
we can
important
eschew
document.
all of this, my lord. There was a complaint.
Are you saying in lieu of all of this, the document will be there?
I'm only saying, my lord, it'll show the sequence, my lord.
All right.
Before this current complaint, which was registered from which this petition arises, there was another complaint that was filed, which, my lord, gives the detailed historical perspective of what has happened.
Which was
What happened in this case, my lord, was it's a joint venture company, my lord. I'm a foreign company. I gave, my lord, a standby letter of credit, and there are developments, my lord, they've encashed a standby letter of credit. That is one of the main issues. Of course, my learned friend is right. There are other proceedings that are pending, but my submission is not latest law on the point is clear. Merely because it is civil proceeding, it doesn't mean criminal doesn't arise.
The other side of the coin is also clear.
No, but the
On breach
latest
of agreement,
position,
criminal law cannot be set into.
latest position, my lord, my endeavor will be to show
All
to
right.
your lordships, my lord,
Yes, sir.
that
fact, my lord,
a
earlier-
teach of civil case
Clear
doesn't,
there was a
my lord,
criminal-
oust criminal court.
No, let's see. There are cases of that kind also.
So that's what, my lord, that one
All right.
document I have to file.
When do you want?
One varam, 1 week or 10 days.
We'll have it on 27th.
Please.
But can it be next week, my lord, is what my learned friend is requesting, 20th, if it is convenient. 19th.
ಮತ್ತೆ it'll haul up. 27th, we'll fix it at 3:30.
Please.
Heard the learned senior counsel Prabhuling Nawadgi appearing for the petitioner and learned senior counsel SS Naganand representing the respondent. Learned senior counsel SS Naganand seeks 10 days time to file certain documents which are inadvertently omitted to be filed along with the statement of objections. Therefore, list the matter on 27th at 3:30 PM. Interim order subsisting shall continue till the next date of hearing. Interim order is granted on SK Alag.
Yes, granted.
Company is not made a party.
Yes, yes.
That's the ground on which interim order is granted.
Yes, my lord, that's one of the.
One of the
My
grounds
case
we are
is
urging.
that won't apply to 420.
No, we are
That will.
Please.
But if it can be until further orders. If it is-
ಅವತ್ತಿದೆಯಲ್ಲ next year.
Already until further orders.
If it is until further orders, it will
Until
continue.
further orders.
ಈಗ ನೋಡ್ಕೊಳ್ಳಿ until further orders ಇದ್ರೆ don't change. Interim order ಬಗ್ಗೆ ಹೇಳಲೇಬೇಡಿ until further orders. List on 27th. Still on. Sure. Let me see.
Again, it should not be that. there's no-
After that.
Till next date of hearing.
After that, in one of the hearing dates, it has been extended.
Till next date of hearing. Till next date of hearing.
But after that, it has been extended.
Oh, here, Justice Hemant Orth. Then don't. 2012-23 until further orders. Oh, madam. 20? Yes.
Try to serve upon the counsel appearing for the respondent as directed by this honorable court, my lord.
You have to serve.
And yes, my lord had asked me to, but he refused to take the notice.
Then take out hand summons. ಇದು 138 ಅಲ್ವಾ?
ಹೌದು, ಇದರಲ್ಲಿ what has happened, the appellate court, my lord, had asked us to deposit 20%.
Not deposited. 5 ಲಕ್ಷ ಕಟ್ಟಕ್ ಕಷ್ಟನಾ?
Swami, ಇದರಲ್ಲಿ ಕಷ್ಟ ಆಯ್ತು because there are many such cases, my lord, and the
Any
respondent.
such cases ಅಂದ್ರೆ then you will have to pay
Yes, sir,
something.
ಅಲ್ಲ,
You can't escape conviction that way.
No, I'm not, my lord,
Then suspension of conviction ಬೇಕಾಗಿರೋದು 148.
ಹೌದು, but
Then-
then, my lord, as far as that deposit of 20%, my lord, there's no discretion exercise, my lord, it is just.
What will see? That,
But
no,
last occasion, my
148
lord
makes
was,
20% minimum.
Yes, my lord, I understand, but my honorable Supreme Court would say.
Aye,
once a
Rakesh
state
Ranjan
court
Verma,
mentioned,
yes.
My lord, it means that, my lord, even that has to be considered.
I will see, yes.
In fact, my lord was passing an interim order. I said, my lord, interim order bad, I will
I
serve
know
it
in
now.
Giridhar's case I have passed on that. Yes,
Yes, sir.
next. List on emergent notice to the respondent returnable by,
My lord, interim order as
The-
far as only
1 minute,
deposit.
sir. Returnable by the 4th of July 2024. Till such time, the order which directs payment of 20% shall remain stayed. 20% to be deposited shall remain stayed. Yes, next.
24.
So you were appearing in the connected cases, so I directed you to take notice. You will accept?
I'll accept.
Yes. Again, problem agide.
Your Lordship, 138 proceedings were initiated in respect of a check issued, one by the company and second by the managing director as a personal guarantor for the company's debt. During the pendency of those proceedings, the company in question came to be wound up. On account of the operation of 446 of the old Companies Act, the magistrate decided to stay both those proceedings as far as the case on the company is concerned, as far as the case on the personal guarantor director is concerned. This was, Your Lordship, by the impugned order dated 2011.
That is set aside.
That has been set aside. Thereafter, the magistrate, after 3 years, on the basis of a memo moved by the complainant that the liquidation proceedings are not going any further, in 2014, set aside his own stay of the proceedings and restored the matter to continue. That order came to be challenged by the accused, both the company and the personal guarantor director, before this honorable court. Those two orders of challenge, Your Lordship, the final orders are produced.
Yes, page 87.
Page 87 and page 94.
Yes.
I'm not before Your Lordship concerning the company's continuance of criminal proceedings. I'm only qua the personal guarantor director.
How can you escape?
Your Lordship, the section 446 relates only to proceedings that are pending qua the company, and specifically there is a exception carved out as far as 138 is concerned, insofar as the personal and penal liabilities of directors are concerned, and there's law on that point. Sorry. This is a reference made to a division bench of the Honorable High Court of Bombay. I've already produced that judgment in the previous case, which I had shared with my learned friend. Similar facts arose. Similar facts arose, Your Lordship, if I can read 3 or 4 paragraphs.
Yes.
Paragraph 1.
I haven't seen that. I will see.
Go through it and
I will.
I'll take it on Wednesday. Counsel, yes, Kamalacharan accepts notice for the respondent. Yes, sir, Kamalacharan accepts notice for the respondent. Counsel for the petitioner submits that if a proceeding under section, if proceeding under 446 is pending?
No, no.
Under 138.
130. No, no.
138.
Why are you relying on this then?
Your Lordship, because the High Court has said that a liquidation or a winding up order in respect of a company will not detract from the continuance of 138 proceedings under the NI Act. That's what the reference was in respect of, and that's what we decided.
I'll list it on Wednesday in the fresh matters list.
In the order passed by the coordinate bench of this honorable court, insofar as the company is concerned, there is a finding that 446 will apply, and on that ground,
it is set aside.
The order staying the earlier.
That is Justice Suresh Govindra
is restored.
No, that is your Lordship, Justice Natarajan.
Just Justice.
But I'm not agitating the matter qua the company at all. I'm only on the director.
You can't escape.
Your Lordship, he has not issued. He has not issued the check. He has not issued the check as a director. He has issued the check as a personal guarantor of the company.
On the merit of
the complaint is very clear, my lord.
Anyway, yes,
I will see that.
Wednesday.
Yes. 19th.
19th.
Great.
Yes. ಬೇಡ ನೆಕ್ಸ್ಟ್ ಅದು ಆ ಫೈಲಲ್ಲಿ ಒಂದು ಲಿಸ್ಟ್ ಆಫ್ ಅಥಾರಿಟೀಸ್ ಇದೆ ಅವ್ರು ಕೊಟ್ಟಿರೋದು ಚೇಂಬರ್ ಕಳಿಸಿ. ಎಸ್ ಗವರ್ಮೆಂಟ್ ನಿಮ್ದೆ 30 ಎಲ್ಲಿ ಅಡಿಷನಲ್ SPP 302ಗೆ ಬೇಕಾಗಿಲ್ಲ ಆರ್ಡರ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಅಂತ ಹೇಳಿದ್ರು.
ಎಸ್ಟರ್ಡೇ
ಏನಾಯ್ತು ಅಲ್ಲಿ?
ಇಲ್ಲ ಅಲ್ಲಿ ಇವಾಗ ನಾಳೆಗೆ ಹಾಕೊಂಡಿದ್ದಾರೆ. ಹಿ ಹ್ಯಾಡ್ ಮೇಡ್ ಎ ಸಬ್ಮಿಷನ್ ದಟ್ ಮೋಹನ್ ಚಂದ್ರ ಗೌಡ್ರ ಸಾಹೇಬ್ರದ್ದು ಒಂದಿದೆ ಅಂತ 2019 SCC ಆನ್ಲೈನ್, ಅದರಲ್ಲೂ ಅಲೋ ಮಾಡಿಲ್ಲ. ನಾನು ಕಾಪಿ ತಂದಿದ್ದೀನಿ. ದಟ್ಸ್ ವಾಟ್ ಹಿ ವಾಸ್ ರಿಲೈಯಿಂಗ್.
ಎಸ್ ವೆನ್ ಈಸ್ ಕಮಿಂಗ್? ಪಾಸ್ ಓವರ್ ಇಲ್ಲಾಂದ್ರೆ ಸಾಯಂಕಾಲ ಸ್ಟೇ ಮಾಡ್ತೀನಿ. ಎಸ್
Order 26.
Yes, in terms of memo, 27 in terms of memo, 28 in terms of memo. Post immediately after service of notice upon the second respondent. Intermod idya?
Respondent is dead.
State?
Second respondent is dead.
Dead.
Please.
Learned counsel for the petitioner submits that the second respondent complainant is no more. In that light, the state will have to defend the action, defend its action. List the matter for admission 2 weeks between date. Intermod idya?
There is an interim order.
Intermod subsisting shall continue till the next date of hearing. Idya ilva?
There is an interim order. Interim order was granted on 10/1/2022.
Yes. On the July second week, haki. 11th July. Yes, next. You are appearing for whom?
Number 30, I represent the petitioner. There are connected.
Furnishing of so and so, what is this?
My lord,
Again, what are all these matters?
138.
38.
Ah,
I appear for the respondents in 30.2, 30.3 and 30.4, my lords. We had
name is
filed,
not shown?
no, my name is
shown.
shown in the three matters, my lord. But we have not, there are no instructions, my lord. After filing of wakalat, there are no specific instructions. So we are filing the NOC, my lord. I mean, we are granting NOC and memo of
Granting NOC.
retirement, my lord. So we will seek further instructions.
Learned counsel for the respondent submits that he has no instructions from his client and he is wanting to issue a no objection to engage any other counsel. In that light, list the matter after 4 weeks, interim order granted.
One more
earlier
submission.
stand-
In 30.1 and 30.5.
Interim order granted earlier stands extended till the next date of hearing in those cases where interim order is subsisting. In the light of the interim order subsisting in the companion petitions, in cases where interim order is not granted, there shall be an interim order as is granted in the companion petition.
In all the cases, there is an interim order, but only thing is in respect to 30.1 and 30.5, notice was not ordered.
ಅಲ್ಲೂ ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಟು ದಿ
30.1 and 30.5.
ಇವ್ರು ಇದಾರಲ್ಲ ಅದಕ್ಕೆ
We are in 30.
ಅವ್ರೇನು ರಿಟೈರ್ ಆಗ್ತಾ ಇದೆ ಅಂತ
3 and 4, my lord.
ಎಸ್
ತಗೋತೀರಾ ನೀವು?
The respondent give it-
ಇದರಲ್ಲಿ ಏನೂ ಮಾಡಿ interim order subsisting in all these cases shall continue till the next date of hearing. ಯಾವ್ದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಅದ್ ನೋಡ್ಕೊಂಡು
ಎಲ್ಲದರಲ್ಲೂ ಇದೆ.
ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಟು ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್. ಎಸ್ ನೆಕ್ಸ್ಟ್. Post immediately after service notice upon the first respondent. Interim order if any shall continue till the next date of hearing. Next.
32.
On the previous date of hearing, my lords had directed me to serve it on the counsel for the appearing for the respondent before the trial court. They've refused service. I've taken process.
The learned counsel of the petitioner submits needful has been done, office to verify and post the matter. Interim order idea?
No, my lord.
Yes, so next.
My lord, kindly on the 24th if possible, my lord.
Step, in the event steps are taken, list the matter on
24th of this month.
24th. All right.
Grateful.
Yes, next. 24th in the fresh matters. 30?
Respondent number 2 in this case, ma'am.
33.
Third, I have filed the wakalat, madam.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರ ಫಾರ್ಮ್ಯಾಟ್ ಅಲ್ಲಿ ಇನ್ವಿಜುವಲ್ ಕೇಳಿ ಕೊಡ್ತಾರೆ ಫಾರ್ಮ್ಯಾಟ್.
Rest time.
ಲಿಬರ್ಟಿ ಟು ಚಾಲೆಂಜ್. ಎಸ್ ನೆಕ್ಸ್ಟ್.
Interim order.
ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ?
ಇದೆ.
ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಇದ್ರೆ ಬೇಡ ಒಂದ್ ನಿಮಿಷ.
Discharge application challenge ಮಾಡಿದ್ರು.
ಒಂದ್ ನಿಮಿಷ.
Discharge application reject ಆಗಿದೆ.
1 minute sir. ಎಂಟ್ರಿ ಮಾಡಿದೆ. ಚಾರ್ಜ್ ಶೀಟ್ ಆಲ್ರೆಡಿ ಹಾಕಿದ್ದಾರೆ.
ಹಾಕಿದ್ದಾರೆ.
ಮತ್ತೇನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಇದ್ದೀರಿ? CC 6293 of 2020 stayed. What instructions?
Challenging the order of discharge application.
All right, sir. Yes.
Rest time.
Fresh time, grants time. Yes. List the matter after 2 weeks at the request of the learned counsel appearing for the respondent. Interim order subsisting shall continue till the next date of hearing. Next.
34.
This matter I undertake to file wakalat, my lord.
Learned counsel so and so undertakes to enter appearance for the respondent, registry to print the name of so and so is appearing for the respondent. List the matter after. Then interim order ಇದೆಯಾ?
Interim order. ಅದರಲ್ಲಿ 138 proceedings. So recalling DW1 application has been rejected.
311 ನಾ?
311. ಅದರಲ್ಲಿ ಏನಾಗಿದೆ?
List the matter.
5 times they filed the application.
Minutes, sir. List the matter on Friday next 21st.
Please.
Yes.
Interim order too.
Interim order subsisting shall continue to the next date of hearing.
Much okay.
2 weeks to come.
For the petitioner, my lord,
Ah.
may I request a week's time to comply with your.
A week's time is granted to comply with the office objection.
Great.
Same order. Yes, Suyog. ಇದಕ್ಕೆ ಇಲ್ಲಿ ಬಂತು ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೆ ಅಲ್ಲ?
Not to precipitate ಅಂತ ಮಾಡಿ. Not they supposed to file objections, all these, my lord, the time they took time only to file objection.
This, you are dragged from Mumbai to here, other.
Yes, my lord.
153A.
But they have not filed objection, my lord. So at least 5-6 times they sought time.
Yes, sir. AG. Pass over. AG ne appear agide. Avat. Next week, then we will stay it. There is no stay.
No stay, there is
Precipitate.
stay.
Such orders are not correct.
Sought for entry, my lord, stay, my lord, because after this, my lord, they issued notice to my wife, petitioner's wife.
Why?
Saying the SIM used to in the mobile is belonging to wife.
Yaru, mobile is in wife's name, is it?
How the petitioner ಹೆಂಡತಿ ಅಲ್ಲ ಮೊಬೈಲ್ ಇರಲಿಲ್ಲ ಓನ್ಲಿ ಸಿಮ್ ವಾಸ್ ಇನ್ ಹರ್ ನೇಮ್ ಅಂತೆ ಅದರಿಂದ ಯೂಸ್
ಅದೆಲ್ಲ ಮಾಡ್ತೀರಾ?
ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಅದಕ್ಕೆ ದಟ್ ಇಸ್ ವೈ ಮೈ ಲಾರ್ಡ್ sought for entry model. They are troubling their family.
Heard the learned senior counsel Arun Sham appearing for the petitioner. And yes, stay. I am extending the interim order by qualifying it that it is stayed. Yes. ಅವತ್ತೆ ಕೊಡ್ತಾ ಇದ್ದೆ. On heard so. This court on 30th May 2024 had passed the following order. The court was following the judgments of the apex court in the case of DN. So and so. It becomes apposite, albeit prima facie, to refer to the judgment of the apex court in the case of Shiva Prasad so and so 2024 SCC online SC page 322, which also dealt with the offense under section 153A of the IPC and its ingredients to be met for a crime to be registered. Prima facie, as found in the order dated 30/5/2024, it would not meet what the apex court has directed. Therefore, further proceedings till the submissions or objections are filed by the state shall remain stayed. Tell judgment.
Compilation has been filed.
Huh?
Compilation has been filed.
ಇದೆಯಾ compilation ಅಲ್ಲಿ?
ಹೌದು.
ಈಗ ನಾನು ಹೇಳಿದ್ದು.
ಯಾವಿದಿದೆ? ಮಾನಿಕ್ ತನೇಜಾ, ಬಿಲಾಲ್ ಅಹಮದ್, ಮಕ್ಕಿ.
Update your compilation.
Please not will be published.
My serial number 36, my lord. Objection is cleared, my lord. Serial number 36.
ಆಗೋಯ್ತಲ್ಲ ಅದು. ನೀವೆಲ್ಲಿದ್ರಿ?
ಸ್ವಾಮಿ ಅದು ಫಾಲೋ ಆಗಲಿ.
ಅದರಲ್ಲಿ learned counsel for the 36 ಅಲ್ಲಿ petitioner submits office objections have been complied with, office to verify, and in the event they stand complied, list on 18th in the fresh matters list. Next.
My lord, already is complaint ಆಗಿದೆ ಸ್ವಾಮಿ ಅದು. ಆಲ್ರೆಡಿ ನಾನು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ ಅದು.
ಅದನ್ನೇ ಹೇಳಿದ್ದಮ್ಮ. 18th ಬರ್ಲಿ. Yes. Next.
38. Lords, Passover, Lord, senior counsel's at.
Passover, why?
Lord, senior counsel's appearing in this matter. He's on his legs in.
All right, why interlocutory ಬಂದಿದೆ?
2:30, your lords.
Wait, madam, what is the matter? No, it's first time coming, is it?
Yes, your lords.
ಯಾಕೆ ಇದಕ್ಕೆ ಹಾಕ್ತಾರೆ ಮಾಡಿ? List tomorrow in the fresh matters list. Yes, next.
39.
Madam, first time matters, dispensation ಇದ್ರೂನು first fresh matters ಹಾಕಿ. Yes, Prasanna Kumar. ನೋಡಿದ್ರಾ?
ನೋಡ್ದೆ.
Some mistake. ಅದು ಎರಡರಲ್ಲಿಲ್ಲ, ಒಂದರಲ್ಲಿ 207 was also a ground in one of the petitions. ಅದರದ್ದು ಇದೆ. Should we recall and hear or correct it?
ಕರೆಕ್ಟ್ ಮಾಡ್ಬೇಕು, ಯಾಕೆ ಅಂತಂದ್ರೆ.
We'll correct it.
ಅಷ್ಟೇ.
Recall ಮಾಡ್ಬೇಕಾ?
Recall lordship because.
No, it cannot be done. No,
Because now lordship will require they restore the writ petition. It will go to division bench for consideration.
Go before division bench.
Yes, why? Because see challenge several petitions where NIA Cognizance order will check will challenge. It has referred subsequently.
No, then that would not be correct. I've already passed an order.
Then lordship maybe.
I'll recall and hear it. That's not
Can you permit
but
me
not
for a minute?
division bench.
Rashmi, can you permit me for a minute about maintainability of this review petition? It is a petition under 482 CRPC.
No, that's all right. I'm not on that. If there is straight away an error.
ಅದು ಮಾಡ್ಬೋದು, corrections ಏನಾದ್ರು ಇದ್ರೆ ಮಾಡ್ಬೋದು. Not that recalling the whole thing and
But
then
if
again
we order
creating
then
one answer.
fresh hearing, maybe posted for fresh hearing of the writ petition. Lordship, I'll convince, after that Lordship can pass it, is an order.
But there is absolutely no.
And Lordship, there is also some several aspects which in the charge sheets, which I found little later, realized
That
it.
cannot be a ground.
No, that I will, Lordship,
That cannot
because
be a ground
Lordship,
for
kindly
review.
appreciate, we are challenging the charge sheet. I am not in the reviewer. See, what in the charge sheet itself, I'll point it out. Which I will, the charge sheet itself, I'll point it out. I will not even going to produce one document or another document.
That is not
In the
permissible
charge
in
sheet
review.
itself.
All that I can say, that is not permissible in
Review
review.
cannot be a rehearing.
Rehearing.
Only the correction of the error that is there. We will
In
do it.
review, if Lordship is restoring, then only I will produce it. In
That
respect
is
of review,
that
I
we
will
see.
satisfy this court. Okay, this is
That
proper case to review the matter. Lordship.
Let's see. All the three matters, I'll pass orders on Friday. Whether it's to be recalled and restored or what is to be done. If it is restored, then I'll hear you. Yes.
It cannot be restored on the ground that the advocate has now become wiser than.
Yeah, no, that is not there. I will not permit him to make any other submission.
No, in
by-
review, I will not make a submission.
Yes.
In the event of restore, I will just point,
We'll
take
see.
this honorable court to the charge sheet,
We'll see.
content of the charge sheet.
On Friday, I'll pass orders.
Please.
List the matter on Friday at 4 PM. Yes, next.
They from
ನಾಲ್ಕು
past-
ಇದೆ?
This all four
All
reviews
four,
are
is
there.
it?
All.
ಆಯ್ತು.
Common order was passed. Lordship, they are from past 4 years, they are in judicial custody because
Bail
of-
ಕೇಳಿ.
Apply for bail, why?
Lordship,
Bail
I will-
Bail is not granted.
bail is not granted. The reason my learned friend may say after that, but in the clock of national security, NIA has fabricated the evidences. That I have to point it out. That's
ನಮ್ಗೆ
it.
NIA ಮಾಡೋ ಕೆಲಸ ಇಲ್ಲ.
That is they only that do only. They do only in all this.
Let him not make, not this
They very
kind of general
subjective
submission.
investigation
right.
they do.
Let him not make.
No, why
this
have you
kind of
not
general
applied for bail?
No, he has gone up to Supreme Court.
Lordship, that my learned friend may say all that, but these aspects have never been considered. Only whatever my learned friend has provided, that has been considered or bail was rejected.
All right. Yes. Friday.
Public.
ಸೀನಿಯರ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಒಂದು ಲೈಫ್ ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಹೆಲ್ಡ್ ಅಪ್ ಆಗಿದ್ದಾರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್
Made a short accommodation. He is already a convicted accused, my lord, in for the offense 302. But matter may be taken up.
20, we'll take it on 2nd July.
Please, ma'am.
Yes, list on 2nd July. Entry order ಇಲ್ಲಲ್ಲ?
ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ ಇಲ್ಲ ಮಂತ್ ಎಂಡ್ ಅಲ್ಲಿ ಸೀಸನ್
2nd July, yes.
16 years
22 ಇಂದ ಪೆಂಡಿಂಗ್ ಇದೆ? Yes.
ಅಲ್ಲ ನೋಟಿಸ್ 3 ಸಲ ಹೋಗಿ ಬಂದಿದೆ
ನೋಟಿಸ್ ಹೋಗಿಲ್ವಾ?
ನೋಟಿಸ್ ಹೋಗಿ ಬಂದಿದೆ 3 ಸಲ
ಅದು
ಅದಕ್ಕೆ
ಆಗಿದೆ, ಎಲ್ಲ ಆಗಿದೆ. Yes. ಸೆಟಲ್ಮೆಂಟ್ ಅಂದಿದೆ? ಸೆಟಲ್ಮೆಂಟ್ Yes. Offense 406, 420.
Yes, Swami, 406, 420.
Heard the learned senior counsel. So and so. The petitioners are before this court calling in question. I'll prayer already and hakpudi adna. During the pendency of the petition, the parties to the list have settled the dispute amongst themselves by drawing up certain terms of settlement. The compounding hakbek yaru settlement hakirodu?
T20 ಅಲ್ಲಿ ಅದು ಏನಾಗಿದೆ
ಏನಾಗಿದೆ?
ಡೈರೆಕ್ಟರ್ಗಳು ಎಲ್ಲೆಲ್ಲೋ ಇದ್ದಾರೆ
ಅಲ್ಲ ಬಟ್ ಏನಾರು ಹಾಕ್ಬೇಕಲ್ಲ, ಹಿಂಗಂಗಾಗತ್ತೆ.
ನಾನು ಇದರಲ್ಲಿ ಕ್ಲೋಸ್ ಮಾಡ್ಕೊಳ್ಳೋಣ ಅಂತ ಹೇಳಿ ಉದ್ದೇಶದಿಂದ ಹೇಳಿದೆ ಅದಕ್ಕಾಗಿ ಡಿಲೇ
I should compound the offense, not compromise the offense.
ಇಲ್ಲ ಮೇಡಮ್ ವಿತ್ ಮೆಮೋ ಮೇ ಬಿ ಪರ್ಮಿಟೆಡ್ ಟು ವಿಡ್ರಾ ಅಂತ ಹೇಳಿ ಅವರು ಹೇಳ್ತಿದೆ.
ಎಲ್ಲಿದೆ?
ಅಲ್ಲ ಇದನ್ನ ಈ ಮೆಮೊದಲ್ಲಿ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡು ಬಣ್ಣ ಅಂತ ಕೇಸನ್ನು ಇಸ್ ಎ ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಲಾಜಿದ ಮೇಲೆ
At least an affidavit of the petitioner should be there. Memo ಏನಾಗಲ್ಲ.
ಅದ್ರಲ್ಲಿ ಇದು ಹೀಗಾಗಿದೆ.
ಹೆಂಗಾರೋ ಆಗಿರ್ಲಿ. File an affidavit. File an affidavit of the complainant. What is the settlement? 60 ಲಕ್ಷ ಕೊಟ್ಟಾಗಿದ್ಯಾ?
Yes, my lord.
ಮತ್ತೆ ಬೇರೆ 4 ಕೇಸ್ಗಳಿದೆ ಅದು ಎಲ್ಲ ಸೇರಿ ಕ್ಲೋಸ್ ಮಾಡ್ಕೊಂಡು
ಎಲ್ಲ ಸೇರಿ ಕ್ಲೋಸ್ ಮಾಡಕ್ಕೆ ಎಲ್ಲ ಸೇರಿ ಒಂದು affidavit ಹಾಕಿ. Yes. ನಾಳೆ ಹಾಕ್ಲಾ? Tomorrow. Yes.
230 ತಗೊಳ್ಬೋದು ಇದ್ದಾರಂತೆ ಇಲ್ಲೇ ಮಾಡ್ಬಿಟ್ಟು
ಆಯ್ತು ಸರ್. I'll take it at 4 o'clock. Pass over. Next. Pass over.
Petition 42.1 and 2, yeah,
ಏನು?
permission motion, waste time motion.
Race time? Why?
Next week,
23 da?
next week.
KPID,
KPI but side. Entry mod is there,
final chance.
please.
Lest this matter on 3rd July as a last chance, it is made clear no further adjournment would be granted in the matter.
Please,
Entry matter subsisting shall continue till the next date of hearing.
please, please.
Next.
I appear for the second respondent. While the charge sheet against the remaining accused, some materials are there to be canvassed. There is a stay as far as the petitioners are concerned.
4 and 9 there is stay.
4 and 9.
Remaining accused ಇರ್ಲಿ.
Charge sheet has been.
ಇವ್ರ
filed.
ಮೇಲೆ ಏನ್ ಹಾಕಿಲ್ಲಲ್ಲ?
My lord,
No charge sheet against these.
can't because of its stay.
I know.
But some materials I'll have to point out.
No, 498A.
490. She is related as well as in relationship with the first accused.
Who?
For first petitioner.
First petitioner,
She herself has said in her petition that she is a distant relative.
distant relative.
Distant relative.
Distant.
Her relationship is mentioned by the complainant and
Then what is
in-laws of the petitioner.
second petitioner, accused number 5? 9.
9.
Who is
She
she?
is her mother.
Who's her mother?
Her mother. Her mother.
Oh, mother of accused number 4.
Yes, ma'am.
Mother of accused number.
Offense is 498A.
498 and various other offenses.
Various other yaws. Yes.
307,
Come on.
498A, 307 and
Charge sheet is filed, not filed. Sir. Against others it is filed.
yes, ma'am.
Come on, merits, yes.
My lord, page 30, my lord. Here the second para speaks about the present petitioners, my lord.
ಮದುವೆ ಮುಂಚೆ
ಮದುವೆಯ ಮುಂಚೆ ಮತ್ತು ಮದುವೆಯ ನಂತರವೂ ಸಹ ಅವರ ಸಂಬಂಧಿ ಎಂದು ಹೇಳಿಕೊಳ್ಳುತ್ತಿದ್ದ ಚೆನ್ನೈನ ಸೋಯನ್ಸೋ ನಿವಾಸಿ ಶ್ರೀಮತಿ ನಂದಿನಿ ಅವರೊಂದಿಗೆ ಮತ್ತು ಅವರ ಕುಟುಂಬದವರೊಂದಿಗೆ ತುಂಬಾ ಅನ್ಯೋನ್ಯವಾಗಿದ್ದು ಮತ್ತು ತುಂಬಾ ಹತ್ತಿರವಿದ್ದಂತೆ ವರ್ತಿಸುವುದು, ದೂರವಾಣಿ ಕರೆಗಳನ್ನು ಮಾಡುವುದು, ಓಡಾಡುವುದನ್ನು ನಾನು ಸೂಕ್ಷ್ಮವಾಗಿ ಗಮನಿಸಿ ಅನುಮಾನಗೊಂಡು ನಾನು ಅವರ ಬಗ್ಗೆ ವಿಚಾರಿಸಲಾಗಿ ನಮ್ಮ ಸಂಬಂಧಿಕರಿಂದ ತಿಳಿದಿದ್ದೇನೆಂದರೆ ಶ್ರೀಮತಿ ನಂದಿನಿಗೆ ಮದುವೆಯಾಗಿದ್ದು ಆಕೆಯ ಗಂಡ ಸುಮಾರು ದಿನಗಳಿಂದ ಕೆನಡಾದಲ್ಲಿ ಇದ್ದಾನೆ. ಅವರಿಬ್ಬರು ಬೇರೆಯಾಗಿದ್ದಾರೆ ಮತ್ತು ಗಣೇಶ್ ನಂದಿನಿ ಗೌಪ್ಯವಾಗಿ ಮದುವೆಯಾಗಿದ್ದು ಸಂಸಾರ ಸಹ ಮಾಡುತ್ತಿದ್ದು ನಮ್ಮ ಮದುವೆಗೆ 1 ದಿನದ ಮೊದಲು ನಂದಿನಿಗೆ ಮಗುವಾಗಿದ್ದು ಅದರ ತಂದೆ ಗಣೇಶ್ ರವರೇ ಆಗಿರುತ್ತಾರೆಂದು ತಿಳಿದಾಗ ನನಗೆ ದಿಕ್ಕು ತೋಚದಂತಾಗಿ ಈ ವಿಷಯದ ಬಗ್ಗೆ ಮೊದಲು ನಮ್ಮ ಅತ್ತೆ ಮತ್ತು ನಮ್ಮ ಗಂಡನನ್ನು ವಿಚಾರಿಸಲಾಗಿ ನನ್ನ ಗಂಡ ಅತ್ತೆ ಮೈದುನ 3 ಜನ ನನ್ನನ್ನು ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ ನಿಂದಿಸಿ ಇದೆಲ್ಲ ಸುಳ್ಳು ಎಂದು ಹೇಳಿರುತ್ತಾರೆ. ಮತ್ತು ನಾನು ನಂದಿನಿಯವರ ಅತ್ತೆಯವರ ಬಳಿ ವಿಚಾರಿಸಲಾಗಿ ಅವರು ನಂದಿನಿ ಮತ್ತು ಗಣೇಶ್ ಅವರ ಸಂಬಂಧದ ಬಗ್ಗೆ ತಮ್ಮ ಅಳಲನ್ನು ತೋಡಿಕೊಂಡಿರುತ್ತಾರೆ ಮತ್ತು ಅವರ ಮಗನಿಂದ ನಂದಿನಿಗೆ ವಿಚ್ಛೇದನೆಯನ್ನು ಸಹ ನೀಡಲು ಮುಂದಾಗಿರುವ ಬಗ್ಗೆ ತಿಳಿಸಿರುತ್ತಾರೆ. Even this allegation is considered to be true, my lord. ಮದುವೆ ತುಂಬಾ ಮುಂಚೆನೇ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ my lord. I have also produced the birth certificate of the said child, my lord.
Page
36, my lord. It clearly shows who is father of that baby. It is not the accused number 1. 498 the ingredients ಏನು ನಮ್ಮಲ್ಲಿ ಇಲ್ಲ.
Yes, sir.
My lord, she is the abettor for commission of these offences.
Yes, sir.
Because she has been sending messages. That message is also produced along with the charge sheet. One of the messages. And photographs are produced. Page 90.
90.
91.
90 and 91, 93. Because of the relationship, she has been compelling him to get divorced from this girl. And statement of witnesses is that A1 did not want to leave his relationship with this petitioner.
You catch hold of A1.
My lord?
Punish A1.
No, A1 punishment correct.
498, how can it get
So-
attracted?
Bro, 498.
At best, she is a paramour. And her mother, what did her mother do?
No, mother's case, I don't say anything.
ಎರಡು ಇಲ್ಲ.
32 says
No,
two lines about
this.
Page 32 speaks about her mother, my lord. Just 2 lines.
No, it is not just 498.
Senior counsel is not saying anything about it.
Various other offences. Various other offences in respect of which a complaint is raised. Assault, brutally assault, attempt to murder.
Not,
etc.
that is by others.
By others.
Well, let to carry on with others.
Others charge sheet
Other
is-
charge sheet ಆಗಿದೆ ಕಂಟಿನ್ಯೂ ಆಗ್ಲಿ. ಇವ್ರೇನ್ ಮಾಡ್ತಾರೆ? ಸುಮ್ಮನೆ ಕ್ರಿಮಿನಲ್ ಟ್ರಯಲ್ ಏನೆ. For the satisfaction of the complainant that she has taught a lesson to paramour. ಅಷ್ಟು ಬಿಟ್ಟು ಏನೂ ಇಲ್ಲ. ಅದು ತಮಗೂ ಗೊತ್ತು. Yes. We close it?
Yes.
Yes, sir. The petitioners accused number 4 and 9 are before this court calling in question registration of a crime in crime number 163 of 2022 registered for the following offences at page 6 alidema. Facts adumbrated are as follows. The accused number 1 gets married to the complainant on ಅದೇ ಹೇಳಲ್ಲ. Accused number 1 and the complainant are husband and wife. It transpires that the marriage takes place on 7/2/2022. Soon after the marriage, it further transpires that the relationship between the husband accused number 1 and the complainant flounders. On such floundering of the relationship, the impugned crime comes to be registered in crime number 163 of 2022 for the aforesaid offences. While accused 1 to 3 and 5 to 8 are all members of the family or the mother-in-law, father-in-law, as the case would be, these petitioners are arrayed as accused number 4 and accused number 9. The relationship between the first petitioner, accused number 4, even according to the complaint, is she is a paramour of the husband, accused number 1. And the second petitioner, accused number 9, is the mother of accused number 4, the first petitioner. This court, in terms of its order dated so and so, has protected the further investigation against these petitioners, and the said interim order is subsisting even as on date. The learned counsel for the petitioner taking this court through the documents appended to the petition with particular reference to the complaint would seek to demonstrate that there is not even sprinkling references to these petitioners which would touch upon the ingredients of any of the offenses so alleged against the petitioners. It is a submission that without any rhyme or reason, these petitioners are drawn into the web of the investigation in crime number 163 of 2022. Per contra, the learned senior counsel Tommy Sebastian, appearing for the complainant, would seek to refute the submissions, contending that the police after investigation have filed a charge sheet against all the other accused. The offenses are grave. What is found in the summary of the charge sheet would clearly indicate that the first petitioner is responsible for all the happenings in the life of the accused number 1 or the family members. While insofar as the mother of the first petitioner is concerned, the learned senior counsel would accept that there is no offense that can touch upon the ingredients of any of the offenses. There is no allegation that can touch upon any of the offenses so alleged. I have given my source at Barkolele. Actions. So the entire issue, the afore narrated facts are not in dispute. The link and the dates and events are all a matter of record. Since the entire issue has now sprung from the complaint, I deem it appropriate to notice the complaint, not in its entirety, but insofar as it is germane to the list. The references made to these petitioners in the complaint reads as follows. Page 30 to 31, marked portion. A perusal at the said reference would indicate an affair between the accused number 1 and the first petitioner. Therefore, it cannot but be said in the least that the first petitioner was a paramour. It is settled principle of law that a paramour or concubine of an accused cannot be dragged into the proceedings under section 498A of the IPC, as the said accused would not become a relative or a member of the family as is necessary under section 498A of the IPC. Thus tumbles down the offense under section 498A, qua the first petitioner. There are other offenses also alleged. If the other offenses alleged are pitted against what is narrated in the complaint, none of the ingredients of any of the offenses can be found against the first petitioner, accused number 4, as accused number 4. As the other offenses are the ones punishable under 323, 324, 307, 420, 504, or 506 of the IPC. There is not even a titter, titter of foundation laid in the complaint, qua those offenses against the first petitioner. The offenses against the first petitioner are therefore loosely laid. The second petitioner, the mother of the first petitioner, is on the face of it unnecessarily dragged into these proceedings, as not even a sentence of semblance of the ingredients being present on the qua the offenses so alleged. Therefore, if further proceedings are permitted to continue, it would become an abuse of the process of the law. The learned senior counsel has placed the entire charge sheet filed against other accused in the crime. The findings rendered herein would not in any way influence or bind any of the trial against any of the accused in the said proceeding, leaving open all the remedy, that is a remedy to the prosecution for any future inclusion of the petitioner, first petitioner only, as an accused. The petition, I deem it appropriate to pass the following order. The so-and-so stands quashed to the petitioners. Yes.
Grateful, ma'am.
In case evidence is found, 319 can always be invoked. Next. Idu Madam Arun Shan. Sir.
Petition, my lord. Serial number 92, my lord. There is another matter that is listed on 14th, my lord, day after tomorrow. This may be taken up on.
Wait, page wise correct.
Page 7, 44, 47, page 8, 48 to 52. Page 9.
Serial number 49, I represent respondent. I need to file detailed objection to the petition.
Interim order ilva? Interim order ilva?
They have filed the
49.
Yes, sir. 2 weeks maybe time may be granted to file objection.
1 minute. 49 al interim order ilva?
One criminal petition 221/23, that is mine petition.
3002 al ilva? Adrallu idya? Adrallu idya? When do you want, sir?
I need 2 weeks time to file objection, your lordship, because they totally 10
Because you've engaged senior counsel, his objections should be denied, is it?
Because both the parties are advocate and there is constitutional, I challenge the constitutionality of.
They are not the wife collection. Claim
Objection
file. Objection hakli. Respond madilva avarna. I will vacate the interim order now. Yes. The learned counsel appearing for the respondent Ganesh K. seeks 2 weeks' time to file statement of objections. Objections, if any, by the next date, list the matter on 27th. In the event 26th, in the event objections are not filed by then, it would be construed that there are no objections to be filed and the matter would be taken up on its merit. Interim order subsisting shall continue till the next date of hearing.
Please.
Yes.
Page 10.
55, 55, 55.1, my lord, my name has not been showed. I have filed wakalat.
Learned counsel so and so submits that his entered appearance for the petitioner registry to delete the name of Naveed Ahmad and print the
I am for respondent.
respondent.
Yes.
Registry to print the name of so and so is appearing for the second respondent complainant in both these cases. Yes, next.
No,
Page 10.
55.1 ಅಲ್ಲಿ ನನ್ನ ಹೆಸರು ತೋರಿಸಿಲ್ಲ.
ಅದನ್ನೇ ಹೇಳಿದ್ದು.
Please.
Page 10, 62 to 68.
59, my lord.
ಅಲ್ಲ 56, 55 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks. Yes, next.
59, my lord. 59, my lord. Entry model.
ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
Lord, serial number.
My lord. Day after tomorrow, reporting settlement.
Settlement. Learned counsel submits that parties would report settlement, list the matter on Friday at 2:30 PM.
My lord, serial number 62. I appear for the petitioner. Request an adjournment, my lord.
Wait.
Page 10, 62 to 68.
62, my lord. I appear for the petitioner. I request a
2
short.
weeks at the request of the learned counsel appearing for the petitioner. Next.
Yes,
My lord, today I had moved 3 memos and your lordship was pleased to direct the registry to list all the matters on Friday. But they are.
ಈ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆಯಾ ನಿಮ್ದು?
ಅಲ್ಲ.
Wait, submit ಮಾಡ್ಬೇಕಾದ್ರೆ wait.
Yes, my lord.
My
Don't
lord,
barge in. Yes.
76.
Hmm.
Your lordship.
62 interim order.
69 to?
Your lordship, serial number 75, your lordship. It
Yes.
may kindly be had on Tuesday, your lordship.
List after 2 weeks. Yes, interim order ಇದೆಯಾ? ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ. Yes, next.
Serial number 76.
77 to 84.
Yes.
Page 13, 5 to 93.
92, my lord. May be taken up on day after tomorrow, my lord, because the other matter is also there.
Now the other matter is also there ಅಂದ್ರೆ?
My lord, the section 500, my lord, the defamation case.
ಅದು
42,
Friday
41,
ಹಾಕಿಲ್ವಾ?
42, 41.
Friday ಇದೆಯಾ ಅದು?
Day after tomorrow, yes, my lord.
Tag number ಕೊಡಿ.
42, 41 of
Tag the
24,
petition along with
my
so
lord.
and so and list on Friday. Next, yes.
42, 41.
Page 40,
Hmm.
84 to 103.
103 ಇಂದ ಕರಿಬೇಡಿ. ಮಧ್ಯಾಹ್ನ ಬಂದ ತಕ್ಷಣ ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್ ತಗೊಂಡು ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ವಿಲ್ ಮೂವ್. ಎಸ್, ಈಗ ಹೇಳಿ.
Yes, my lord. Today I had moved 3 memos, one matter pertaining to Dharwad bench
All
and
right.
another to this principal bench.
All right.
And your lordship was pleased to list all the matters on Friday.
ಸರಿ.
But the concerned branches are telling no, only we are, your lordship has directed to list them, the matter pertaining to Dharwad bench only.
ಬರುತ್ತೆ.
Kindly they may be directed to
It
list.
will come. Yes.
Yes, my lord. Much obliged. ಬಂದೆ ಮೇಡಮ್ ಗೀತ್ ಅವ್ರ ಹೆಸರು ಗೀತಾ ಮೇಡಮ್ ಜಿ
File ಅಂತೂ ಹೋಯ್ತು. File ಅಂತೂ ಹೋಯ್ತು. ಗೊತ್ತಾಗುತ್ತಲ್ಲ everyday 1:30 adjournments.
ಮೇಡಮ್ 2:30 ಒಂದು ಅಡ್ವಾನ್ಸ್ ಆಯಿತು 7970. 2:30 for the hearing of settlement. ಅವ್ರು ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ಮೇಡಮ್, ಇಲ್ಲ ಅಂದ್ರೆ ಫಾರ್ ದ ಹಿಯರಿಂಗ್ ಕರೆಕ್ಟ್.
Not 5, 105, reporting settlement, 05, 106.
Kindly pass. ಏನು offense? 354. ಆಯ್ತು.
11.
ಸೆಟಲ್ಮೆಂಟ್ ಇದೆ 11. 7 ಹಂಗೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. 107.
107.
Yes, this, where is the age? Pratima Honnapura, madam. She is appearing in this case. Ask her to be present in this. What is the development? We don't know. Yes, continue. Nobody is here. ಆಯ್ತು, ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಆಮೇಲೆ ಮಾಡಿ 109.
109. 110.
230 ತಗೊಂತೀನಿ ಅಂತ ಹೇಳಿದ್ದೆ ನಾನು. Yes, okay, continue the list.
Continue. 44.
Yes.
Section 45 is sought for, not for the check which is in question in 138, my lord. It is for some other check which they got marked. Exhibit D1, where they state that he has not encashed money through that check. Anta. It has no relevance.
Court has allowed it.
Court has allowed.
So what?
But
How is that
the
relevant?
thing is, my lord, he signs differently in different places. If your lordship feels that it has to be referred for 445, 45 Evidence Act, then his charge signed and then bail bond and exhibit P1 also may be referred.
Can I examine here?
No, sir.
It has to be sent.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಅವ್ರು ಕೇಳಿರೋದು ಈಗ ಹಾಕಿರೋ exhibit D1 ಅನ್ನು ಕೇಳಿರೋದು.
ಈಗ come to the
D1 has no relevance.
come to the impugned order.
Kindly come to page number 36, my lord, of the objection filed. 36, ಒಂದು ಸಲ.
Come to the impugned order. Page 6, 14, 13 and 14.
Yes. Order is at 15, my lord. Application filed by accused under section 45 Indian Evidence Act is hereby allowed. Exhibit P1 and exhibit D8 were liable to be sent for FSL. Exhibit P8 ಅಲ್ಲಿ ನಾನ್ ಸೈನ್ ಮಾಡಿದ್ದಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು, but his signature looks similar. ಅದರಿಂದ
Should I look into it?
I'll know, lord, I am praying for sending another 2 documents along with that. ಅಷ್ಟೇ. Just
Well, where is your application? Where is your application to send 2 more documents?
No, I have not filed any application, lord.
Then we will allow this, let it go.
This has no relevance. He signs it differently in different places. May I take your lordship to page
Madam,
number?
that is the defense that you have or the allegation that he has.
But
Or allegation you have and the defense he has.
All right, my lord, his evidence itself is there. Page 36 of their objection.
Now, what prejudice is going to ensue if this is sent to an handwriting
Because
expert?
he signs differently in different places. He has signed differently, my lord.
That is not a plausible reply.
That is not the signature taken before the court. It is not admitted signature. ಯಾರೋ ಹಾಕಿದಾರಂತ ಹೇಳುದು.
Yes, sir.
How is it relevant, my lord?
My lord,
My
two-
case.
The 2 checks, one is exhibit P1
And D8.
and D8, wherein he says by D8, 9 lakhs is paid. And he says, I have signed that check. And the defense is, my lord, the earliest point I have stated, that this check, my lord, D8, which is paid, he has himself gone and withdrawn and signed because it's an uncrossed open check. Therefore, immediately filed application for CCTV footages to examine the bank manager, and they have objected. CCTV should not be given. And the complainant is my lord.
Yes, Heli.
The complainant, he states he is the power of attorney holder who is himself a practicing advocate, filed several check cases which has come in the evidence, and there is a dispute between us. He has taken the blank checks and he has signed and forged is the contention, my lords. We have taken up that content at the earliest point of time, lodged the complaint, etc. Therefore, to prove our
Anything
defense
else,
is
madam?
Page number 36, my lord,
Yes.
please.
All right.
Exhibit P1 ಚೆಕ್ ನಿಶಾನೆ P1 ಚೆಕ್ ಅನ್ನು ನಾನು 2010ರಲ್ಲಿ 10,000 ಸಾಲ ಪಡೆದ ಸಂದರ್ಭದಲ್ಲಿ ಕೊಟ್ಟಿದೆ. So exhibit P1 is admitted. Another page, my lord, 38.
Exhibit D8 ಎಲ್ಲಿದೆ?
D8 is a check.
Page 27 in the, if they have not produced it, in
I
the
have
statement of
produced,
objections,
I have
page
produced.
27.
Exhibit D1 is produced.
27, open check. They say it's the name of the accused, at the back, his signature is found. At the back, which say he has encashed by signing at the back.
Bearer check, anybody who
this
signs
is the
will
content.
withdraw the money. With Aadhaar card ತಕೊಂಡ್ ಬಿಡ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. Aadhaar card P38, page number 38 of their objection, my lord.
38.
ಹೌದು, page number 36 ಆಯ್ತು, where he has admitted. Exhibit P1. 38 ಅಲ್ಲಿ last third line, my lord. ನಿಶಾನೆ P1 ಚೆಕ್ ನಲ್ಲಿ ಇರುವುದು ನನ್ನ ಸಹಿ. ಒಂದರಲ್ಲಿ ಚೆಕ್ ನಲ್ಲಿ ಸಹಿ ನನ್ನದು. So exhibit P1 check is admitted, check signature is admitted. Then where is the relevance of exhibit P8, my lord? D8, I'm sorry, D8, my lord.
Disputed.
D8 is the check I had given him for 9 lakhs and he has withdrawn it, signing behind it.
Now, exhibit P1 is admitted.
My lords, now to compare with the P1, P8, D8 is not our signature. Yes, D8 is not our signature.
Yes. Anything else?
So, my lord, it is not that he himself has gone and withdrawn. We don't know. We have given the check for 9 lakhs. He has withdrawn. And exhibit P1 is there.
Anything else?
No, my lord.
Dismissed.
If
Next.
Kalyani Bhaskar, my lord permits him. Trial principles. You can come.
Yes, next.
ಏನದು?
Dismissed. Yes.
Great.
Copy.
45.
ನೀವಿದ್ದೀರಾ?
25.
ಯಾಕೆ 4 to yes sir 45 sir.
45 last time my lord dictated judgment my lord. Last time he was
not there.
Not there. Today is also not there.
This court on 23/11/2023 had passed the following order. On 6/6/2024, the following order. Even today, there is no representation on behalf of the respondent complainant, though he is represented by a counsel. In that light, the petition stands disposed in terms of the order dated 6/6/2024. Same order with 5/6. Next. ಅವತ್ತು ಡಿಸ್ಪೋಸಲ್ ತೋರಿಸಿದ್ದೀರಾ? ಅಲೋನ್ ಆಗಿತ್ತು ಗೊತ್ತು. ಮತ್ತೆ ಇವಾಗ ಡಿಸ್ಪೋಸಲ್. ಮೇಡಮ್ 5/6ಗೆ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ದೆ, ಅದನ್ನು ಡಿಸ್ಪೋಸ್ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ಡೇ ಅವರು ಬಂದಿರಲಿಲ್ಲ ಅಂತ ಗೊತ್ತಾಗಿ ರೀಕಾಲ್ ಮಾಡಿದ್ದೆ. ಇವತ್ತು ಅವ್ರು ಬಂದಿಲ್ಲ ಅಂತ ಪ್ರೀವಿಯಸ್ 5th ಏನಾಗಿತ್ತು ಸೇಮ್ ಆರ್ಡರ್, ಯಾರಿಗಾಗಿತ್ತು ಗೊತ್ತಿಲ್ಲ, ಅದು ಸೇಮ್ ಆರ್ಡರ್ ರಿಪೀಟ್ ಮಾಡಿ.
Petitioners before the
Respondent.
served, my lords, they have filed application for
ಇಲ್ಲ,
vacating.
advocate is there.
Yes, my lords, they have filed application.
ಏನ್ ಫೈಲ್ಡ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದಾರಾ?
They have filed objection and also the application for vacating stay, my lords.
Both. Heard the learned counsel, Srimati Sridevi Bhosle appearing for the petitioner. There is no representation on behalf of the respondent, awaiting his appearance as a last chance, list this matter on 26th. In the event there would be no representation, appropriate orders would be passed. Interim order subsisting shall continue till the next date of hearing.
47.
Appearing for the petition, this case, my lord. 494 and 498A, my lord.
Respond number 1, my lord. Senior so ಹುಷಾರಿಲ್ಲ ಸ್ವಾಮಿ.
494 is alleged against my lord in-laws.
494 in-laws ತಗೊಂಡೆ.
ಬರದಿಲ್ಲ ಸ್ವಾಮಿ. 494
ಸ್ವಾಮಿ ಅವರು ಹುಷಾರಿಲ್ಲ.
And your lordship, my lord.
In-laws ಹುಷಾರಿಲ್ವಾ?
It is covered by the judgment.
ಗೊತ್ತು ಸರ್.
Please.
ಆಂಧ್ರ ಕಾರ್ಡ್ ಲಾಯರ್ ಹುಷಾರಿಲ್ಲ ಸ್ವಾಮಿ. ನಾವು ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ ಕೈಂಡ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಎನಿ ಡೇಟ್ ಫಿಕ್ಸ್ ಡೇಟ್.
The learned counsel for the respondent seeks time on the score that the arguing counsel is indisposed today. List this matter next week, Kodi. List this matter on 21st.
Yes.
In the event no submissions are made, the petition would be answered on the contentions of the petitioners.
Please.
Interim order subsisting shall continue.
No interim order, my lord. This is
No interim order, why?
earlier it was listed for maintainability, my lord, last week.
Maintainability, why?
Maintainability, my lord, earlier, my lord, it was challenged on the FIR.
There shall be an interim order of
Please.
stay of further proceedings till the next date of hearing.
Please.
Yes.
In connected matter also, man.
ನಿಮ್ದು ಯಾವುದು?
Otherwise, husband, man.
Memo for withdrawal, yes, in terms of the memo. Yes. Next.
48.
Appearing for the petitioner, madam. Kindly pass over.
Passed over by 1 week, yes.
Seeking for washing up the FIR, my lord.
ಎಲ್ಲ ಅದೇನೆ ಸರ್ ಹೇಳಿ ಒಂದೊಂದ್ಸರಿ ಚಾರ್ಜ್ ಶೀಟ್ ಒಂದ್ಸರಿ FIR.
Now the dispute arising out of the contractual relationship between the parties, the supply of materials. Page number 16 is the complaint.
He was not present, remains absent. This court on 29/5/2024 had passed the following order. Even today, there is no representation on behalf of the respondent complainant. As a last chance, lest this matter on Wednesday 19th, in the event no representation would be made, appropriate orders would be passed. Interim order subsisting shall continue till the disposal of the petition.
Much obliged.
Next.
950.
Four 20 of IPC offenses. Complaint is at page number 13.
Where respondents counsel ಬರೋದಿಲ್ಲ.
Last occasion, they have not represented.
Same order 19th ಹಾಕಿ madam. This court on 29/5 so and so order, lest the matter on 19th. Interim order ಇಲ್ವಾ?
ಇಲ್ಲ.
We'll dispose it on that day.
Please.
Lest the matter on 19th in the event so and so. Interim order ಇಲ್ಲ ಇದೆ ಅಷ್ಟೇ.
51.
The respondent is.
The application for sending the check to handwriting experts has been rejected. Your
ಅದರ ಮೇಲೆ ಬಂದಿರೋದು ಇಲ್ಲ.
Supreme Court judgment is clear that it is.
List on Friday. Counsel for the petitioner is not present. List the matter on Friday.
Appearing for petition.
Second respondent.
ಏನಿವೆರಡು?
Criminal petition, my lord, was
Case and counter
different
case.
dates, so several complaints were given by the second respondent.
Different?
Dates,
Huh.
different complaints were given by the second respondent. Page number 62 may kindly.
First ಯಾವುದು?
First 3801 of 23.
1 minute, AG ಬಂದಿದ್ದಾರಾ? Yes, madam, 1 ನಿಮಿಷ. What have you done to that school?
They have written a letter, my lord.
Where the petitioner is not here, Prakash?
The month of February, we had filed an affidavit, my lords have granted 6 months for completion. They have requested till August 15th.
ಯಾಕೆ ಅವತ್ತು ಇನಾಗ್ರೇಟ್ ಮಾಡ್ತೀರಾ? How long?
Let me kindly take it up in the month of August. We'll report what has happened.
No, I'll take it in the last week of July.
We'll report the progress.
Heard the, madam, ಇದು serial number 107. Heard the learned additional advocate general Srimati Pratima Honnapura, who would submit that construction of the school has begun and would report its completion by the end of July 2024. List the matter on 31st July 2024 for further hearing at 2:30 PM. By then at least finish it, madam.
Apologies, that's not there.
ಅದಕ್ಕೆ yes.
Page number 58, my lord, second respondent and her mother have filed a suit for partition in OS 213 of 2012. 58.
Yes, sir.
My lord, prior is at page number 62 for partition and separate possession. My lord, in the year 2062 itself, we have filed a written statement at page number 68. Rudrappa and Channappa are brothers. My lord, this Rudrappa has married to one Ramaka. Out of their wedlock, no male issues was born. Only one female issue was born, Shivananjamma. Thereafter, my lord, since Rudrappa was in Indian Army, since he had no male issues, he had executed a will dated 29/10/1970 in favor of brother Channappa. These are all the children of Channappa. Second respondent is the granddaughter of Rudrappa. My lord, thereafter, my lord, at page number.
No, the allegation is 341.
Yes, we have created the documents on that.
341 created the documents, what sir?
341 alla, our major allegation, page number 25 may kindly peruse, my lord, complaint. 25.
Crime number 125
ಅಲ್ಲ, ಅದು ನಾವು ಹಾಕಿದ ಕಂಪ್ಲೇಂಟ್ ಅದನ್ನ ಕ್ಲೋಸ್ ಮಾಡಿದ್ದಾರೆ.
ಕ್ಲೋಸ್ ಮಾಡಿದಾರ?
ಯಾವ್ದು?
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ, ಯಾರು ಕ್ಲೋಸ್ ಮಾಡಿದ್ರು?
ಪೇಜ್ ನಂಬರ್ 25 ಮೇ ಕಂಡ್ಲಿ.
ನಾವು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದನ್ನ
ಅವ್ರ ಕಂಪ್ಲೇಂಟ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ, ನಮ್ಮದ್ರಲ್ಲಿ ಕ್ಲೋಸ್ ಮಾಡಿದ್ದಾರೆ. ಪೇಜ್ ನಂಬರ್ 25 ಮೇ ಕಂಡ್ಲಿ ಪೇರೆಸ್ ಮೇ. ದಿಸ್ ಕಂಪ್ಲೇಂಟ್ ವಾಸ್ ಆನ್ 8/8/2021. ಅದರಲ್ಲಿ ಮೊದಲನೇ ಪ್ಯಾರಾದಲ್ಲಿ ಸದರಿ ಜಮೀನುಗಳಿಗೆ ನಾವು ಸ್ವಾಧೀನದಲ್ಲಿರುತ್ತೇವೆ, ನಾವು ಉಳುಮೆ ಮಾಡಕ್ ಹೋದಾಗ ಅವ್ರು ಬಂದು ಗಲಾಟೆ ಮಾಡಿರು ಅಂತ ಹೇಳ್ತಾರೆ. Long back in the year 2012, second herself has filed a suit for partition. That's why I
Page. Which one? ಈಗ ತೋರಿಸಿದ್ದ?
ಈಗ ತೋರಿಸಿದ್ದು ಪೇಜ್ ನಂಬರ್ 25 ನಲ್ಲಿ ಮೊದಲನೇ ಪ್ಯಾರಾದಲ್ಲಿ ಈ ಎಲ್ಲಾ ಜಮೀನುಗಳು ನಾವು ಸ್ವಾಧೀನದಲ್ಲಿರುತ್ತೇವೆ.
That I have seen, sir.
Yes.
Suit ಯಾವುದು?
Suit my lord OS at page number 58. OS number
213 of 2012.
12. Long back 12 years back suit ಫೈಲ್ ಮಾಡಿದ್ವಿ.
ಆಯ್ತು. ಅದ್ರಲ್ಲಿ ಏನ್ ಪ್ರೇಯರ್?
ಅದು suit for partition.
Partition.
Yes.
You are all members of the same family?
Same family. ಅದು ರುದ್ರಪ್ಪ ಮತ್ತೆ ಚೆನ್ನಪ್ಪ ಫ್ಯಾಮಿಲಿ. My lord, we have taken a.
What happened to the suit?
Suit is pending.
Pending.
My lord, we have saved.
Who both of you are in possession of the property?
ಇಲ್ಲ, ಅವ್ರು ಇರಕ್ ಸಾಧ್ಯ ಇಲ್ಲ. His grandfather was in Indian defense. She was settled.
Now he is seeking partition of it.
Our granddaughter is seeking partition. He has executed a will in the year 1970 itself. ಅದ್ರ ಬೇಸಿಸ್ ಮೇಲೆ ಖಾತೆ ಚೇಂಜ್ ಮಾಡಿತ್ತು. At page number 68, we have taken a specific defense.
What is the connected matter then?
Connected matter, ಇದಾದ್ರು ಒಂದ್ ತಿಂಗಳಿಗೆ ಇನ್ನೊಂದು ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾರೆ.
ಎರಡು ನೀವೇ ಹಾಕಿರೋದಾ?
ಎರಡು ನಾವೇ ಹಾಕಿರೋದು. ನಮ್ಮ ಮೇಲೆ ಸೇಮ್ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಸ್ ಗಿವನ್ ಎ ಕಂಪ್ಲೇಂಟ್. ಅದಾದ್ಮೇಲೆ ಇನ್ನೂ ಒಂದು ಕೊಟ್ಟಿದ್ದಾರೆ, ನಮ್ ಕ್ಲೈಂಟ್ ಬಂದಿಲ್ಲ. ಈಗ 2023 ನಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಆನ್ಯುವಲ್ ಬೇಸಿಸ್ ಇದು ಕಂಪ್ಲೇಂಟ್.
ಇದ್ರಲ್ಲೂ ಕೂಡ ಅಲಿಗೇಷನ್ಸ್ ಅಷ್ಟೇನೆ. ನಮ್ ಜಮೀನು ಉಳುಮೆ ಮಾಡಕ್ ಹೋದು ಅದರಲ್ಲಿ.
ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ನಿಮ್ ಕೇಸಲ್ಲಿ ಹಾಕಿರೋದು?
ನಮ್ ಕೇಸಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ.
ಆಗಿಲ್ವಾ ಇನ್ನು?
ಇಲ್ಲ, ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿ ಕ್ಲೋಸ್ ಮಾಡಿರಿ ನಮ್ದು.
ನಿಮ್ ಎಗೇನೆಸ್ಟ್ ಈ ಪೆಟಿಷನ್
ಹಾಕಿರೋದು ಅಟ್ ಪೇಜ್ ನಂಬರ್ my lord is with respect to first case 3801 at page number my lord 26. Column number 17 will start at page number 34.
33 341 504 506.
From third generation they are not in possession of the property.
ಅಲ್ಲ, ಅಲ್ಲಿ 447 ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ನಿಮ್ಮ ಮೇಲೆ?
ಇಲ್ಲ,
341 ಇರೋದು.
ಹೌದು. ಆ ಜಮೀನೊಳಗೆ ಅವ್ರು ಹೋಗ್ಲಿಕ್ಕೆ ಸಾಧ್ಯನೇ ಇಲ್ಲ. ಫ್ರಮ್ ಥರ್ಡ್ ಜನರೇಷನ್ ದೇ ಆರ್ ನಾಟ್ ಇನ್ ಪೊಸಿಷನ್. ಅವರೇ ಅವ್ರ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, ನಮ್ಮ ತಾತ ಬರೋಡಾದಲ್ಲಿ.
ಆಮೇಲೆ ಇದು 341. ನೆಕ್ಸ್ಟ್ ಪೆಟಿಷನ್ ಏನು?
ನೆಕ್ಸ್ಟ್ ಪೆಟಿಷನ್
ಅದು 341.
ಹೌದು, ಅದರಲ್ಲಿ 465 471 420 ಅಂದ್ರೆ ಖಾತೆ ಬದಲಾಯಿಸಿದ್ದನ್ನ ದೇ ಆರ್ ಚೀಟೆಡ್ ಅಂತ.
465 420 49 ಖಾತೆ ಬದಲಾಯಿಸಿದ್ ಯಾವಾಗ? 2004 ಅಲ್ಲಿ.
ಹೌದು, ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋದು 2021 ಆಗಿ. ಅದರಲ್ಲಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಪರವಾಗಿ ಖಾತೆ ಬದಲಾಯಿಸಿದ್ದು. ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಇಸ್ ನಾಟ್ ಬಿಫೋರ್ ದಿಸ್ honorable court. She has expired.
Yes sir.
Please my lord, the second respondent is an advocate and
Second respondent is an advocate.
Alla, let apart she is also doing the agriculture and she is looking after the
Advocate and doing what? Agriculture.
She is also doing the agriculture and when she gone
Advocate agriculturist.
to the part-time, but she is not actually
Advocacy is part time or agriculture?
the advocacy ne
Part time.
The property in question in OS 212, that it was the grandfather's property. One Rudrappa was the grandfather, and he was granted with the land by the order of the Tahsildar. And after demise, his brother was also there. He also no more. His wife has got illegally the change of the khata and mutation, and she has also contacted genealogical tree copy also. In that genealogical tree copy, she has claimed that the wife of Nanjamma, the wife of Rudrappa was also or died, and he has no daughters. So she has concocted the document. By virtue of it, he filed an application for the change of khata and mutation,
before the Tahsildar. And subsequently, they have got the change of Kata and Pani, claimed to be in possession of property absolutely. After coming to, after she has filed a application before the Tahsildar, and it was allowed in favor of this second respondent. And subsequently, they have preferred an appeal. It is also held in favor of this second respondent. The under
They have
mother, and
change of Kata.
subsequently, in revision petition was also filed before the deputy commissioner. It also dismissed in favor against this.
Now the Kata
petition.
stands in your name.
Yes, yes, Kata and Pani stands in our name.
Kata and
Of course,
Pani-
the suit was filed for partition. That suit is pending. Irrespective, when she has gone to visit the land, these fellows attacked and
When did you go to visit
unparliamentary
the land?
words and used to assault using the weapon, deadly weapons. That is the unfortunate thing. And she has screamed, she has somehow evaded and avoided the untoward incident. So therefore, I submit, if already the charge sheet has already been filed by the police and summons was already also issued. And in the meanwhile, they have filed these petitions before this honorable court. How it is tenable in law?
Why?
When the police have already started already investigated and filed the.
So for it
charge
to
sheet-
ಹಾಕ್ಲೇಬಾರ್ದು ಆಮೇಲೆ?
ಅಲ್ಲ ಹಾಕ್ಬೋದು, but that petition is not made on the ground that the
On the ground charge sheet is filed.
charge sheet is already filed and the summons was also issued to the witnesses. All these things are there. When that is so, the petitions do not survive. Both petitions do not survive because her life is in very much danger. They used to assault with deadly weapons. That is, anyhow, she is.
Yes, sir. Why did you use deadly weapons to assault?
ಇಲ್ಲ ಡೆಡ್ಲಿ ವೆಪನ್ಸ್ ಯಾವುದೂ ಇಲ್ಲ.
ಏನು? Simple weapon.
ರೋಟಿ ಕೊಡ್ಲು ಅಂತಾರೆ ತೋಟದಲ್ಲಿ
ರೋಟಿಯಿಂದ ಹೊಡೆಯಕ್ಕೆ ಹೋಗಿದ್ರು.
Simple
ಮತ್ತೆ
weapons.
they wanted to run over the
ರೋಟಿ ಕೀಳ
car.
ಕೊಡ್ಲು ತಂದು ಎದುರಿಸಿರು ಅಂತ ಹೇಳ್ತಾರೆ.
car ಹತ್ತಿಸ್ತಾರೆ
ತೋಟದಲ್ಲಿ
ಅಂತ ಹೇಳ್ತಾರೆ.
ತೆಂಗಿನ ತೋಟದ ರೋಟಿ ಕೀಳ ಕೊಡ್ಲು ಇದ್ದೇ ಇರುತ್ತೆ. ಅದ್ರಲ್ಲೇನು ಎದುರಿಸೋಂತ ಅವಶ್ಯಕತೆನೇ ಇರಲ್ಲ.
This is the problem.
ತೆಂಗಿನ ತೋಟದಲ್ಲಿ
ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಇನ್ನೊಂದು ಮಾಡಿದ್ದಾರೆ, ಇನ್ನೊಂದು FIR ಕೊಟ್ಟಿದ್ದಾರೆ. ಹೀಗೆ ಎಷ್ಟು FIR ಅಂತ ಆಗೋದು? ಲೆಟ್ ಇಟ್ ಬಿ ಇನ್ವೆಸ್ಟಿಗೇಟೆಡ್, ಲೆಟ್ ದಿ ಕಲ್ಪಿಟ್ಸ್ ಶುಡ್ ಬಿ ಪನಿಶ್.
ಕರೆಕ್ಟ್. ಸಿವಿಲ್ ಸೂಟ್ ಡಿಸೈಡ್ ಮಾಡ್ಕೊಂಬಿಡಿ.
ಸಿವಿಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ತೀವಿ.
ಅದ್ ಮಾಡ್ಕೊಂಬಿಡಿ, ಆಮೇಲೆ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಮಾಡಿದ್ರೆ ಆಯ್ತು ಅಲ್ವಾ?
ಎಸ್
ಎಸ್ ಸರ್. ವೈ 341?
ಅದೇ ರೋಟಿ ಕೀಳ ಕೊಡ್ಲಿನಿಂದ ಎದುರಿಸಿರು ಅಂತ ಅಲ್ಲ, ಕಾಯಿ ಕೀಳ ರೋಟಿ ಕೊಡ್ಲಿಂದ ಎದುರಿಸಿರು ಅಂತ.
ಅಲ್ಲ, ಕಾರ್ ಬೇರೆ ಹತ್ತಿಸ್ತೀರಿ ಅಂತ ಹೋಗಿದ್ರು, ಅದ್ ಬೇರೆ.
ಕಾರ್ ಮೇಲೆ, ಕಾಲ್ ಮೇಲೆ.
ಆಕೆ ಮೇಲೆ
ಎಲ್ಲವುದು ಅಲಿಗೇಷನ್
ಹೇಳಿರ್ತೀರ ನೀವು ಅದೆಲ್ಲ?
ಅಲ್ಲ, ಇಂಜುರೀಸ್ ಏನೂ ಇಲ್ಲ, ಎಲ್ಲವುದು ಅಲಿಗೇಷನ್ಸ್ ಆಗಿಲ್ಲ.
You know, she has escaped, avoided it.
Long back in the year 1970, her grandfather has gifted the property, executed a will. ಈಗಲ್ಲ, 1917 ನಲ್ಲಿ ಮಾಡಿರೋದು. So that has to be adjudicated. And ಖಾತಾ ಚೇಂಜ್ ಮಾಡಿದ್ದು 2004 ನಲ್ಲಿ. So ಅದನ್ನ ಈಗ they are challenging. And she has also sought a declaration that her grandfather has to be declared as dead ಅಂತ.
The petitioner is before this court. ಇದು criminal petition 3801 of 2023. The petitioner is before this court calling in question proceedings in CC 792 of 2022 registered for offences punishable under section 341, 504, 506 of the IPC. The second respondent is the complainant, said to be the member of the family of the petitioners accused 1, 2, 3, and 5. A complaint comes to be registered. The facts narrated in the petition are as follows. On 8/11/2022, the 2012, the second respondent, complainant, and her mother file OS 213 of 2012 before the concerned civil court for partition and separate possession. The suit is pending consideration. The petitioners contest the suit by filing written statement contending that they are in possession of the property on the strength of a will that was executed in the year 1970. After the filing of the written statement comes the impugned complaint on 8/8/2021, contending that the petitioners have indulged in ingredients of offense under section 341 447, 341, 341, 504, 506, and 149 of the IPC. The police conduct investigation and file a charge sheet against these petitioners. Filing of the charge sheet is what has driven these petitioners to this court in the subject petition. The learned counsel appearing for the petitioner, by taking this court to the documents appended to the petition, would seek to demonstrate that the possession being in favor of the petitioners pursuant to a will has driven the daughter and mother to register the complaint. He would contend that the suit filed by the second respondent complainant or her mother would clearly indicate that they are not in possession of the property and are seeking partition of the property. And therefore, the incident could not have happened at all, as they have not come into the landed property of the petitioners for ages. He would contend that the projection of section 341 is with intention suffering from want of bona fides. The learned counsel appearing for the second respondent complainant, on the other hand, would seek to refute the submission, contending that the petitioners have threatened the second respondent lady with dire consequences if they would enter into the land belonging to the petitioners or have trespassed into the land belonging to the complainant. The learned counsel would submit, since the police after investigation have filed a charge sheet, even this court in exercise of jurisdiction under section 482 of the CRPC should not interfere, and the case and the petition should be dismissed. Government of the area. The learned HCGP would toe the lines of the second respondent complainant in seeking dismissal of the petition. The four narrated facts are not in dispute. The relationship between the parties are as is borne in the civil suit in OS OS 213 of 2012. They are admittedly members of the same family. The petitioners claim to be in possession of the property pursuant to a will executed in the year 1970, and the respondents are seeking partition of the said property through the suit in OS 213 of 2012. Therefore, a factum that is clear from the pleadings in the plaint OS 213 of 2012 is that the petitioners are in possession of the property. Therefore, any offense the complaint so registered that the petitioners have entered into the land of the petition of the complainant and have threatened her with dire consequence suffers from that improbability which is incurable. Therefore, if incurable, the police, after the conduct of investigation, have filed a charge sheet. The summary of the charge sheet, as obtaining in column number 17, reads as follows, page 33. The summary of the charge sheet is in slight glorification of the complaint with regard to offense punishable under section 341 of the IPC. Section 341, for an action to become an offense under section 341 of the IPC, the ingredients as found in section 339 of the IPC is to be necessarily present. The complainant should not be permitted to move, and the restraint should be in such a manner that the complainant would the restraint should be in such a manner that the complainant is precluded from moving to any direction from where she or he was standing. That is not the allegation in the case at hand. Therefore, the offense under section 341 is loosely laid against the petitioners. So goes with the offense under section 504 and 506 of the IPC. All this have sprung into action only because the petitioners are contesting the suit before the concerned court, in which the complainant and her mother have sought partition of the property. Therefore, the issue being purely civil in nature, though the offense under section 341 would not be a license to unleash violence upon any victim on the strength of the civil suit pending, the case at hand does not demonstrate any of the ingredients of section 341. Permitting further proceedings would become an abuse of the process of the law and result in miscarriage of justice. Therefore, for the aforesaid reasons following what allowed cost. Second petition. Criminal petition 3766 of 2023. The petition is between the same parties. It is an offshoot of what is contended urged in the aforesaid petition, so and so companion petition. The challenge in this case at hand is proceedings in CC 10471 of 2022 for offences punishable under section 465, 471, 420 and 34 of the IPC. The fulcrum of the allegation is that the accused number 1 has got the khata changed in her name in the year 2004. The complaint comes to be registered in the year 2021, clearly 17 years after the change of khata. There is no plausible explanation in the complaint or in the summary of the charge sheet as to why the complainant kept quiet for 17 years after the change of khata. The learned counsel for the respondent would try to defend the action of registering the complaint after 17 years by contending that when they went to the land of the petitioners, they come to know that the khata is changed, which again would vindicate the stand of the petitioners that they are in possession of the property. If khata had been changed in the year 2004 and the petitioners, the complainants have been fighting for the partition of the property right from 2012, it cannot be said that close to 17 years they did not know what was happening with the ownership of the land of the accused number 1, of the accused number 1. So and so, accused number 1. The delay that is in the case at hand, as it is not explained, is fatal to the case of the complainant. The apex court in the case of Chanchalapati Das versus State of West Bengal, reported in 2023 SCC Online SC page 650, has delineated that the delay caused in registering the complaint would undoubtedly become fatal to the case of the complainant unless there is plausible explanation for such delay, which I do not find any such explanation in the case at hand. Therefore, finding the crime registered after 17 years of the change of khata, alleging that the change of khata is a document that is forged, would become highly improbable for permitting the petition trial to continue against these petitioners. For the aforesaid reasons, the following order allowed quashed. The findings rendered in any of these cases will not come in the way of, will not bind or influence the pending civil suit or any other revenue proceedings between the parties. It is rendered.
Including the recurring criminal action by the other side.
ಅಂದ್ರೆ next year ಇನ್ನೊಂದು ರಿಜಿಸ್ಟರ್ ಮಾಡಬೇಕು ಅಂತಿದ್ದೀರಾ?
ಇನ್ನೊಂದು ಮಾಡ್ಬೋದು ಅವರು.
ಆನ್ಯುವಲ್ ಬೇಸಿಸ್ ಮೇಲೆ ಹಾಕ್ತಾ ಇರಿ, ನಾವು ಅದೇ ಬೇಸಿಸ್ ಮೇಲೆ ಒಂದ್ ಸರ್ತಿ ಒಂದು 5 ಲಕ್ಷ ಕಾಸ್ಟ್ ಹಾಕಿ ಕ್ಲೋಸ್ ಮಾಡ್ತೀವಿ. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನನಗೆ ಸಿಕ್ಕಿದ್ರೆ 5 ಲಕ್ಷ ಕಾಸ್ಟ್ ಹಾಕ್ತೀವಿ. ಎಸ್. ಸೊ ರಿಕರಿಂಗ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್
ರಿಕರಿಂಗ್ ಅವರು ಮತ್ತೆ ಮಾಡ್ಬೋದು ಅಂತ.
ಮತ್ತೆ ಮಾಡ್ಬೋದು, ಮಾಡಿ
ಮಾಡ್ತಲೇ ಇದಾರೆ ಅವರು. ಬಹಳ ಕಷ್ಟ.
ಎಸ್. ಅಂಡ್ ನೀವು ಡೋಂಟ್ ಟ್ರೈ ಟು ಅಸಾಲ್ಟ್.
ಇನ್ನೂ ಒಂದಿದೆ.
ಅಸಾಲ್ಟ್
ಅಲ್ಲಲ್ಲ, ಹಾಕಿರೋ ಕೇಸ್ ಇನ್ನೂ ಒಂದಿದೆ.
ಅದು 23
23
ಇದೆರಡು 22
21
ಒಂದು 22 ಒಂದು 23 ಎಲ್ಲಿದೆ?
ಇನ್ನೂ ಫೈಲ್ ಮಾಡಿಲ್ಲ, ಮಾಡಬೇಕು.
25 ಅಲ್ಲಿ ಎರಡು ತಗೊಂಡ್ಬೋಣ. ಎಸ್,
ಸೇಮ್ ಅಫೆನ್ಸ್ ಸೇಮ್ ಲೈನ್.
25 ಅಲ್ಲಿ ಎರಡು ತಗೊಂಡು ಡೆಫಿನೆಟ್ ಆಗಿ ಒಂದು ಬರುತ್ತೆ.
ಆಯ್ತು, ಬರುತ್ತೆ.
ಎಸ್.
ಪಿಟಿಷನರ್ ಸ್ವಾಮಿ ಕೈಂಡ್ಲಿ ಪಾಸ್ ಅವರ್ ಆಗಲಿ ಸ್ವಾಮಿ, ಸೀನಿಯರ್ ಇನ್ನೊಂದು ಕೋರ್ಟಲ್ಲಿ ಇದ್ದಾರೆ.
ಇನ್ನೊಂದು ಕೋರ್ಟಲ್ಲಿ ಇದ್ದಾರಾ?
ಹೌದು ಸ್ವಾಮಿ.
Passed over to 21st. Yes. Entry matter subsisting shall continue till the next date of hearing.
Section correspondence 7 of the PC Act, read with 201 and 120B of PC. My lord, substance of the allegation.
Unsuccessful trap. In case ilva?
No, sir, assistant.
Yeah. Third,
The substance of the allegation, my lord, that complaint came to be presented by the one complainant by name one Mr. Manjuna, who is a owner of, who is one Mr. Manjuna. He is none other than the manager of one hospital, man, which is adjacent to the railway authority, man. Where the petitioner and superior of the petitioner are police inspector and assistant sub inspector of the railway protection force, man. They have caused, while doing a renovation of the hospital, my lord, they have caused a certain damage of a certain cable of the railway property, my lord, which case has been registered against the hospital authority, including that Manjunath, my lord. So they have filed a complaint stating that the petitioner and that superior officer are demanding of illegal gratification of rupees 1,50,000 rupees to close the case which is being filed against them. That was the substance of the allegation. In consequence to that, my lord, before filing of registration of a case which is against the complainant authority, my lord, lordship may kindly have a look at the page number memo which I have filed. This is the one letter, my lord. The case which is being registered against page number 29, memo which I have filed, my lord. This is the case which is against the hospital authority, which Nexel that they have violated the provisions of the Protection Act, and which has caused a damage, which is page number 29, my lord, of that said memo.
Chart sheet.
Chart sheet, page number 29, ink page 29. This has been registered, my lord, serial number 5 in that their occurrence report, my lord. Name of the officer Umesh Dakar and Muhammad ASIF. It's not the petitioner, madam. He is a superior officer who had registered the ways. Based upon that, there was a search and seizure has been taken place at the hospital. The finding which has been made, my lord, last 2 line, my lord. It is also stated due to the obvious so cable cut all the important communication circuit affected, the penalty to be raised 1.5 lakh rupees. This is a kind of information, please. This has been addressed by, my lord, Post Commander RPF 2. This is registered by officeman. Subsequently, my lord, one more case has been registered. This is also under inquiry. This is also which clearly indicate 1.5 lakhs. Next, my lord, page number, lordship has to page number 33.
Yes.
Page number 33, which lordship is a date is important, my lord. 17/2/2022. That occurrence.
But accused number 1 is it?
No, it is not accused number 1. It is accused number 2, my lord.
You are accused number 2.
I am appearing for accused number 2. This was addressed by, my lord, senior section engineer, telecommunications, so engineering, to the RPF police station, to the police where that accused is working, my lord. This has been addressed on 17/2/2022. This would be a very important matter for the reason, my lord. This is also 3 line of that letter, my lord. Kindly peruse. Penalty for the so 1.5 lakhs, which is so. Kindly be investigate, do the needful. That was addressed by.
Sorry. That's may I pass on list of dates so that it will be convenient for the court.
Why I am highlighting this, my lord? Prior to registration of a case by the police, by the petitioner against the complainant authority, that they have caused a damage of rupees 1,50,000 rupees is a damage which has been caused to the railway property, which the department has raised a penalty and addressed to the police authority, my lord.
You are no way connected.
I am no way connected, my lord. For this, my lord, the complainant comes and file a complaint saying that no, he has demanded of illegal gratification. His mobile, not his official mobile, my lord. His mobile has been recorded. That recording conversation which has been extracted before this honorable court in the form of charge sheet, my lord, that is nowhere it has been a demand of illegal gratification made by the accused number 2, who is the petitioner before this honorable court. Only what he has been.
Against whom was the trap laid?
trap is been laid against accused number 1 and 2, my lord.
What happened to the trap?
No, trap, the demand of a money, demand of illegal gratification goes and handed over to the accused number 2, my lord. But he did not accept.
You did not.
No, I did not accept. Then he goes along with the accused number 2 to the some railway station, my lord, where one Mr. Avinash, who is working in railway authority, that he is a supplier of water, my lord, he accept on behalf of accused number 1. Accused number 1 properly. Accused number 1, my lord, that no demand, no acceptance by myself or purported recovery has been made from myself. So entirely, my lord, only support of a demand, my lord, it is a purported conversation between the accused number 1, accused number 2, and this complainant. In that entire conversation,
Is Avinash, is it?
Avinash, not Avinash, my lord, complainant. Complainant 1, Mr. Manjuna. In the entire conversation, my lord, nothing has been revealed to show that there is a demand of illegal gratification. What I have been told to the complainant, no, you go and deposit it. Deposit to the counter. I will write a letter, deposit to the counter, because I did not accept that. So what the CBI has done it, my lord, because they did not get anything, did not demand acceptance has not been proved. Subsequently, they made a creation of a story saying that after, my lord, this became important. 17/2/2022 is a letter, my lord. What is the complaint came to be registered 2/3, my lord, complaint dated 2/3/2022. Well, after many days. So after this, my lord, lordship as his 164 statement came to be recorded. Who has accepted the illegal gratification, my lord? His statement under 164 statement has been recorded. After 3 months, my lord. After 3 months, his 164 statement has been recorded, saying that no, that accused, who am a petitioner, who has instructed the complainant to make that payment to the Avinash Kumar. In turn, Avinash Kumar is handed over to me. This is a statement where he has given before the magistrate, which they are relying upon. That is the only piece of evidence which is available. That evidence which is been available, my lord, in the 27/7, my lord. That date is a 27/7/2022. After 3 months of alleged incident, they made it this story. There is nothing, Lord, your lordship has held it in many judgment where demand, acceptance, and purported recovery is a sine qua non. And subsequently, your lordship has held in many cases where it has been held that even demand acceptance, because they are saying, my lord, recovery is being made through Avinash.
So
Avinash.
there is demand.
No, there is no demand at all, my lord. In the entire case,
their cases that there is demand.
No, my lord, there was no even a piece of evidence to show that there purported demand. Only when they have been recorded 164 statement of the one Mr. Avinash Kumar, because they did not get any demand acceptance. Consequently, they made a story that statement can be useful only after 3 months of a alleged incident.
All right. Yes, right.
My lords, if my lords were to look at the list of dates, my lords, initially 2 crimes came to be registered against the hospital, my lords. One, crime number 67 on 18/2/22, my lords. This is on the allegation that fiber cables were damaged. My lords, they call the complainant, the other stuff. Subsequently, on 26/2/22, there's another crime registered, my lords.
Against the hospital.
Yes, my lords. On the allegation that there is a chimney on the backside of the hospital, which is adjacent to the railway property. Therefore, it is infringing and therefore it's an offense. These are the 2 crimes, my lords. This is the work pending on the file. Work pending on the file. They
What
are alleging,
work?
my lords,
So these 2 are the crimes that you say that this was the work of investigation pending on these crimes.
correct.
All right. Now, who was interested with the investigation?
My lords, the petitioner and A1 and A2 were the ones in charge of the investigation.
Where is that?
My lords may see the FIR.
They are the Railway Protection Force Police.
Correct, my lords.
Now, who was in charge of the police station there?
No, it's
Accused
the
number 1
RPF
or
police
Number
who
1, my lord,
registered
I am
this.
subordinate to him.
RPF police is the one who has registered these 2 crimes
Correct.
against the hospital.
Correct.
You said he was interested with the investigation.
My lords, A1 was interested with the investigation.
A2.
Petitioner was the subordinate.
All right.
My My lords, on 2/3/22, Manjunath was the manager of the hospital, my lords. He is called to the police station.
By A2, by A1.
A1 and A2.
Aye.
My lords, he meets A1 in the police station, my lords. A1 further entrusts him to A2 to record his statement.
Now
This is-
complainant is called and is demanded 25,000.
No, my lords, 1,50,000.
Illa the fine amount of 25,000 he
Fine
paid.
amount is 25.
In addition to 25,000.
Correct.
Yes.
My lords, there, over the series of dates from 18/2/22 to 2/3/22, there are conversations, phone conversations which happen, my lords, which is recorded by the complainant. The transcripts of which is provided, the charge sheet. My lords, this is where the demand takes place, my lords. May I point out from the records, the demand which is there. My lords, in their documents,
Charge sheet ಅಲ್ಲಿ ಇದೆಯಾ?
how's Lots documents D1 to 24 is not paginated.
D1 to
D24, my lords.
ಇದರಲ್ಲಿ ಇದೆಯಾ charge sheet ಅಲ್ಲಿ?
They have filed 3 volumes of charge sheet.
3 volumes.
No, only one volume. Total this much of a charge sheet, my lord.
ಆಯ್ತು ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಅಲ್ಲಿ ಏನಿದೆ ಹೇಳಿ.
My lords, transcript nalli, lords, if I seek a help of the fellow colleague in Kannada.
ಕನ್ನಡದಲ್ಲಿ ಇದೆಯಾ? ಕೊಡಿ ಇಲ್ಲಿ.
Lordship is page number 30.
ಕೊಡಿ ಇಲ್ಲಿ ಕೊಡಿ.
Page number 204 of my
This is where the
compilation.
relevant
give it,
part is. Thank you.
Who is Raghavendra?
He is the petitioner, my lords. Onduvare is the demand.
ಇದು ನೋಡಿದ್ದೀರಾ?
I gone through it. My continuation, conversation, lordship, entirety, lordship is kindly see.
If you say no, I won't pay.
No,
you
no.
go and pay.
No, no, my lord, this is a deposit, my lord. That is the reason, my lord.
Deposit ಯಾವುದು 25% fine amount?
No, no.
25,000.
No, no, my lord.
Then?
The investigation, there are 2 cases where investigating, my lord. Lordship in the same page, my lord, lordship has to
The
kindly.
voluminous transcript, my
No,
lords,
no,
entire content.
entire transcription, my lord, it pertains to the case which is going to be deposited of 1,50,000 rupees as a cable, which is a cable which has been caused by the hospital
Not
authority.
the bribe amount.
Not the bribe amount. That is the reason, my lord, that they could not get a.
All right. You say it is, the demand is there. When did he accept that amount?
My lords,
No, no, there was no acceptance at all, my lord.
Wait, sir. When did he accept the amount?
my lords, the trap is
No, if
laid.
there is no acceptance, say no acceptance. We'll go on demand.
Yes, my lords.
Was he caught red-handed accepting the bribe amount?
My lords, with amount he was not caught,
Then
but the pant in which the amount is kept, the phenolphthalein test turns positive.
pant in which?
My lords, I'll assist the court on that. Let me take through the trap.
No. You tell me, where was the amount kept?
My lords, the amount was initially with the complainant, my lords. He takes, the petitioner takes the complainant along with his scooty to another secluded place where there are shadow witnesses to that effect. There they ask one person to keep the amount for some time, my lords. His name is Pinto Kumar. He refuses to take that. I don't know him. Lords, subsequent to that, they go to another pantry car manager who's working in that. There they entrust that amount to him, saying, keep this amount for some time.
The pantry car manager.
Correct, my lords. His statement is 160. That is the 164
All right.
statement which they're in. Keep it for some time. I will come and collect it later.
Who says that?
The petitioner.
All right.
Thereafter, money is handed over to him and the petitioner drops the complainant back to the police station. Subsequently, again goes to that place.
Goes to Pinto.
The same pantry car
Pinto
manager.
Kumar.
Takes the amount, keeps it in his right pocket. That is when the trap is.
The petitioner.
Correct, my lords. When the trap raiding party approaches, he flees away. Because that is the exact reason why 201 is invoked in this, my lords. He flees away through the bushes.
Who?
The petitioner.
Taking the money.
Yes, my lords.
In his pocket.
Yes, my lords. My lords, all the FSL reports, my lords, assist. FSL reports phenolphthalein test turns positive. Shadow witnesses support the case. 164 statement clearly indicates.
Of Pinto Kumar.
164 Pinto Kumar clearly says petitioner gave me money.
No,
I'll show it from the statement.
He is not, his statement 164 is not there, my lord. Only the witnesses who is Avinash Kumar purportedly received that acceptance of the illegal gratification on behalf of the accused.
Why did you go to the pantry car back?
No, my lord, it's not pantry car at all, my lord.
Why
I
did you
never
go to that man back?
No, that's what, my lord. If suppose such an incident came to be happen, why? Because it is a Bayapnadi railway station, my lord. It is a superior, everywhere CCTV cameras have been installed. Why did not they take that CCTV camera? Because the reason, my lord, for the purpose, they did not get any money. They did not get any
Not
demand.
collect it in the precincts of the railway station.
No, my
It
lord.
went somewhere.
No, my lord, that is the reason. Their case is, I did not accept the money there. Otherwise, if I really demanded of illegal gratification, I could have been accepted there itself in the station.
In fact, my lord,
If no such incident have been happened, what I said in the entire conversation, you go and deposit.
Man will accept gratification under the CCTV.
No, not in the CCTV, sir. Police station, of his police station.
Fact, my lord.
What is ultimately what happened, my lord? They creating a story that I goes to the railway station. In that railway station, I have collected the money from the Avinash Kumar, which my hands.
Where are the statements?
Please.
My lords. My lords were to see the.
Not the, not the audio transcript, statements.
No, yes.
Statement of Avinash or Pinto Kumar, whoever it is.
Lords, volume 164. Volume.
In which?
What, my lords, in that volume.
Idaralla.
Yes, my lords.
Page?
My lords, I do not have.
Give that. Put him in. But why did you run away then?
No, my lord, that was no, I have never accepted the money. I never go. Only because, my lord, once a case has been registered against me, I go and voluntarily surrender to the, because there was a CBI has chased.
You surrendered?
No, I myself has surrendered to the
No,
police.
it was
But the
arrested.
reason that, my lord, I immediately been suspended for the reason.
164, what is the state of whom?
No, it's Avinash Kumar Mishra, the one to whom
Pantry
money
worker.
is, yes, my lords. Lords, he collects it. He sits in the train. For him also, my lords, phenolphthalein test is conducted. That is also turned positive. The births
So
phenolphthalein.
whoever has touched the notes.
My lords, the FSL report is also part of the charge sheet. I'll point out from that. So all I've done.
Your
Plus,
file
this is the
detail
report.
note idea?
Yes, my lords.
Yes.
My lord, only for reply for 1 minute. I never been accepted any money, nor demanded any illegal gratification. I only.
The problem is you're caught red-handed.
No, my lord, that is the reason.
Not accepting.
No, my
Taking it from Avinash Kumar, keeping it in your pocket, the test turning positive, and you running away from it.
lord, kindly show me the prosecution may show even single piece of evidence. I accepted the money on that day.
Accepted Allah. You went and took it from Avinash
No,
Kumar.
my lord, that's what, that is the reason. Because
Why
only.
will Avinash Kumar give you 1.5 lakhs just like that?
No, my lord, it is a false story which came to be registered.
That is a statement of Avinash Kumar.
No, that's what, my lord. When it is statement came to be recorded, my lord, please kindly have it to page number.
Contention is a
My,
matter of
my,
trial.
my,
No,
no,
if
my-
you want this to be considered as a false story, you should come out clean in the
No,
trial.
that is a different issue. My humble submission, there should be some material to show that.
Abundant, I will answer, abundant
demand-
material.
No, there should be a demand of illegal gratification. Somebody has shown, somebody has seen that I have received the money or I demanded of illegal
So
gratification.
demand can be direct or indirect.
Any circumstances, my lord. I am not saying anything. Either by shadow witnesses or demand of independent witnesses or even worse come, my lord, that Avinash Kumar, whose statement came to be recorded in the, my lord, page number 21/7/2022 after 3 months of alleged incident. Alleged incident came to be.
Then ಅವತ್ತೇ statement ತಗೋಬೇಕು ಅಂತಿಲ್ಲ.
No, Mala, at least 164 statement, 161, Mala. Incident came to be happen on 3rd.
These are all disputed questions. of
Third,
facts.
Mala. Even there was no material. Forget for a moment, Lordship, even is been, according to the statement of Avinash Kumar is to be accepted as it is, my lord. Even then, my lord, where is the material which, because conversation has been taken place, my lord. in the telephone.
They will prove it.
That conversation should have been contained of this statement of Mr. Avinash.
That's what, not the transcript. Avinash Kumar's statement itself is there under 164.
No, that's what, my lord. This would be definitely because they did not open their mouth from 3/3/2022 to 21/7/2020.
That's a matter of evidence. I cannot here decipher
humble
that to
submission.
say that these witnesses' statements are not believable.
One aspect. And second aspect for clarification, my lord, where did I shown any favor or disfavor to the parties? Because, my lord, this case, he himself has pleaded guilty. That one Mr. Manjuna, he himself has pleaded guilty and made a deposit to the court, my lord, the penalty.
But that's not the problem. See, Manjunath paying 25,000 as penalty, accepting the guilt, that's a compoundable offense. He has done it. No problem. But to get everything cleared, you have demanded 1.5 is what is said.
No, that's the reason, my lord. 1.5 lakh rupee is a demand of illegal gratification. What they are saying, my lord, this is a deposit to be caused damaged, which is required to be deposited by the hospital authority.
If that is the case,
Otherwise,
I will not get into all that.
And otherwise, my lord, first case, that was, I have no concern, my lord. That case is registered by the accused number 1, my lord. So my humble submission, there was no material at all.
Interim order here.
No interim.
No interim.
Let's even from his 161 statement,
Lord.
Avinash Kumar Mishra clearly deposes that there was instructions from A1 that petitioner and so a complainant will come, will hand over money to you, keep it for some time, then we will collect it later.
One more point.
The FSL.
What my learned friend has, the pant has been recovered. This pant has been recovered only after 3 days of alleged incident. According to the prosecution, my lord. According to the records, my lord, according to the records which they are saying, my pant of the petitioner has been recovered after 3 days of alleged incident. That has been having a color of a platinum powder of it is turned to pink anta.
It's seized under a cover of
When
Seizure
he himself has goes and surrendered, his pant has been recovered.
Pant itself turned pink.
Adike. That is the stand of the prosecution.
What turned pink, sir? Panta.
It was the right pocket.
Right
Let me point out from the FSL report.
Is it possible, man?
Because
After
it's
3 days
seized
of
under a cover of seizure master. It was not the case of us that he was wearing that pant. It's seized.
Is it
For 3 days he wasn't hiding. He was arrested. He did not surrender.
He was not wearing that pant.
No, afterwards.
That is the reason, my lord. I know because any possibility that a man who is wearing 3 days of the same pant, after 3 days he surrendered to the police, surrendered to the police station.
Whether he was wearing the pant for 3 days is a disputed question.
That is the fact, Milord. FSL report is a prism.
This is how the
293, 294 have a presumption. It's a public document. They have dispute. It's a question of fact. Plus, on law, there's one judgment.
Good.
My lord, I have also placed some 4.
All demand and acceptance judgments there.
No, that's what.
Plus, there's only one judgment which
Lordship.
Sita Soren is what I would like to rely upon, Milords. May I read the relevant portion? Please. Milords, para 117, Milords, of page 81.
Why is this?
Milords, the fact that they said there is no acceptance, that's their contention. Milords, may be permitted.
Paragraph
117, Milords, have flagged it. Para 117, Milords, page 81. 7 judge bench. Milords, under section 7 of the PC Act, the mere obtaining, accepting, or Milords.
This is passing reference in that legislator.
Correct. Neeraj Datta was done. Attempting to obtain an undue advantage. Even in the amended act also, Milords, may I read the explanation of 7?
No, that is there in para 119.
Obliged.
My lord, this also been answered by this honorable.
Even in Neeraj Datta, inferential deduction can be done.
Neeraj Datta, the constitution bench is explained by subsequent Neeraj Datta.
Correct. They said inferential deduction can be done.
We'll see. Yes.
My lord, my compilation, my lord, lordship judgment, page number 45, 47. My lord. The judgment, though it is a Menon judgment, well, lordship, First part, your lordship, has
And
wiretapping has been led. I have provided.
It is wiretapping, sir.
Wiretapping has been led. Where your lordship has referred.
Illegal wiretapping ಬಿಟ್ರೆ ಬೇರೆ ಅದರಲ್ಲಿ ಏನು ಎವಿಡೆನ್ಸ್ ಇರಲಿಲ್ಲ.
No, my lord, apart from that, my lord, page ಅದರಲ್ಲಿ judgment refer ಆಗಿದೆ. ಶಾಂತಮ್ಮ case, my lord.
Pre and post amendment, what is demand and acceptance?
That is the only. A prerequisite demand and acceptance what not available.
What happened to this? It's challenged?
SM Mannan, my lords. My lords, it's currently not under challenge, my lords. We have provided our opinion.
That's fine.
Lords, SM Mannan, my lords, your lordship is well aware. It's on 419.
It's on 419 of Telegraph Act, sir.
Apart from that,
There
other
was no permission taken or granted with application of mine to wiretap
yes,
the petitioner's telephone.
yes, and apart from that, my lord, another three judgments have placed. My lord. Srikanth lordship, well, Dharwad bench.
Vijay Kumar and
Please. That is, my lord, Vijay Kumar case and Neeraj Datta case and Jairaj case and Shantamma case, which I have relied. The only relevant portion, my
Lords,
lord.
all of these are referred in the larger bench of Neeraj Datta.
Please.
Yes, list on 28 for further hearing. I'll dictate on that.
Grateful for the office.
You filed your list of dates, right?
Yes.
I will permitted to make one list of date on my.
Goody, yes.
Oblige, please.
If I attend 56. For the petition. Yes, challenged is the rejection of B report and issuance of taking cognizance.
Page. We have to come on merits, nothing wrong with this order.
Well, on merits,
Oh.
we are not on Dr. Ravi.
Rejecting B report
Yes,
and taking cognizance is in consonance with law. I told you
Yes,
last time itself.
we have not raised that ground also.
Then what is it?
Lords, the case is this, my lords. There come,
You're ready?
Weeks time, my lords.
Why?
Seniors,
Interim order, yeah?
interim.
At the request of the learned counsel appearing for the respondent, list the matter on 26th. Interim order subsisting shall continue till the next date of hearing. Next.
7.
For the petitioners in this matter, my lord. The offences punishable under section 376, 417, 420, 506, 109, read with 34 IPC, my lord. Petition number 2 and 3 are the parents of the petition number 1, my lord.
Insta meet.
Yes, my lord. Now she is married, my lord. Respondent number 2. Her marriage was solemnized on 1/5/2014 with one Mr. Trishal Pujari.
ಎಲ್ಲ ಇನ್ಫಾರ್ಮೇಶನ್ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಾ? ಇನ್ಸ್ಟಾಗ್ರಾಮ್ ಅಲ್ಲಿ ಸಿಗ್ತಾ? ಎಸ್ ಗವರ್ಮೆಂಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಲ್ವಲ್ಲ? Heard the learned counsel appearing for the petitioner. This court on 15/6/23 has passed the following order. Noticing the fact that the petitioner and the complainant had met on Instagram and had developed friendship and had physical relationship also for close to 3 years. And at a later point in time, the complainant termed the same to be a rape under section 376 of the IPC, had granted the interim order of stay as aforesaid. The learned counsel for the petitioner submits that the complainant is now married and is living elsewhere. The learned counsel for the respondent complainant remains absent. Therefore, list this matter on 26th. In the event the counsel for the complainant would not be present, the petition would be answered on the contentions of the petitioner. Interim order subsisting shall continue till the next date of hearing.
Much obliged.
The offences which alleged under section 376 and 493.
Idu 376, sir.
Yes, ma'am. The
Same.
the complaint also married your lordship.
Married.
Married.
You are also married.
No,
You're not married?
no. When this honorable court had issued the twice notices to the prosecutor.
Served unrepresented, don't worry.
100%.
Where is the complaint?
Complaint at page number you lost. 37 years.
How long was the relationship?
From 2017 you lost.
Complaint is registered in 2019, 2 years.
2 years. Engagement was also performed.
Illi yavaga? Where is the?
On 6/11/2017, sir.
6/11?
2017.
17.
2017.
ಸುಮಾರು ಗಂಟೆಯಲ್ಲಿ ಇದು ಚಿನ್ನಾಗರ ಕನೆಕ್ಷನ್ ಕನ್ವೆನ್ಷನ್ ಹಾಲ್ ಇಬ್ಬರ ಹಿರಿಯ ಸಮಕ್ಷ ನಿಶ್ಚಿತಾರ್ಥ ಮದುವೆ ರೂಪದ ಸಂಪ್ರದಾಯದಂತೆ ನೆರವೇರಿತು. We'll close it. The petitioner is before this court calling in question proceedings in SC 49 of 2022. Arising out of crime number 27 of 2019, registered for offences punishable under section 376 and 420 of the IPC. Heard so and so. Facts in brief germane are as follows. The second respondent is the complainant. The complainant and the petitioner meet on 13/2/2017 when the complainant was pursuing her at B and coaching for the administrative service examination at Delhi. It is alleged that the complainant and the petitioner befriended each other and the friendship turned into relationship and was physical as well. A perusal at the physical as well. It is the further allegation that the petitioner, on the pretext of a promise of marriage, has indulged in physical relationship with the complainant and at a later point in time seeks to marry someone else. It is that at that point in time the complainant registers the impugned complaint. The police, after investigation, file a charge sheet against the petitioner and the matter is committed to the Court of Session, which is pending as SC 49 of 2022. The learned counsel for the petitioner, taking this court through the complaint, averments in the complaint and the summary of the charge sheet, would indicate that the consensual acts between the complainant and the respondent are given a color of crime, given a color of rape. The learned counsel would submit that the petitioner and the complainant were intending to get married and the engagement ceremony of the two was also performed. Therefore, there can be no question of rape on false promise of marriage as is alleged in the case at hand. The complainant, though served, remains unrepresented. The learned counsel for the petitioner informs this court which is on instructions that the complainant is already married to someone else and is residing elsewhere. The learned HCGP, though would refute the submissions of the learned counsel for the petitioner to contend that the offence alleged is one of rape, and the petitioner has to come out clean in the trial. Even if it is in the first blush construed to be a consensual act, it is for him to face trial and then be acquitted in the normal course, and this court should not interfere in exercise of its jurisdiction in section 482 of the CRPC. The aforenarrated facts are not in dispute. Since the issue has now sprung from the complaint, I deem it appropriate to notice the complaint. The complaint reads as follows, page 37 to 39. The police, after investigation, file a charge sheet. The summary of the charge sheet as obtaining in column number 17 reads as follows, page 52. The complaint narrates that on 6/11/2017 at 11 a.m., the betrothal ceremony of the petitioner and the complainant takes place. and all the happenings of the physical relationship between the two at Delhi is after the date of the engagement. On manifold circumstances, the marriage does not take place, it breaks. And therefore, later it becomes an offense of rape offense of rape on registration of the complaint on 13/2/2019. Whether such instances could amount to an offense of rape is considered by this court. Release so in the light of the law considered by this court in the aforesaid judgment, this court judgment, a deeper delving into the issue in the case at hand would not be required. Suffice it to state that the issue stands completely answered by this court in the aforesaid judgment. Aforesaid judgment, therefore, the petition deserves to succeed. So and so allowed cost.
Right.
60.
Pass over. Adjournment. Next
Madam,
is
pass over.
that day he wanted Passover, you wanted adjournment. Yes. 2 weeks. 26th.
My lord. My lord, it may be taken on 19th.
List on 26th. Yes, sir.
Interim order may be.
Interim order will continue. Yes, Naveed.
Lots offense under section 323, 324, 504 and 506 of IPC, my lords. It is a counter case, my lords. My lords, filed by my lords, the husband of the my lords, brother's my lords, husband, my lords. Initially, my lords, the petitioner's sister has filed a complaint. But she is the my lords, wife. Plus 498A, my lords, initial complaint was filed on 27/7/2022. Section 498A. But day after, my lords, brother, my lords, has filed this complaint, my lords, husband's brother, against the brothers of the sister.
Who is the complainant here?
Brother of the husband, my lords.
Brother of the husband.
Brother of the, yes, my lord, brother of the husband, my lords.
Counter case. The wife is filed one more complaint.
What happened to that?
It was charge sheeted, my lords. 498 is charge sheeted. Let's kindly see the, my lord, the allegation, the charge sheet, my lord.
Let both the cases be tried.
Let's kindly see the allegations, my lords. Lord, the incident, my lords, at charge sheet, my lords, at page number, my lords, 20. Lord, the same, Lord, the incident is at, my lord, on 24/7/2022. And the complaint was reported, my lords, on 27/7/2022.
24/4.
24/7/2022 is the incident.
3 days later.
Yes, my lord.
So what?
Only when my complaint is filed under section 498A.
Parval. If there are ingredients, we will close it.
Plus, there is a delay, my lord.
3 days delay.
3 days.
I will answer, it is not fatal.
Lords, kindly see, lords, what made them to keep lords silent? Lords, still the 498A is filed, lords, against them, lords.
No problem. Yes. 498 ನಡೀತಾ ಇದಲ್ವಾ?
ನಡೀತದೆ.
5 ನಡೀತದೆ. 2 ಒಟ್ಟಿಗೆ ನಡೀತದೆ. Same family.
Absolutely false allegation, lords. There is no such incident has taken place, lords, on that day.
ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವ 498?
They did not challenge me.
Ask them to challenge.
Lords, they are here, lords.
Close both.
Lords, kindly permit me to read the allegations.
Ah,
Complaint.
Yes.
Lords, page number 33 is the complaint allegations.
Yes. ಪರವಾಗಿಲ್ಲ. ಸೇರಿಕೊಂಡು ಬಲಗೈಯಿಂದ ಸೋಣಿಸಿ ಹೊಡೆದಿರುತ್ತಾರೆ. Anything else?
No medical record, lords.
Admit ಆಗ್ತೀರಿ.
Allegations in page number 54 maybe, sir.
54 madam.
Column number. Second paragraph.
I am at page 20 ಅಲ್ಲೇ ಇರೋದು. ಯಾವ ಕೇಸ್?
That is my 498A. That is the allegation under 498A. That is my complaint.
No. 323, 324, 504, 506 ಅದ್ಯಾವುದು? ಮೇಡಮ್ ನೀವು ಯಾವ್ದು 54 ಯಾವ್ದು ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
54 is my lords, 498A, my lords.
54 is 498.
Yes, yes.
That's not before the court.
Yes, yes.
Come to page 20. This is the allegation against them.
Delay is there, my lords. Lords,
Submit
kindly,
for that.
Lord, they have not at all filed, my lords, any petition before this court, my lords. Lords, they kindly see the.
Accepted, sir. They accepted trial. Yes. The petitioners are before this court calling in question proceedings in CC 363 of 2023, registered for offences punishable under section 323, 324, 504, 506 and 34 of the IPC. A solitary incident, solitary incident on 24/7/2022 gives rise to two complaints. One on the same day, one registered by new matter.
I have registered, my lord.
One registered by the petitioners and others alleging offences punishable under section 498A, 324, 354, which becomes a crime in crime number 94 of 2022. On the same day, ಅಂತ ಹೇಳ್ತಾರೆ, ನೀವೇ ಹೇಳ್ತೀರಾ?
Same day, my lords, a complaint is filed, my lords, reporting the incident of, my lords,
On the
earlier
same
incident.
day, a complaint comes to be registered by these against these petitioners before the jurisdictional police, which becomes a crime in crime number 95 of 2022 for offences punishable under 323, 324, 504 and 506, read with 34 of the IPC. Therefore, it is a case and a counter case, though what is alleged in the first complaint is the offence punishable under section 498A of the IPC. The police conduct investigation in both these cases and file respective charge sheets. The charge sheet filed in the crime registered by the petitioner against the respondents is not challenged, and the same is pending trial before the concerned court. Insofar as the crime registered against the petitioners after filing of the charge sheet, the petitioners have knocked at the doors of this court in the subject petition and interim order, and an interim order of stay is subsisting, which has interdicted the trial before the concerned court. The learned counsel appearing for the petitioner would submit that the impugned crime is registered as a counterblast to what the petitioners have registered for offence punishable under 498A inter alia in crime number 94 of 2022. He would submit the complaint or the summary of the charge sheet does not meet any of the ingredients so necessary to drive home the offence under section 323, 324, 504 or 506 of the IPC. He would seek quashment of the entire proceedings. Per contra, the additional SPP, Srimati Rashmi Jadhav, would vehemently refute the submissions to contend that the complaint and the narration in the summary of the charge sheet would clearly meet the ingredients of section 323, 324, 504 or 506 of the IPC, as the narration is that the petitioners have assaulted the complainant. She would therefore seek that the petition be dismissed and the petitioners undergo trial, as it is a case and counter case. And in the counter case, the respondents are undergoing trial. I have given my sounds. The afore narrated facts are not in dispute. The complainant is the brother of the wife of accused number 1, the first petitioner. The dispute arose between the members of the family, i.e. the husband and the wife's family. On 27/7/2022, an incident of alleged altercation gives rise to two crimes, one in 94 of 22 and the other in 95 of 22. Therefore, it is a case and a counter case. In the first case registered by the petitioners, the offences alleged are 498A and 354, and the rest of the offences are in common in both the complaints. The second complaint, though, is registered at a later point in time. It is for the very same offences except the two narrated herein above. The police conduct investigation and draw a charge sheet against these petitioners. The summary of the charge sheet as obtaining in column number 17 reads as follows, page 20. Page 20. Page 20, mark portion. The narration in the summary of the charge sheet is clear with overt acts performed by accused 1 to 4, which would clearly become the ingredient of section 323 or even 324 of the IPC, albeit prima facie. Any further observation about the contents of the statements or the narration or the explanation of the summary of the charge sheet would definitely cause prejudice to the petitioners who are to face further proceedings before the concerned court. In the light of the issue being a case and a counter case, and the summary clearly pinning down these petitioners' quay the ingredients of the offences, there is no warrant of interference at this stage in exercise of the jurisdiction of this court under 482 of the CRPC, leaving open such remedies as available in law to these petitioners. The petition stands rejected.
Was permitted to file discharge notes.
Leaving open ಅಂತ ಹೇಳಿದ್ನಲ್ಲಪ್ಪ.
Obliged.
Sorry.
30 more matters. Order. Bill number 1, Srimas Manu.
Withdrawal bidding. Next. Next.
Filed.
In terms of
Number 2,
same.
number 3, Arunji. For settlement.
What offense?
498 ML.
Vakalatva.
Joint memo.
Joint. Application under 320 supported by an affidavit. Baritara. 498, madam. 498, I will settle it, yes. Signatures though. Disposed cost, yes.
Number 4, Gautam Yar.
Withdrawal.
Memo.
Kotilva. Learned counsel of the petitioner has moved the matter seeking to withdraw the petition. In the light of said submission, petition disposed as withdrawn.
14 settlement. Number 105, 105.
Not there.
106.
Petitioner. Yeah, 354 and.
376 da.
354.
354.
Filing the wakalat on behalf of.
Yesterday, nobody to identify adena idu.
Respondent number 123, wakalat.
But offenses were horrible.
40%.
Government copy ಕೊಟ್ಟಿದ್ದಾರಾ?
354. Please, I've given it yesterday.
354. 354, madam. Is it 10 lakhs da?
No, no, madam. These are sold.
We'll close it. Same. ಮಾಡ್ತೀರಾ? 354. Yes.
That's
111.
Petitioner is present. Joint memo is filing.
Yesterday's matter.
Yes, please.
Offense ಏನು?
498 AM. Petition is accused number 2 in this case, madam.
Counsel, so what about accused, who is accused number 1?
Accused number 1 is husband. She is not ready to withdraw the allegation against accused number 1, my lord. Only for A2, she is.
Who is A2 now?
A2 is husband. A2 is a sister's husband.
A1 no husband ante.
No. Sister's husband.
Sister's husband. Reject. ಇದರಲ್ಲಿ The, who is the petitioner? Only the sister's husband?
Yes.
The petitioner is accused number 2. Brother-in-law of, brother-in-law, na? Of the accused number 1 husband. He is arrayed into the web of proceedings under section 498A of the IPC. During the pendency of the petition, the parties to the present list, accused number 2 and the complainant, have resolved the differences between them and have filed a joint memo of such compromise of compounding before this court. The joint memo reads as follows. In the light of the offense punishable under section 498A and the present petitioner being another member of the family, the petition the proceedings insofar as the present petitioner accused number 2 is quashed on account of the said settlement. It is made clear that the settlement will not come in the way of further proceedings against any other accused. For the aforesaid reasons, this post quashed.
Other sections are there, 323, 504.
Oh, number three.
Ella ಹಾಕ್ತಾರೆ.
Please. Much.
Affidavit. Yeah.
Ready.
ಏನು offense 498?
ಅಲ್ಲ ಸರ್ 406 and
406 and
420. The private complaint ಮಾಡಿ refer ಮಾಡಿ
affidavit.
put in. Affidavit.
So and so appears to the second respondent, ಅದೆಲ್ಲ ಮಾಡಿ. ಎಲ್ಲ ಶಾಸ್ತ್ರೋಕ್ತವಾಗಿ. ಎಲ್ಲ ಸೆರೆಮೋನಿಯಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿ.
Publish.
Other hearing provisions.
Number 108, 108.
Sorry, 10.
I'm for the petition. Monday, kindly senior
Monday
counsel is
ಆಗಲ್ಲ.
being engaged.
We'll take it on Thursday.
Next Thursday.
Next Thursday, next Friday. List on Friday, the next. Yes, next.
109.
For the petitioner, my lords. This matter, my lords, had given us liberty to get the lift commissioned, and insofar as the petitioners were concerned to install the rope, my lords, they have some financial difficulty. They were only requesting, my lords, just for their, if this honorable.
What is this rope of the, I will release it, you take a chance before the other court.
Could I pray for one last opportunity, my lord? They're requesting, my lords, if it could be recorded in the order that this.
ಈಗ lift
it
is
would-
working or not working?
No, my lords, it's not commissioned. That's my instruction.
We have
You're troubling senior citizens, you will not improve, leave it.
My lords, could I pray for just one last opportunity, if it could be recorded in the order that it will be set off against maintenance dues in the future, that may give them some confidence to spend on the rope. It's about 70,000, my lords. 2 houses are spending that entire money. If only that could be made,
Maintenance dues ಎಷ್ಟಿದೆ ಈಗ?
Lords, I'll have to ascertain. my lords.
No, anyway, you agitate it.
This,
dues,
Any amount of
my lord.
indulgence shown is not resulting in resolution of the dispute, and the dispute between the two is spiraling. Release the matter from the status of being part heard, post the matter before the bench having roster.
My lord.
Great.
But this is that matter relating to
Yes, where is
asset
Gautam?
restructuring. But his filed his reply. Essentially, there isn't too much that he says there. That being said, my lord, can I just tender this memo? Further precipitation is now being done. They're saying, don't change khata, don't, further instructions are being given. Despite, my lord, your lordship's orders of stay.
Anyway, he said he has nothing to say, he has filed his objections.
That's what he said the other day, but I don't want to say anything. My lord. The only thing he says is that it's a premature in that it's only a communication.
No,
But ultimately,
that I will answer, he has argued.
that's all.
I heard reserved.
Lordships, great.
If there's anything, let him make a submission.
Interim may please be extended.
Interim order will be there.
Please.
Yes. Yes, next.
But may I just tender this memo? I'll make sure that a copy is given.
You give it to Gautam.
I'll see that.
Yes.
Great.
Yes, continue the list.
Petitioners in this case. Lord, this is about that. Lord, I sought the agreement entered between the parties last date of hearing.
What agreement?
This is about that incident which happened in the ragging Manipal Institute of Technology.
College ragging.
Please, my lord. One of the accused, my lord was pleased to quash also.
Alla, the affidavit could have killed him. Why was it adjourned?
It was agreement to see whether the original persists or not.
Original persists. What? That was not. What original?
The parties have entered into an agreement wherein they have culled down certain conditions to be complied by either of them. And my lord.
Which agreement is it? Illa hakidira agreement.
Illa, hakirilla. I made a submission, your lordship recalled that there is an agreement. Then I got it through my party.
No, in the earlier case, I had closed it on account of the agreement.
There is also an agreement entered into the same parties. Please.
No, I did not want to quash on account of agreement entered into between two different individuals.
No, my lord, this is a separate agreement which is entered between the petitioner and the complainant.
They will not stay in the campus, and that's what is said.
And an order is also being passed,
Yes,
my lord.
ಕೊಡಿಯೋದು ಅದೆಲ್ಲ ನೀವು ಗವರ್ಮೆಂಟ್ ಕೊಡ್ಬೇಕು ಮುಂಚೆನೆ. Madam, in this ragging cases, they sought to settle the issue saying that these students will never stay in the hostel. I have passed that order based upon that undertaking of theirs. The same undertaking is now produced here. This student also will not stay in the hostel. Whatever order I have passed here will be passed in this. That's all right. Heard the learned counsel appearing for the petitioner and the learned additional SPP Srimati Rashmi Jadhav. The learned counsel for the petitioner submits that the petitioner is another accused in the same crime. In crime number 42 of 2023. In CC 9316 of 2023, which arose out of crime number 42 of 2023 for the following offences. The other accused, this court recording the undertaking has closed the proceedings by the following order. Identical agreement or undertaking is drawn by the father of the petitioner, by the petitioner and others. The said agreement is also placed before the court. In the light of the quashment of the proceedings, other accused, and for the same reasons, recording the same undertaking, I deem it appropriate to close the present proceeding as well. As the undertaking is entered into between the present petitioner and the complainant, as was entered into in the petitioner and the same complainant in criminal petition 5393 of 2023. Disposed court. The original tawali copy kodi. Yes.
For responding to
Can be the petitioner, my lord.
My lord, I have seen the judgment and I pray 1 week of time. I'll make
3 weeks.
1 week of time. Whether my petition fits to. this-
Covered by a lordship judgment in.
I know,
David's.
I'm aware, my lord. I have the copy. I pray 1 week of time to go through.
Go and die.
Go and die.
I'll take my chance, my lord.
David, which judgment is that?
David, yes, it is handed
David
over.
D'Souza.
Handed over to.
David D'Souza.
And David,
I pray 1 week of time.
I grant 1 week. Yes. Learned counsel appearing for the respondent submits that he has gone through the judgment in the case of David D'Souza on the very issue and would seek to go through thoroughly go through the same and make his submissions. List the matter on next Friday, 21st.
So
as the last chance. Interim order,
Interim order.
Interim order subsisting shall continue till the next date of hearing.
So grateful.
Yes.
I appear for respondent number 2, complainant, my lords. No, there are 2 petitions.
Connected matters, what is the matter?
My lords, these
I appear
are
for-
both. Please go ahead.
498 yardo. Both are by you only. What's the matter, sir?
My lord, the first matter, 65.
Huh?
65, section 498A.
We will take 65 first.
Please, my lord.
Yes, sir.
Mother, father, sister.
ಯಾವ್ದು ಇದ್ರಲ್ಲಿ?
65.1 is the husband.
1 minute. This is Will, Mill, Sill. Sister-in-law, mother-in-law, father-in-law.
Please. At 65.1, husband, 65.1 husband. Please.
Right. First, we will go to the other members of the family.
Please, ma'am. My lord may please, they have also filed their objections.
You're not ready?
I'm ready.
They're ready, they're ready.
In fact,
they're
we
ready.
have filed an IA for vacating the stay order.
Please.
In the husband's case or the in-laws case?
Both the
Because-
cases.
So you're against the in-laws also?
My lords, both, I'll show my lords from the. company.
Therefore, my submission was, with the permission of senior, was the application for vacating of the interim order, the main petition
Is it
may be
granted,
considered
madam?
as objections.
Is it granted?
His main matter can be considered as
So
objection.
he's asking your
to
permission.
Vacating.
Yes, I give the permission. Let
therefore-
the matter be heard fully.
It can be heard of my,
My permission, he needs my lord's permission.
because in fact,
That's fine.
because,
Yes, sir.
because of the protocol, the senior has to complete first, therefore.
So not when the senior is on the other side, sir.
Please, my lord.
Yes.
My lord, in the objection statement, there are totally about 5 complaints. I'll just go with the chronology and the datelines, and then it is for the court to decide.
What, this is the 6th complaint, is it?
It is in the sequence, the 4th complaint. My lord, in the objection statement, my lord may have it, 8837.
88?
37, my
I'm holding that.
please. In that objection statement at ink page number 109,
Yes.
my lord has it, it is the NCR 252 of 2023. My
Yes,
lord, in this, it is dated 7th March 2023, that may be marked. Then to the Inspector of Police, East Zone Women Police Station, that may be marked. Then subject, that may be marked. Then, my lord, the governments with all the paragraphs and all the 8-9 pages, verbatim, it's a repeat of the complaint. It ends at ink page number 116. Then the NCR acknowledgement is at page 117. This is dated 8th March 2023. That may be marked. Then, my lord, ink page 119. I'll come to the averments, my lord. Then ink page 119, 14th April 2023, to the Inspector of Police, that is the superior authority, East Zone Women Police Station. So the difference is exactly 1 week, and it is the same complaint for, it's more like the 156.3, my lord. And next, my lord, ink page 120. This is dated 16th March 2023.
Yes.
And this is addressed to the chairperson, Karnataka State Commission for Women. And it is the same complaint again. Please, my lord, that is again on 16 March 2023. Then, my lord, the impugned complaint before my lord, the current subject matter, this is dated 17th June 2023. Annexure B is the complaint. Then, my lord, in the same annexure, the objection statement, 10th August 2023. I have taken the filing date from online, criminal miscellaneous. This is the DV case. This is 10th August 2023. Now, there are totally about 6 complaints, my lord. And this is the objection statement. I will come to this a little later. And my lord, in the other objection statement 9903, it is the same annexures which are produced, but with the different page numbers. That page numbers also are marked. And exactly the same addressed to the Superintendent of Police, the Women Police Station, Inspector General of Police, etc. My lord, now the sum and substance of the matter. The matrimonial home is located in Ahmedabad. The date of marriage is 6th July 2019. The marriage was performed in Bangalore on 6th July 2019. My lord may have the list of dates for the ease of reference. I have just culled out what is required for 482. And 17 June 2023 is the impugned complaint. In my list of dates, in page 1, which is produced at Annexure B. And 20th July 2023, anticipatory bail was granted. I have cooperated with the investigation, parents and husband also. Right. Then 15th September, I have approached this honorable court to prevent the abuse of the process of law. My lord, now coming to the further facts. It's the second marriage between the parties. And there's a natural wear and tear in the marriage.
Natural wear and tear?
Natural wear and tear andre, apartha. And apartha ಆಯ್ತು.
Apartha you call wear and tear.
My lord, in fact, there were some disturbances between husband and wife. And there is further, my lord, she left the matrimonial home during the January 2023 from Ahmedabad. But as per the complaint, she says that she left from Delhi after the Christmas vacation.
Andre Delhi or Ahmedabad?
ಇವರೆಲ್ಲ ಅಹಮದಾಬಾದ್ ಇಂದ ಜಿಮ್ ಕಾರ್ಬೆಟ್ ಪಾರ್ಕ್ ಹೋಗಿದ್ರು ಉತ್ತರಾಖಂಡ್ ಅಲ್ಲಿ 2022 ಡಿಸೆಂಬರ್ ಸಮ್ಮರ್ ವೆಕೇಶನ್ ಇದು ವಿಂಟರ್ ವೆಕೇಶನ್ ಆದ್ಮೇಲೆ
ಜಿಮ್ ಕಾರ್ಬೆಟ್ ಇಂದ ಆಚೆ ಬರ್ಲಿಲ್ವಾ?
ಜಿಮ್ ಕಾರ್ಬೆಟ್ ಇಂದ ಆಚೆ ಬಂದು ಇವರು ಡೆಲ್ಲಿನಿಂದ ಅಹಮದಾಬಾದ್ ಬರೋ ಮೊದಲು ಡೆಲ್ಲಿನಿಂದ ಬೆಂಗಳೂರಿಗೆ ಬಂದ್ಬಿಟ್ರು ಅಷ್ಟೇ. ಅದಾದ್ಮೇಲೆ ಇವ್ರು ವಾಪಸ್ ಬಂದಿಲ್ಲ. ಅದಾದ ನಂತರ ಕಂಪ್ಲೇಂಟ್ಸ್ ಫೈಲ್ ಆಗ್ತಾ ಹೋಗಿದೆ. ವುಮೆನ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ ಹ್ಯಾಸ್ ಬೀನ್ ಸೆಕ್ಯೂರ್ಡ್ ಬೈ ದ ಹಸ್ಬೆಂಡ್. ಅಲ್ಲಿ ಇನ್ಲಾಸ್ ಆಮೇಲೆ ಸಿಸ್ಟರ್ ಇನ್ ಲಾ ಇಲ್ಲ. And further, my lord, the complaint averments as such, there are many citations, but one citation which my lord is aware is Muhammad Wajid and another. To read in between the lines.
That is not Muhammad Wajid. Muhammad Ali. Muhammad Wajid is 951, Muhammad Ali is 950. 2023 SCC.
Correct. Therefore, the criminal machinery cannot be started off to set a score, to settle a particular score. It's a matrimonial dispute. Idadrinda, itara complaints mele complaints haki, cognizance mele cognizance togondo, it's just impossible. To prevent this abuse of the process of law, this is the remedy I have, my lord, to consider.
For I did not say you have no remedy.
My lord?
I did not say you have no remedy, don't worry.
In fact, to prevent the abuse of the process of law, to avoid the continuous complaints that are being filed before the authorities, to prevent that abuse, my rightful remedy is under 482. Therefore, it is for this honorable court to exercise the discretion, because this is a fit case where the complaint averments are in fact repeated.
Is it a common complaint against the in-laws and the husband?
Yes, my lord.
Or a separate complaint?
It's a common complaint. It's a common complaint. And in-laws are together. They have their family course to attend. Sister-in-law is also married. She also has her family course to attend. And in between all
family courts to attend. Everybody is in a problem, is it?
The problem, everyone has their own family. They have things to attend.
Why do everyone attend family courts?
Family courts are family course. Course in the family. It's a natural law.
All right.
And in fact, my lord, I stand corrected on a particular term that I had said, the wear and tear. It's not the wear and tear.
It is neither wear nor tear, sir.
My lord, in fact,
It's only minor skirmishes between the husband and the wife is what you want to portray, I guess.
my lord, the relatives and the husband cannot be forced to undergo the trial for these flimsy averments in the complaint.
There is meting out torture against the husband in the complaint.
My lord,
You have kicked her also is what is said.
my lord. Permit me to please go to Annexure B.
That's
I
what
have made my markings, please, my lord.
Mm.
In the complaint dated 17 June 2023, ink page 25. I'll just go through the relevant portion. In para 25, this is what it is. When was the marriage performed, etc. My lord, please come to the next page, ink page 26, paragraph number 4. Then 6th line. We were forced to heed to some of the demands since wedding arrangements were already made, including printing and distribution of wedding invitations, and that cancellation of the marriage at that stage would cause irreparable damage to our family honor. This is one part. And at the last line, and would also psychologically impact upon me. Accordingly, my father paid so and so to my husband. This apart, they also demanded and received so and so towards purchase of jewelry. The check through so and so was sent by post courier few days prior to the marriage, while the cash was handed over to my father-in-law by my father at our house in Bangalore. Then next paragraph, my lord. On 6th July 2019, she has quoted a particular number, paragraph number 6. Then please come to the next paragraph number 5. Then please come to paragraph number 6. In paragraph number 6.
One moment. Any chance of settlement, madam? Nothing. All possibilities explored.
He has now got a child from another woman, and there's a birth certificate with his name as the father of a child, with the mother as being another lady. Where is the question of a settlement? I've produced the birth certificate.
My lord.
All right, I'll get back to you.
It's very. My lord, next paragraph number 6. I'll reply to that, because after I complete this, then the chronology.
Come to the next woman. Yes.
My lord, it's a live-in relationship that way.
Seriously. Yes.
Live-in relationship.
You're married?
No.
No, you're married once.
No, married twice.
What is live-in relationship? With whom?
I'll just come to
No, with the present complainant, you have a live-in relationship or married?
With the present complainant, I'm married.
With another woman, you are in live-in relationship.
Yes, my lord. And that, my lord, now, let me complete the chronology, and I am there. I'm not running away. I'm there.
No.
To answer that, I'm there.
I'm not holding you. Yes.
My lord, paragraph number 6. I joined my husband at the marital home immediately after the marriage. Now, the place is not mentioned here. This is important.
Now, with this development or whatever, with this admission, all the allegations stand to reason.
My lord, it's very important to see the averments of the complaint.
We will see, sir. Muhammad Ali will answer. Odi, read.
My lord, I'll complete the complaint and then come to the judgment.
You complete the complaint. Yes.
My lord, in paragraph number 6, the last line, it says which place is not mentioned, and then within 3 days of my entry into the marital home. Then paragraph number 7, my husband and in-laws who were disappointed for not getting more dowry. There is no dates that are mentioned here.
Dowry go dates go in sambandha.
My lord, complete.
On this day, this much demanded. On this day, this much demanded. Then
ಅವ್ರಿಗೆ ನಾ ದುಡ್ಡು ಕೊಡಬೇಕಿತ್ತು ಅಂದ್ರೆ ಯಾವಾಗ ಎಲ್ಲಿ ದಿನಾಂಕ ಅಂತ ಆದ್ರೂ ಹೇಳ್ಬೇಕಾಗತ್ತೆ. Because these allegations are serious. The cognizance is taken by the honorable court. Therefore, that has to be demonstrated. It cannot be said, Mr. X had to pay me. ಅವತ್ತೆಲ್ಲೋ ಕೊಡ್ಬೇಕಿತ್ತು, ಹೆಂಗೋ ಕೊಡ್ಬೇಕಿತ್ತು ಅನ್ನೋದು ಆಗಲ್ಲ. Everything has to be reasonable. Now, 2019 ಇಂದ 2023 ತನಕ ಮಧ್ಯದಲ್ಲೆಲ್ಲ ಚೆನ್ನಾಗಿದ್ದವರು, ಹಾಲಿಡೇಗೂ ಹೋದವರು ಸಡನ್ ಆಗಿ ಹೋಗಿದ್ದಾರೆ ಅನ್ಬಿಟ್ಟು RR ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ರೆ ಹೆಂಗ್ ಬರುತ್ತೆ ಸ್ವಾಮಿ?
ಯಾರ ಜೊತೆ ಹೋದ್ರಿ ಹಾಲಿಡೇಗೆ ನೀವು?
ಅಲ್ಲ, ಹಾಲಿಡೇಗೆ ಇವ್ರು ನನ್ನ ಹಸ್ಬೆಂಡ್ ಜೊತೆನೆ ಹೋಗಿದ್ದು 2022 ಡಿಸೆಂಬರ್ ಅಲ್ಲಿ.
ಹಸ್ಬೆಂಡ್ ಜೊತೆನೆ ಹೋಗಿದ್ದು.
ಅವಾಗ
ಬರ್ಬೇಕಾದ್ರೆ you came back with the wife or went with the live-in?
ಆ ಲಿವಿನ್ ಇನ್ನೂ ಆಗಿರ್ಲಿಲ್ಲ ಅವಾಗ.
ಓ.
ಆ ಲಿವಿನ್ ಆಗಿರ್ಲಿಲ್ಲ ಅವಾಗ. ದಟ್ ಇಸ್ ದ ಪಾಯಿಂಟ್. ಆ ಲಿವಿನ್ ಆಗಿರ್ಲಿಲ್ಲ. ಕಂಪ್ಲೇಂಟ್ ಆದ ನಂತರ ಆಗಿದ್ದು. ಆ ಟೈಮಲ್ಲಿ ನಾನು ಒಬ್ನೇ ಇದ್ದ ಕಾಯ್ತಿದ್ದೆ.
Good story for a soap opera.
What is there is there.
Yes,
This is unfortunately real.
I know.
Real.
No, he admits it. What is not real? It's candid in admission.
ತಪ್ಪಿಸ್ಕೊಂಡು ಹೋಗೋದೇನಿದೆ? ನಾನು ಹೇಳಿಲ್ಲ, ಅವ್ರು ಹೇಳ್ತಾರ. ಇಲ್ಲ ಕೋರ್ಟ್ಗೆ ಗೊತ್ತಾಗತ್ತೆ.
ಕರೆ, ನನ್ಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗತ್ತೆ?
ಇಲ್ಲ ಕೋರ್ಟ್ಗೆ
ನೀವಿಬ್ರು ಹೇಳ್ದೇವ್ರ ನನಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗತ್ತೆ? ಇಲ್ಲ ನಾನು ಹೇಳ್ಬೇಕು, ಇಲ್ಲ ಅವ್ರು ಹೇಳ್ಬೇಕು, ಇಲ್ಲ ಕೋರ್ಟ್ ಗೊತ್ತಾಗತ್ತೆ ಅಂತ.
ಇಲ್ಲ ಕೋರ್ಟ್ಗೆ ಗೊತ್ತಾಗತ್ತೆ. ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲ ಹಂಗೆ ಕಣ್ಣಿಡ್ತಾರೆ.
ಜಡ್ಜ್ಮೆಂಟ್.
My lord, in fact, para number 7, 8, let us see at paragraph number 8, one amendment. In the month of August 2019, my husband and in-laws took me abroad. I was taken on the said trip only to extract more money from my father and to utilize me as a maid. ಅಲ್ಲ, ಇರೋ ಪರಿಸ್ಥಿತಿಯಲ್ಲಿ ಯಾರು ಮನೆ ಕೆಲಸದವರಾಗಿ ಟ್ರೀಟ್ ಮಾಡಲ್ಲ. During this trip, we stayed at the service apartment and I was made to do all the household chores for cooking, cleaning dishes and carry their suitcases and serve them. ಖಂಡಿತ ಇಲ್ಲ. In September 2019, while we were in London, my mother-in-law and sister-in-law demanded me to arrange 10,000 sterling pounds. ಸ್ವಲ್ಪ ಫೆಮಾ ಆ ಥರದ್ದೆಲ್ಲ ಇರುತ್ತೆ. 10,000 sterling pounds ತಗೊಂಬ ಅಂದ ತಕ್ಷಣ ತರಕ್ಕಾಗಲ್ಲ. Through my relatives in England, and on my refusal to do so, I was severely insulted, abused and harassed by them and was treated worse than a slave for rest of the trip. ಮನೇಲಿ ತುಂಬಾ ಜನ ಕೆಲಸದವ್ರು ಇದ್ದಾರೆ. ನೋ ಸ್ಲೇವ್.
ಎಲ್ಲಿ UK ಅಲ್ಲ?
UK ಅಲ್ಲ, ಅದು ಅವ್ರ ಮನೇಲಿ, ನಮ್ಮ ಮನೆ. My mother-in-law and sister-in-law would pick up quarrels on non-existent issues and abuse me physically and mentally, and also instigate my husband to do so. And on such instigation, my husband would routinely slap, punch, kick and beat me up. ಅಂತ ಬರೀತಾರೆ.
ಸೊ ಹಸ್ಬೆಂಡ್ ಇದೆ,
ಏನಾಗಿ ಹಸ್ಬೆಂಡ್ ಇರೋದು ಇಲ್ಲದೆ ಇರೋದಲ್ಲ, ಇದಕ್ಕೆಲ್ಲ ಒಂದು ಗೂನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇತ್ಯಾದಿ ಇರಬೇಕು. ನಾವು ಸತ್ಯ ಪ್ರಮಾಣವಾಗುವ ಯಾವ ಹೆಣ್ಣನ್ನು ಮುಟ್ಟೋ ಇದಂತೂ ಅಲ್ಲ. ಐ ಹ್ಯಾವ್ ಆಲ್ಸೋ, ಇನ್ಫ್ಯಾಕ್ಟ್ ವೆನ್ ಐ ಆಮ್ ಟೇಕಿಂಗ್ ಮೈ ಬ್ರೀಫ್ಸ್, ಐ ಹ್ಯಾವ್ ಟು ಬಿ ವೆರಿ ಕ್ಲಿಯರ್ ವಿತ್ ವಾಟ್ ಮೈ ಕ್ಲೈಂಟ್ ಇಸ್. ಆತರ ಹೆಂಗಸರು ನೋಡಿಯೋರಲ್ಲ, ಅದೆಲ್ಲ
ಅವರು ನಿಮ್ಮ ಹಸ್ಬೆಂಡ್ ನಿಮ್ಗೆ ಹೇಳಿದ್ರ ಅದೆಲ್ಲ?
ಇಲ್ಲ, ನಾನು ಕೇಳಿದೆ.
ನೀವು ಕೇಳಿದ್ದಕ್ಕೆ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ?
ಇಲ್ಲ, ನಾನು ಕೇಳಿದ್ದೀನಿ, ನಾನು ಓಪನ್ ಆಗಿ ಕೇಳಿದ್ದೀನಿ.
ಸರಿ, ಏನ್ ಹೇಳಿದಾರೆ ಅವರು?
ಇಲ್ಲ, ನಾನು ಹೊಡೆದಿಲ್ಲ.
ಯಾರು ಹೇಳ್ತಾರೆ ಹೊಡೆದಿದ್ದೀನಿ ಅಂತ?
ಇಲ್ಲ,
ಈ ಸೆಲ್ಫಿ ಎಲ್ಲ ಯಾಕೆ? ಬನ್ನಿ. ಎಸ್, move on.
I was most of the time confined to one room except when I was ordered to do cleaning and cooking in other areas due to my failure to get so and so. There was constant instigation by my parents, in-law and sister-in-law to my husband to get a better wife who would match their status and meet their dowry demands. Due to this constant harassment, I developed anxiety and fear and began to get depressed. Then para 10, my lord. Then this is the event again in December 2019.
So anyway, if you go on reading this, I think tomorrow 4:30 ಆಗುತ್ತೆ. ಅಷ್ಟು ದೊಡ್ಡದಿದೆ ಕಂಪ್ಲೇಂಟ್.
ಅಲ್ಲ, ಅದು ಕಂಪ್ಲೇಂಟ್ ಅಮೆಂಡ್ಮೆಂಟ್ಸ್ ಮೇಲೆ I have to demonstrate. I need to, because the timelines, the dates, because the complaint is made in such a way that the water will not flow out. But my request to this honorable court is to understand and see what is the space in between the
problem.
ಇಲ್ಲ, ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಅಲ್ಲ, ಪ್ರಾಬ್ಲಮ್ ಅಂತ ಖಂಡಿತ ಹೇಳ್ತಿಲ್ಲ. ಅದು ಕಂಪ್ಲೇಂಟ್ ಅಷ್ಟು ಚೆನ್ನಾಗಿ ಬರ್ದಿದ್ದಾರೆ ಮೈ ಲಾರ್ಡ್. ಇಟ್ಸ್ ಅ ವೆರಿ ಡಿಫಿಕಲ್ಟ್ ಕಂಪ್ಲೇಂಟ್. ಇಟ್ಸ್ ಅ ವೆರಿ ಡಿಫಿಕಲ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ಫಾರ್ 482. ಐ ಆಮ್ ಬೀಯಿಂಗ್ ವೆರಿ ಆನೆಸ್ಟ್ ವಿತ್, ಬಿಕಾಸ್ ಇದರಲ್ಲಿ ಇರೋ ಅಂತರಾರ್ಥನ ನೋಡೋ ತನಕ ಇದಕ್ಕೆ ವಾಶ ಆಗಲ್ಲ.
ಸೊ ಯು ಪ್ರಿಸ್ಯೂಮ್ ದಟ್ ಇದು ಓದಿದ್ರೆ ವಾಶ ಆಗುತ್ತೆ ಅಂತ?
ಓದ್ರೆ ವಾಶ. ಐ ನೀಡ್ ಟು ಗಿವ್ ಮೈ ಬೆಸ್ಟ್ ಶಾಟ್.
ಎಸ್, ಟೆಲ್ ಮಿ ದಿ ಜಸ್ಟ್.
My
ಏನಿಲ್ಲ ಇದರಲ್ಲಿ. ದೇರ್ ಇಸ್ harassment, some harassment meted out by the husband on several things. The in-laws are said to have instigated such harassment by the husband.
That is the genesis of the complaint.
That is the complaint. Till the cows come back, you want to read the complaint and they will not permit you.
Please, my lord. But each paragraph, the dates and timelines are important, because all these.
But only one surprising thing is that para 18, my husband and in-laws conspired me to throw out of the marital home. Allivargu okay. And took me to Jim Corbett Park. Why?
This is the afterthought.
To throw out of the marital home, taking you to Jim Corbett Park.
This is an afterthought. Ade ಹೇಳ್ತಿರೋದು, my lord.
Yes.
Yes.
That is the afterthought.
Now you have told your
ಆದ್ಮೇಲೆ ಇದು in that sequence.
Charge sheet ಆಗಿದೆಯಾ?
Charge sheet ಆಗಿಲ್ಲ.
Then you sit down. Yes.
Immediately after the FIR was filed, these quashing petitions were both filed and interim order was obtained. The gist of it, my lords, the FIR against all the.
Madam, you tell me straight away,
Yes,
against the in-laws, what is there? Husband,
lords-
yes, definitely we will not
Yes.
touch.
my lords,
But
the,
against the in-laws, what is there? You tell.
yes, my lords, against the in-laws, I don't want to read
No,
out.
no,
the-
unless you have a personal axe to grind against the
No, no,
in-laws.
against the
You
in-laws.
demonstrate the legal acts.
Yes. Now,
Yes.
my lords, the sections are sections of the Dowry Prohibition Act 498A and 506.
Yes.
Against the in-laws, there are clear allegations of dowry being given. In fact, I want to just point out one document at page, my lords, at page 50 in my objections that shows, I'm sorry, my lords may see my objections in 9903. I'm just referring to the petition in 9903.
Elect.
Yes, my objections in that,
Page.
page 50, my lords, 50. Page 50 is a bank statement. Kindly see the last line. On 16/7/2019, 1 crore has been given. And my complaint, I have stated that they demanded
To
1
whom?
crore. To the in-laws, to the parents.
Why?
So that is a dowry demand. Santosh Chandra Sharma. 1 crore. And that is there in para, my lords, para 4 of my complaint. That there was a demand for 1 crore. In fact, there was a demand for 2 crores. My father paid a sum of 1 crore to my husband through check bearing number so and so.
Then.
So that is, and all the bills of the jewelry purchased and given, all of it is with them from page 41 onwards. All of the details are in the complaint. I'm not going to take more time by reading out the complaint. From page 41 onwards are all the bills of the jewelry purchased,
Yes.
which are all demanded. In fact, the demands was during my wedding and even during my sister-in-law's wedding. After I got married, my husband's sister got married. Even for her wedding, I was demanded to pay. So all those bills are there. Thereafter, my lords, the other allegations against my in-laws are of harassment and both physical and mental harassment, which are there. Now, my lords, kindly see at page.
So you should come within the definition of cruelty.
Yes, yes.
In 498.
Yes, I will show
Not
my-
the harassment or cruelty that is for divorce.
No. 498A, which makes 498A cruelty has been defined, as my lords are well
Yes.
aware, that which makes it difficult for her and has a bearing on the safety of her life. That, my lords, in fact, is not only stated, but all the documents have been given to the police. So in the complaint, demands for dowry, non-stop, my lords, from the beginning throughout the father-in-law. At para 10, we say, even during the sister-in-law's wedding in December 2019, my husband and in-laws demanded and received a diamond jewelry set, pearl necklace, and gold chain of around 13 lakhs. And all the bills have been produced. Thereafter, my lords, when she had conceived, her mother-in-law, in fact, got her aborted. Yes. And there was threats to throw her out.
The complaint.
Yes, all of it is in the complaint. Now, my lords, further on at para 16, she says, my mother-in-law and sister-in-law attempted to harm my life. In fact, there were many instances of physical abuse. So all that is also laid there. And then, my lords, I want to, in fact, my lords asked the question, what about Jim Corbett? In December 22, they all, on the pretext of a family holiday, went there. I was given a one-way ticket to Bangalore and I was sent back.
One-way ticket.
Yes. I was sent back from there forcibly. I came back with my parents. In fact, the flight ticket are also there at page 108. I came back to Ahmedabad with my parents and requested that we get back. And I was asked to leave again. and I had to again go back. And so therefore from January 23, I'm out of the house and I've been thrown out. And finally, at page 157, from January 23, in fact, even prior, the husband started having a relationship which has been admitted. And at page 157 is the municipal birth certificate of a child that he has had with another lady. Page 157, my lords.
Of the objections.
Of my objections. Kindly see.
Ahmedabad.
Yes, because he is there. It is date of birth is Feb 10th, 24. Name of mother so-and-so, some other lady. Name of father on the right-hand side is the accused, Shambhav Jitendra Chauhan.
That he accepts.
That he accepts. So this is, I mean, after I am thrown out of the matrimonial home, not only does he meet someone and they are already in a relationship in the nature of marriage. And this is part of it, while he has done it and there is already a child, they're living together as a openly married couple, in fact. Whereas I am thrown out of the house, all in fact, the amounts of dowry have all been taken. More than 2 crores. I mean, 1 crore is only in cash, which has been transferred. And all of this is with the entire set of family members. Of course, this incident of having the child and, the fact that I have been thrown out and left out of the marital relationship is by the husband. But the family members, all those allegations are very clearly there. My lords, the complaint is filed, and the second allegation made is that I filed multiple complaints. My lords, I filed initially, my lords may see in the same objections at page 112, I first went to the women's police station.
What happened?
There an NCR was made, and there, my lords may see, the parties were called.
Later.
No. Immediately there.
Second complaint.
No. There is no second complaint. I don't know
One.
what my friend is submitting. There is no second complaint. The complaint initially at the women's police station is at page 112.
That was the only complaint.
That was the first complaint.
Second one.
The second one is the impugned one.
That's all.
That's all. The other pages, my lords may see, is on page 120, an NCR is made. At page 121, a police notice is issued to the accused in that same first complaint.
That is before the women's.
Before the women's police station. They don't come. At page 122, I write to them.
That's all right. Then
saying that they have not come.
Justified in the second complaint.
Thereafter, I filed it before the jurisdictional police station. That's all that has happened. I have filed one more identical complaint to the Women's Commission, Karnataka State Women's Commission, just as a body that helps women in distress. They are not going to take any action. I'm not in the action in terms of a criminal offense. They may call the parties to try and settle. So therefore, my lords, this is a case wherein, my lords, there is a serious case of domestic violence, dowry demands by the entire, not just the husband, by the family, and all the ingredients of the offenses are made out. And my lords, there cannot be any quashing, matter has to be dismissed.
My lord.
In fact, I've also filed DV complaint proceedings. Those are pending between the parties.
For permission of the court, I have 1 point for a rejoinder, my lord.
Please, sir.
Please. Paragraph number 44, ink page number 151 of the statement of objections. The tone and tenor of the averments in their own complaint are equally important to be considered.
What is that?
Please, my lord. Please come to paragraph number 44. The objection statement in 9903 or 8837. Anything is okay.
Anything is okay?
They're
Because it's the same complaint.
Wait, page.
My lord has which petition?
8837.
8837. My lord, in this, ink page number 148, my lord. Para number 44. The first respondent is a businessman by profession, husband. This is where it becomes interesting. Para 44, my lord. He is a director on the board of the company so and so, which is a family-run business. his salary from the said company alone is so and so. He holds a stake which is valued at so and so, and the company has declared so and so. This apart, he is a director in so and so company. He is also a partner in the Designs LLP. He has an undivided share in the ancestral properties. My lord, this is all the admissions given by the complainant herself.
What are you suggesting?
My lord, the averments which have been shown to say there was a alleged demand, etc.
No, that is not by the husband. The demand is
In-laws
by the
ಕೂಡನೂ
in-laws.
ಬೇಕಿಲ್ಲ. My lord, in-laws ಗೂ ಬೇಕಿಲ್ಲ, my lord, because we have a,
ಕೇಳಿದ್ರ ನೀವು?
my lord,
ಅದು
ಖಂಡಿತ,
ಕೇಳಿದ್ರ?
ಖಂಡಿತ.
ಇಲ್ಲ.
ಹೇಳೋ ಪರಿಸ್ಥಿತಿ ಇಲ್ಲ.
ಅಲ್ಲ, ನೀವು ನಿಮ್ಮ ಪೆಟಿಷನರ್ಸ್ ಕೇಳಿದ್ರ?
ಕೇಳಿದ್ದೀನಿ.
ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರ?
ಇಲ್ಲ, ಅವ್ರು, my lord, in fact, ಕೇಳಲ್ಲ. I have checked. ಕೇಳಲ್ಲ. And in fact, these are the admissions of the complainant herself. And further, ನಾನು ಹಿಂಗೆ ಅಲ್ಲಿ ಪ್ರೇಯರ್ಗೆ ಪ್ಲೀಸ್ ಕಮ್ ಟು ಮೈ ಲಾರ್ಡ್ ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 150. ಇದರಲ್ಲಿ ಪ್ರೇಯರ್ page 150, prayer 3. Direct the first respondent to pay a sum of rupees 8 lakhs per month towards the maintenance.
You know why? You are reading from what, you know?
The DV complaint.
Petition
Is it-
claiming maintenance.
Correct, correct.
While claiming maintenance, it is the duty of the claimant to demonstrate that he is in a
Correct.
position to pay maintenance. That is why this averment is there.
Absolutely correct.
Don't try to
ಇಲ್ಲ, ಇಲ್ಲ,
paraphrase
I'm
this to
trying.
your
ಇಲ್ಲ,
case.
ಇಲ್ಲ, ಇಲ್ಲ.
It has
I'm not
nothing to
trying.
do.
I'll get back. I'll get back now on the complaint itself.
ಅಲ್ಲಿಗೆ ಹೋಗಿ.
ಅಲ್ಲಿಗೆ
DV
ಹೋಗ್ಬೇಕು.
case ತೋರಿಸ್ಬಿಟ್ಟು maintenance claim.
It was subsequently filed.
Maybe.
10th August.
See, to
Correct.
claim maintenance, the wife has to project that the husband has enough
Absolutely
income to
correct,
pay
my
this
lord.
amount.
I'm with the court.
That is what is said.
ಅದರಲ್ಲಿ ಎಂತ dispute ಇಲ್ಲ.
ಅದಕ್ಕೆ
Correct.
ಡೌರಿ ಡಿಮಾಂಡ್ ಏನು ಸಂಬಂಧ ಇಲ್ಲ.
ಇಲ್ಲ. ಆದ್ರೆ, my lord, the series of complaints which have been filed, till date, there is no diverse petition that has been filed or for restitution. That is equally important.
1 minute. Divorce petition by whom? By the wife.
My lord, at the end of the day,
The
when there is
restitution of conjugal rights, why? To come and live with the live-in relationship?
my lord,
Then
even as
why
per
will the wife come and
my
live
lord,
with both
even
of you,
as per
sir?
even as
To
per
file restitution of conjugal rights?
my lord, even as per the complaint averments, she left the matrimonial home in January 2022. Then the series of complaints have started from first week of March.
Correct.
And they
That is-
went on till September.
That is the one-way ticket.
Yes.
Uh,
In January, I was thrown out.
So the initial complaint, what is there, and the subsequent developments have no bearing, my lord. And the marriage happened, it's a second marriage which happened in 2019. All was okay till 2022. Then this complaint is an afterthought, which is filed in the local jurisdiction of Bangalore, not at Ahmedabad. Therefore, this is a fit case.
No, it is not a complaint that is afterthought. It is a well thought after complaint. Yes.
My lord, one citation which my lord is already aware.
What is? Which ones?
Next. Head note.
Head note F.
Head note F in the, this.
Mohammed Wajid.
Please.
Ah,
my
yes,
lord.
sir.
Invoking on the quashing of the FIR, the complaint averments have to be,
ಅದರಲ್ಲಿ 3 offenses were considered. 504, 506 and 323.
correct, my lord. But on the averments of the complaint, it can be.
That is Mohammed Ali, sir.
Correct.
That's not Wajid.
Correct. Therefore, I respectfully pray that both my petitions may be allowed and the FIR and complaint may be quashed.
I'll take it for further hearing next Friday. We'll dictate on that.
On Friday, my lords.
No argument. Further hearing only to dictate.
Yes, my lords, great. My lords may take it this Friday, 14th,
No, 21st.
21st, my lords, I'm not in station.
No, nobody need be there.
Very well.
Yes.
Interim order may be extended.
Interim order will continue till next date. But no more submissions again. ನೀವು ಮತ್ತೆ ಪೆಟಿಷನರ್ಸ್ ಏನೋ ಕೇಳ್ಕೊಂಡ್ ಬಂದಿದ್ದೀನಿ ಅಂತ ಮತ್ತೆ
My lord, ನಾನು ಹೇಳೋದೆಲ್ಲ ಹೇಳಿದ್ದೀನಿ.
ಆ,
Now it is left
ಇಲ್ಲ
to
ಮತ್ತೆ
the
ನೀವು
honorable
ಈಗ
court.
ಇಂಟರಾಕ್ಟ್ ಮಾಡಿ ಏನೋ ಹೇಳಿದ್ರು ಅವರು ಅಂತ ಮತ್ತೆ ಹೇಳೋಂಗಿಲ್ಲ.
My lord, ಏನಿದೆ ನಾನು ಹೇಳಿದ್ದೀನಿ. This honorable court will take a decision. Grateful.
Obviously.
Grateful.
ಹಾಕು ಮೇಡಮ್. ಡೇಟ್ಸ್ ಏನು ಬಿ ಗ್ರೂಪ್ ಇರೋದು ಒಂದು Friday 103 ಮಿಕ್ಕಿದೆಲ್ಲ ಬೇರೆ ಡೇಟ್ಸ್ ಹಾಕೋಣ. 103 ನಾವು ಬಿ ಗ್ರೂಪ್ ಯಾಕೆ ಪೋಸ್ಟ್ ಅಡ್ಮಿಷನ್ ಏನೋ ರಿಟ್ ಪಿಟಿಷನ್ ಏನು ನೋಡಿ. ಎರಡು ಹಾಕಿ ಕೊಡಿ. ಎರಡನ್ನು post them for admission. Now 450. We'll only assign dates. Just yes, call the cases Karnataka. Manjunath, entry ಮಾಡಿದ್ಯಾ?
ಇದೆ.
66. July 5th. Same. Entry ಮಾಡ್ರೆ ಎಲ್ಲಿದೆ ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ? ಯಾವ್ದ್ರಲ್ಲಿ ಇಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಿ 67 ಎಂಟ್ರಿ ಮಾಡಿಲ್ವಾ? ಒಫೆನ್ಸ್ ಏನು? ಲಿಸ್ಟ್ ಆನ್ 20th next week.
My lord.
68.
Calling case by case. Wait, sir.
No, my lord. In 67, my lord, the case has been transferred to the CBI, my lord. Morning I made a submission.
Oh, correct. Freezing of the account.
Adralli CBI ಹೋಗಿದೆ ಸ್ವಾಮಿ. At this moment, if the account is defreezed, then CBI will.
I have not defreezed, sir. I am posting it only on 20th. Yes.
I'm for the petition, Manoj.
68.
68.
Entry model unta?
Illa, sir.
ಏನು offense?
Interim order was granted, but it was vacated because
by a positive order vacate ಆಗಿದ್ರೆ I am not going to extend.
No, Manoj, not because of positive. I did not appear. I could not appear on that day.
I have vacated the interim order.
No, Manoj. It was vacated 2023
extended.
December, Manoj.
No, is it
ITP.
specific
Owner.
ಆಗಿದೆಯಾ? ನಂದ. Oh, ITP na?
Also, owner, no knowledge, Manoj.
Owner?
Yes, Manoj.
Madam? Owner of the hotel?
Yes.
Trial ಆಗ್ಲೇಬೇಕು. ಯಾಕೆ trial is not going on despite the
A date
owner
may
of
be,
the hotel customers?
Manoj, owner of a lodge, basically, he was not there.
You need not be there, sir.
Manoj, it was
He has
done by
left
the
the lodge
manager.
for prostitution ಏನಕ್ಕೆ ಬೇಕಲ್ಲ?
No, there are many other materials which I can show the court also, Manoj.
ಏನ್
It may,
material?
it may be posted on a particular date or
We'll post it 2nd July.
Manoj, not second.
3rd July.
Manoj, this month itself, please.
3rd ಏನ 10 days ಇದೆ ಅಷ್ಟೇ.
Please, Manoj.
3rd July.
21st. 21st.
July, yes. Yes, next, correct.
My lord, for the respondent, my lord. My lord, that is NI Act 138, my lord, it's going on 9 months. Stay.
ಓ ಇದೆ ಇವ್ರದ್ದು ಮೇಡಮ್ ದಿನ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಹೌದು,
ಒಂದ್ ನಿಮಿಷ ಇದನ್ನ 20th ಹಾಕಿ.
please.
Yes. ಶಂಕರ್ ರೆಡ್ಡಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? 5th July. IO. Praveen.
I'm for the petitioner, my lord.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
Then entry order with this emergency.
What urgency?
Lords, this is under 498A. Against my lords, then the niece dies. The mother-in-law, my lord, the mother files a complaint against her husband's brother and sister. We are citizens of US.
My lords,
498A.
my lords, in this matter, there is a death note, my lords, which has.
Death note.
306
306 illa. 498A dowry. It's 498.
ಬರೀ 498 ಏನ 304 ಬಿ ಇದೆಯಾ?
Illa. Lords, if your lordship.
ಡೆತ್ ನೋಟ್ ಇರೋದೇ 303 ಡೆತ್ ನೋಟ್ ತಗೊಂಡು 498 ಇಲ್ಲಿ ಮಾಡಿ
498A 304B 34 3 of dowry.
It should be either 306 or 304B and 498A 304B lethal combination.
Lords, 498A, if your lordship sees, it is against the relatives of the husband. Lords, the girl dies, she is my niece.
No, that will see who is in the US or not.
No, she is my, lords, she is my niece. That is my brother's daughter. My brother's daughter, lords, I am nothing to do with the marriage. I am from 25 years, I am in US. And what is the allegation even in the death note?
If that is the case, those we will quash. If it is abuse, definitely we will
Please
quash.
see that, my lord. The complaint itself says.
Not at 455.
Not today, some
yes.
date, my lords, that's all. Because now, my
Then see, okay.
lords, because problem is they are
Because they are in the US.
US and they are US citizens.
So?
My lords, the problem is with this, they'll run into trouble. I am unable to come also. I don't want to come back here now till this gets, and the complaint is, we were harassing for property, nothing to do with anything else. There is no allegation against me.
Shyam Sundar appears, huh?
My lords, in this case, Shyam Sundar sir is the SPP, my lords. They may be,
Some date.
So you
you
will
have to-
make the submissions?
my lords,
You are submitting in this case then?
we are for respondent number 2, my lords.
Complainant and SPP, how can they go hand in hand? Then the very appointment is doubtful,
That's good.
not highly incorrect. Yes, sir? ಯಾಕೆ ನೀವು ಇರ್ಲಿಲ್ವಾ?
My lords, in
First time I am hearing about special PP.
ಅಲ್ಲ, special PP appointed,
yes,
who is also the counsel of the complainant. How is it possible?
That runs contrary to the
That
settled
only-
judgment of this honorable court, division bench judgment.
Division bench, I myself heard last year.
Lord Justice Kumar or
That is Shiva Reddy.
how it has to be, when and how.
That's 2005 is Shiva Reddy.
it's my kind.
That, then you will have to make submissions.
Yes, my lords.
Yes. We will not permit Shyam Sundar to make submissions.
No, my lords.
ಈಗ entry order ಇದೆಯಲ್ಲ?
But there is urgent because they want to come and go, my lords. From, my lords, we have come last when there was a settlement deed amongst all of us.
ಪರವಾಗಿಲ್ಲ, you come next after the closure of these cases. We'll do it.
Okay, some date, my lords, I'm only requesting.
2nd July. Second, what year is this? 3rd July. That is the earliest. 3rd July, and don't get Shyam Sundar in this. Yes. 3rd July. Interim order subsisting shall continue till the next date of hearing. We are already on the 12th, sir. Another 2 weeks after. Yes.
It's again getting crowded.
What to do? That you can't help.
Lordship, serial number 110, my lord.
No, wait. On the VC, wait, sir.
17 for the petitioner.
70?
Interim order ಇಲ್ಲ.
ಎಲ್ಲ 5th ಹಾಕ್ಬಿಡಿ. Interim order continued. ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ.
Interim order.
ಇದೆಯಾ?
No, sir.
No interim order? There is no interim. Yes. 5th.
73, the issue stands. 73 issue stands covered by your lordship's decision.
What?
Let exoneration in disciplinary proceedings.
Ashu.
honorably. Ashu.
It's not covered, my lord, because of this is, my lord, they are
Okay.
deposited the amount.
5th. Yes.
Let may request let their promotions have been, some of them have retired. That
ಎಲ್ಲ
is why
retrospective effect ಎಲ್ಲ ಸಿಗುತ್ತೆ. Don't.
Can it be little earlier? Only one request.
5th. Yes.
74.
Interim order ಇದೆಯಾ? 5th. Yes.
25 at 76.
I'm for the petition, 76.
Interim order?
Interim order.
5th. Yes.
Interim order, IA is August.
ಅಯ್ಯನೇ ಹಾಕಿಲ್ವಾ?
Allala,
5th. Yes, next.
Copy is served.
Yes, Ajay.
My lords, I appear for the respondent.
Appear for the petitioner, my lords.
Trial has concluded. Evidence is closed on both sides. Matter was set down for my lord's argument.
138, huh?
I'm sorry, there are 3 matters. The matter which my learned friend is saying is the first matter, not the other 2 matters, my lords, I have put it. That's on the private, there's no interim order. The 22nd is that case, my lords, in the.
List on Friday. This Friday.
Grateful.
Yes.
This case for the petitioner, please, madam.
Interim order ಇದೆಯಾ?
And similar.
5th. Yes.
When it is,
29.
Appear for the petition, my lords. There is no.
5th. Yes.
For the petitioner, my lords.
85th.
81, I appear for the petitioner, your lordship.
5th. Yes. Jayasur Reddy ಅವರೇ, ನಿಮ್ದೆಲ್ಲ ಕೇಸ್ಗಳು ಎಲ್ಲಿದ್ದಾರೆ?
7, 82, 83.
7, 82, 83. All 3 you call on 21st. Yes.
84.
My lords, for the petitioner, my lords, short date, my lords. It's a very short question that's involved, my lords.
Why?
21st. My lords, if there are 2 petitions that have been filed, the respondents have filed challenging one interim order for 20% deposit.
143.
Yes.
And we've
List on 21st. Yes.
obliged.
Interim order subsisting will continue. That you don't mention it.
85. Withdrawal option.
In terms of
86.
86, my lords, is covered by decision 7980 of the KP Act, please.
21st. Yes. 87. Interim order continue ಮಾಡಿ 5th.
My lord, 87, my lord. Appearing for the petition, there's some urgency because I want to press on the IA for stay, my lord. My lord, the co-accused in this matter has already been acquitted in this matter, my lord. And an NBW has been issued.
87 day after tomorrow.
Grateful.
Yes, next.
I am for the petitioner, 138, my lord. Summons is served. Next date is 18/6 is posted for trial court.
Let it be. Interim order ilva?
No, madam. Summons is served, my lord.
Friday document. Yes. Yes, next.
Have it on Tuesday, my lords, in these days. There is an undertaking, my lords, not to arrest my clients, my lords, but the independent directors are now being issued notice.
Huh?
Excise that.
I am aware there was an undertaking that they would not.
Not to arrest the petitioners before, my lords. Now, my lords, what has happened is I have got 5 independent directors.
When do you want? When do you?
Tuesday.
Tuesday, fresh matters irutte. I'll take it on Wednesday.
Okay.
Wednesday, yes.
Your lordship, the high number stay were pending your emergency
yes.
FLW and NBL.
FLW stay ಮಾಡಿದೀನಲ್ಲ.
ಇಲ್ಲ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. Last time notice serve ಮಾಡಿಬಿಟ್ಟು ಹೊರಕ್ಕೆ ಹಿಡಿದಿಲ್ಲ.
Friday ತಗೊಳ್ಳಿ 90.
Sorry, 91, the undertaking needs to be extended, my lords.
That will be extended, sir, whatever it is. 91.
Even I successive FIR that I filed.
Interim order ilva?
Interim, there is no interim order.
No interim order in successive FIR, why?
So that with regard to that, the chit fund will not that you lost.
Chit fund,
That
yes,
I produced that memo of retirement and.
Second, 4th July, yes.
I produced that TT Antonis with the citation.
I know, sir. I have rendered so many, yes.
93. Respondent number 2.
Fifth one, yes.
92, your lordship had posted for dictation on 14th.
Why?
Both these matters were heard, 2 matters for them, my lord, regarding the senior counsel, petition as a senior counsel in the Supreme Court.
ಬೆಳಗ್ಗೆ 14th ಹಾಕಿದ್ದೀನಲ್ಲ. Day after tomorrow ಇದೆ ಮ್ಯಾಟರ್ ಅಂತ ಹೇಳಿ ಹಾಕಿದೆ. Along with the other one, 14th it is there. ಅದೇನ್ ಬರಿಬೇಡಿ. 14th, yes.
93. Respondent number 2 in this case.
5th, yes.
Your lordship, in this notice has been not sent. The petition copy has been also not.
Petitioner to serve set of papers upon the council forthwith. Next.
Great. 4.
5th.
5.
457 application is dismissed.
Huh?
457 application is dismissed.
ಏನ್ ರಿಲೀಸ್?
ಇದು ಮನಸ JCB.
JCB. Yes. 24 matter, 4th, yes.
96.
457 application is released.
Same 4th.
Please.
7.
For the petition, no interim order is there. Petitioner to the director.
Offense.
420.
Why no interim order?
Last time.
Not a case for interim order.
Not to.
Yes, list on 21st, yes.
98.
Petition 311 application filed by. Rejected.
Interim order ಕೊಟ್ಟಿದ್ದೀನಾ?
Interim order ಇಲ್ಲ. ನಾಳೆನೇ ಇದು ಆರ್ಗ್ಯುಮೆಂಟ್.
ಪರವಾಗಿಲ್ಲ, ಇರ್ಲಿ.
Tomorrow.
ಇದು ನಾಳೆಗೆ ಆಗುತ್ತಾ ಮೇಡಮ್? ನಾಳೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಹಾಕಿ.
ಅರ್ಜೆನ್ಸಿ ಮೇಲೆ 311 ಅಪ್ಲಿಕೇಶನ್.
ಏನ್ ಪರವಾಗಿಲ್ಲ ಸರ್. 2009 ಕೇಸ್ 311 ಅಪ್ಲಿಕೇಶನ್ 15 ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕಿರೋದು. ಐ ಆಮ್ ಅವೇರ್ ಆಫ್ ದ ಫ್ಯಾಕ್ಟ್ಸ್.
ಕಂಪ್ಲೇಂಟ್ has been lodged.
Yes.
Tomorrow ಮೇಲೆ.
Tomorrow ಹಾಕ್ತೀನಿ. Yes. ಅದ್ ನಾಳೆಗೆ ಹಾಕಿ.
Please.
99.
NDPS, my lords, that section 50 has not been complied. You're asked to check.
Government. NDPS. Has been complied.
Joint notice has been.
We'll see. List on 21st.
Order is not there.
21st.
Interim order maybe.
ಯಾವತ್ತು? ಯಾಕೆ? ಅವರಿದಾರಲ್ಲ.
Well, the interim order is also.
Additional SPP ಅವರಿದ್ದಾರೆ. ನೀವು ತಗೊಂಡಿದ್ದೀರಾ ನೋಟಿಸ್ ಇದರಲ್ಲಿ? ಹಾಗಾದ್ರೆ ನೀವೇ ಬನ್ನಿ. Yes.
Interim order.
ಯಾವ Thursday ತಗೊಳ್ಳ? 20th, yes.
March up.
Again, 5th. Satnarayan? Interim order ಗೆ.
Please.
Satnarayan.
Supplementary charge.
Interim order ಉಂಟಾ? 5th. 102, Leela.
Appearing for the petition, transfer of investigation.
ಗೊತ್ತು. Additional SPP. ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ಅದೇ ಹೇಳಿದ್ರು.
ಹೌದು, 2 ಸಾರಿಗೆ ಹೇಳಿದ್ರು. 2 times.
No, this can't be done. Yes, list this on Wednesday. Yes.
Much.
103.
For the petitioner, my lord, there's an interim order. Lordships may have it in first week of July as per lordship's convenience.
What's the matter?
My lords, this is a matter, my lords, a senior IPS officer, an FIR is filed against him. B report comes to be filed. Protest petition is filed after that, my lords. Cognizance is taken, summons is issued, my lords.
What is the offense?
My lords, the offense is 323, 355, my lords, which is basically, my lords, assault and illegal.
323?
323, my lords.
On a police officer?
On a police officer. My
Sanction?
lords, sanction is not taken, my lords.
ಅಲ್ಲ ಇದರಲ್ಲಿ CH ಹನುಮಂತರಾಯಪ್ಪರ ಏನು
ಅಲ್ಲ, ಪರವಾಗಿಲ್ಲ, ಬನ್ನಿ.
ಅಲ್ಲ mention
Component number 2, I have filed a NOC Vakalat, my lord. My name is not shown in the cause list.
Registry to print the name of so and so is appearing. Lakshmikant ಯಾರು?
My lord,
Lakshmikant ಹೆಸರಿದೆ
ನಾವು
ಅವ್ರೆ. You are not there?
No.
Who are you?
File ಮಾಡಿದ್ದೆ, CH Hanmantaraj.
So and so has entered appearance, registry to print the name of so and so and delete the name of Lakshmikant. Learned counsel for the petitioner submits that the issue relates to non-obtaining of sanction to prosecute an IPS officer. Yes, less the matter on ಯಾವತ್ತದು? 3rd July.
Grateful, my lords.
3rd July at 3:30 PM. Yes.
Interim order to continue. my
Interim
lords.
order subsisting shall continue till the next date of hearing.
Grateful, my lords.
104,
For petitioners in this case.
Same 3rd July. 3:30 PM. Yes.
voting settlement 105.
ಅವ್ರಿಲ್ಲ ಹಾಕಿ, don't worry about it. Yes, Gautam sir.
My lordship, so I am apologizing for my absence, my lord.
No problem. I have taken your submission as heard in terms of the objections. I will
Obliged,
pass
ma'am.
orders.
Yes, my lord. Obliged, ma'am.
Lordship, one submission, serial number 72, my lordship. Appearing for respondent, I got held up in other court hall. Last
ಏನಾಗಿದೆ?
time my lordship have said that. My
Fifth
apologies. for-
ಹಾಕಿದೆ ಬಿಡಿ. Yes. ಆಯ್ತು ತಗೊಳ್ಳಿ. Additional SP ಎಲ್ಲಿ ಅವರು ಹೋದ್ರ? This 302.
Yes, my lord. There is no order passed.
Order need not be passed or what?
No order is passed. Because 302, order is not required. What the endorsement is issued is, under 302, you can appoint if court permits, you can be engaged. That's all is been done. But my issue is, my lord.
It will become arbitrary. ಯಾರು
No, it is
ಬೇಕಾದ್ರೆ
not, no, it is not been appointed. It is not a government appointment. Your lordship may see 302.
Then we'll have to write something on 302.
Yes, my lord.
ಯಾಕಂದ್ರೆ ಆಮೇಲೆ ಎಲ್ಲಾ ಕೇಸಲ್ಲಿ ಶುರು ಆಗ್ಬಿಡುತ್ತೆ.
Allah, that is what the Supreme Court has said in one judgment.
ಕೊಡಿ.
Madam?
We'll answer it. Let the trial be stalled till the next date.
Literally,
Heard the
there is
learned
no
counsel.
order. The order also.
The
trial
learned
court
counsel
order.
appearing for the petitioner. The learned counsel for the petitioner submits that an action under 302 is taken by the court without there being any order passed by the government under subsection 8 of section 24 of the CRPC. The learned counsel would submit that this court, a coordinate bench of this court in Shivareddy versus so and so has held that both under section 302 and 24(8), an order of the government is imperative. It is an admitted fact that there is no order of the government in the case at hand to appoint a special public prosecutor, even a public prosecutor. Whether 302 would not require an order of the government requires consideration.
That only Supreme Court said that.
We'll see, requires consideration till the consideration is answered, that the further proceedings before the concerned court shall remain stayed. 498 ತಾನೇ ಇದು?
ಹೌದು.
302 ಏನಲ್ಲ ಬಿಡಿ.
Literally, the only issue, the order may have to go because there is no reasons forthcoming. That's all.
ಏನೂ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ.
That's what Supreme Court said, para 15.
We'll do it next date. ಸ್ವಲ್ಪ ಅವ್ರು ದಿನ ಹಾಕೊಂತ ಇದಾರಲ್ಲ, ಅದನ್ನ ಸ್ವಲ್ಪ ರೆಸ್ಟ್ ತಗೊಳ್ಳಿ ಅವ್ರು.
They may not survive, my lord, because.
No, let the court which is posting the matter daily take some rest.
Allah,
We
sir.
will answer it next week.
Even I've seen the application also, there is no reason forthcoming the application. Order also, there is no reason.
Sir, application ಏನು ಹೇಳ್ದೆ ಹೋದ್ರೆ, it's a judicial duty to record reasons and then pass orders. ಅವ್ರು ಹೇಳಲ್ಲ ಅಂತ ನಾವು ಹೇಳ್ದೆ ಇರಕ್ಕಾಗತ್ತೆ.
And the para 15 is what exactly says, ma'am.
We'll see. ಇದು ಫೈಲ್ ರೆಡಿ ಮೇಡಮ್. ಇದನ್ನ post it on 21st.
Let the notice also have to.
Emergent notice 21st ಬೇಡ ಹಾಗಾದ್ರೆ, list the matter on 28th. Petitioner is directed to serve on the counsel who represents the complainant before the concerned court. Yes.
After 11.
For petition in this case, my lords.
ಏನದು 11 ಹೇಗೆ ಪಾಸ್ ಆಯ್ತು ಮೇಡಮ್?
DNA report.
Oh, yes. Settlement ದಾ?
Parties present.
Parties ಕರಿಬೇಡಿ ಎಲ್ಲದಕ್ಕೂ. Wait, sir. ಯಾರು ತೇಜಸ್ ಇದಾರ ನೀವ? No, here it is POCSO.
Yes, madam.
They are married and have a child. We'll close it. Condition, ಇನ್ನು ಮದುವೆ ಆಗ್ಬೇಕಲ್ಲ, ಕರೆಕ್ಟ್ ಅಲ್ಲ, DNA ಯಾಕೆ ಮತ್ತೆ? They have a child ಅಲ್ವಾ?
1 year old, my lord.
1 year old. They are already married. They have a child. And after that, the POCSO case is registered. ಮದುವೆ ಆಗಿದೆಯಾ ಇಲ್ವಾ?
ನೋ ಮೈ ಲಾರ್ಡ್ಸ್, ಮ್ಯಾರೇಜ್ ಜಸ್ಟ್
ಮತ್ತೆ ಮಗು
ಮಗು ಆಗಿದೆ.
Out of the action.
ಇವಾಗ ಮದುವೆ ಆಗಿ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
The lordship said, you release him on interim bail.
Oh, yes, that
Condition may
matter,
be
huh?
imposed for the produce marriage certificate.
Let him be released on
No, then I will do this way. I will release him on interim bail. Let him get married.
Yes, my lord.
Then let him get married. We'll get the
Please.
DNA checked of all the
There are no objections for the paternity. DNA test may not survive.
no objection of paternity. You're accepting.
I'm accepting the child ನಮ್ದೇ ಅಂತ accept ಮಾಡಿದ್ದೀನಿ.
Then we will not subject.
DNA
DNA report ಇದೆಯಾ?
ಇದೆ.
Biological father.
ಬಯಾಲಜಿಕಲ್ ಫಾದರ್ ಅಂತ ಇದೆ.
Yes. ಆಯ್ತು, ಬೆಳಗ್ಗೆ ಮಾಡ್ತೀನಿ. Tomorrow at the first case we'll do it. Interim bail I will grant. Let him come out. Let the parties not be present.
Please, ma'am.
We will grant the interim bail. Tomorrow, ನಾಳೆ ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಹಾಕಿರಿ. ನಾಳೆ ಮಧ್ಯಾಹ್ನ 2:30 ಹಾಕ್ತೀನಿ.
Grateful.
ನಾಳೆ ಎಷ್ಟಾಗಿದೆ? Get the parties, don't get the parties for tomorrow.
Please.
I will grant interim bail with all conditions. ಅಷ್ಟೇ ಸಾಕಲ್ಲ. Let them get married.